Welcome to the Adakay Show. I'm your host, Adakay, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. I'm your host, Good morning, everybody. How are you doing? I hope this finds you fabulously well. I am doing okay. I was trying to fix some technical issues from yesterday, and thank God we got that done. However, I hate it when you find you got a glitch in something you just made. Oh, y'all, that ticks me off. Ticks me off. Yes, I know. I gotta fix it. I saw it. I'm not happy. It didn't format that way. It didn't. Not when I made it. It was good. It was all good. Well, today we are here ready to go into hopefully I can salvage this. Hopefully I can salvage this. We're hoping. We are attempting to salvage. I love what I do, but boy, let me tell you, sometimes it ain't easy. It ain't easy. Oh, bringing this, making it a little smaller. So we'll see if that works. We are into two trials today. Good morning. We are in the Daisy Link trial. She is accused of rendering her significant other. And then we are also watching the trial that is the Ellis trial, and that is one where she unalived her child, or not her child, a 3-year-old child, and they are already live in court, but we will be going in and visiting with them off and on throughout the day because the judge has made it to where they cannot have any live, that's what I'm looking for. We cannot have any live recordings. So that, come on, ears. My ears are glitching. It's been a glitchy morning. I want to thank my fabulous mod. Sorry about that. Court TV Live just started screaming in my ear. And I'm like, what? It sounded like somebody pushed the breaking news button on my channel. And I was like, what the heck is this? It kind of just shoveled me this morning. So Court TV is live. Why do they play their breaking news? Oh, okay. They're just doing one of their little thingies. Okay. Phew. Y'all, I thought I was going to be in trouble. Okay. So, good morning, Miss June. Who's in chat today? Who's in chat today? Who's in chat today? We need to make a little stomping music that says that. Who's in chat today? Who's in chat today? All right. Who's in chat this morning? Good morning. First in chat was Honey 2800. Then we had Miss June. And then we had me welcoming everybody. And then we have hello, it's Brit. And then Jason. Good morning, y'all. Lovely seeing everybody this morning. Yes, I know I'm fidgeting. Let's see that. Good morning, everybody. I know, Jason. It's the okay. Now these are glitching. It was one of those dun 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 coming in from the court TV, and it was no breaking news. It was just their crap coming in. That's a jolt in the morning. Let me tell you, you guys. When you get something like that blasting in your ear and you're not quite awake yet, that's a good jolt. All right, guys, I have 2 sets of earrings I can wear this morning. I can do the one on this one, number 1, or I can do this one, number 2. Which do you think I should wear today? Number 1, who people call the EDB earring. By the way, I owned them before EDB did. I was wearing them before EBD did, and I'm older than EBD. Yeah, believe it or not, I am. And then this one, the glitzy one. So 1 or 2, you vote on them. 1 or 2, what should I wear today? 1 or 2. I can't help it that EDB and I have fabulous taste in jewelry. We do. We have fabulous taste in jewelry. By the way, I have a new intro again. I just played it. We're going to see as YouTube does its thing and decides to copyright me on it. Even though I found out that the music I was using in the other one was copyright free, only in America, though. If it's not copyright free worldwide, you get struck in. Yeah, I know. It's crazy. Okay, guys, I don't see any comments about the earrings. Let me see. Hello, it's Brit. You see, I see you say me. What is me? Okay, what I need you to do, Jason, is send me a link into our Discord. That is going to be the best way for me to get the information that you were putting up. That, in all honesty, is going to be the best way for me to get that. If you'll send it to me in Discord, we will look at it. Put it in breaking news, please. Yes, I want to replace it. Now what I'm going to do is get rid of it. I'm getting rid of the other video clip because there's something wrong with it. I don't like it when I have something wrong with it. Welcome. I'm Adakay, your deaf courtroom comment. Stop. Well, don't copyright me. That's the one I can't play. I was deleting it and it decided to play. So anyway, we're going to play the new intro just so I can see and make sure I fix the issue. And then we're going to get into court. And when I see the thing from Jason, I will be happy. Oh, I got to do that. I'm going over to my Discord now, looking for breaking news. Members only. Okay, I'm in breaking news. So if you can't do that, just pop the link up in the comments. That would be fabulous. Let's play this and see how it works. Welcome to the Adakay Show. I'm your host, Adakay, and I am a criminal justice major. I am also a deaf courtroom commentator. Breaking. Okay, it didn't fix it. Dang it. I had all the word sizing perfect, and now it is not perfect. And it pisses me off when that happens. Royally pisses me off when that happens, because I work very hard at sizing and making sure everything is where it needs to be. And it is throwing me off that it is not being a very good participant in my plan, and it is angering me. So now I'm going to save it again. Technology, y'all. Technology. By the way, just to let you know, please mark your calendars for Monday, October 13th at 2 p.m. Central Standard Time. Granny Gotti, The Reckoning is happening. Donna Adelson's sentencing hearing will be live here on Monday afternoon. We will see the Reckoning Ball. She came in like a wrecking ball. All right, Jason, I appreciate you, but I cannot have that comment. Sorry, can't mention anybody else in this. Let me Google. If you guys have anything, please go into our Discord and put it in there. Judge orders restrictions on federal taxes used against ICE protesters after Chicago area pastor shot with pepper balls. Well, pepper balls. I mean, come on. If you're wrongfully protesting, you get pepper balls. Judge in Illinois has temporarily blocked the federal agents from using certain. And now I get this freaking dang commercial. Certain types of force and crowd control measures against protesters after video of pastor being repeatedly shot by pepper balls during a demonstration outside the ICE facility. Cooperate. I lost my place. ICE facility near Chicago drew widespread outcry. A federal judge granted temporary restraining order Thursday in the lawsuit filed Monday by Chicago Health Headline Club, nonprofit that represents journalists alongside unions and individual protesters over the federal law enforcement tactics. The lawsuit alleges federal agents have shot, gassed, and detained individuals who have been protesting outside the ICE detention facility in Broadview for the last week, preventing them from exercising their First Amendment rights. The suit also claims the tactics infringe journalists' right to cover the protests. There comes a point to where your rights should not be rights anymore. If your rights infringe on the safety of those in that building, if your rights are over superseding the rights of somebody else, then how are your rights more important than the other person's rights? This is a conundrum. It is. So the judge order which appeals to the entire North District of Illinois blocked federal agents from firing various types of less lethal projectiles and chemicals, irritants and it from using force such as pulling or shoving a person to the ground, tackling, or body slamming an individual. Well, if you need to be arrested and you're resisting arrest, then doesn't that mean they can use that force? Let's read on. Federal agents are more broadly prohibited from ordering a crowd to disperse or require any person to leave a public place that they have a lawful right to be. There are exceptions for individuals who pose a threat to the law enforcement or others. The day 14 overtook effective Thursday. The 14th day order took effect Thursday and applies to all DHS agents, including those with ICE and U.S. Customs and Border Protection in district, which encompasses Chicago's and Broadview ICE processing facility. The judge also laid out specific protections for journalists covering the protests, blocked federal agents from arresting members of the press unless there's probable cause to believe the individual has committed a crime. A preliminary injunction hearing has been set for October 23rd, according to the federal docket. The order issued on the same day that another judge temporarily blocked the Trump administration from deploying National Guard members to Illinois, one of several legal battles playing out over the President Trump's push to send troops to Democratic led cities. The new ruling limited the use of force against protesters was issued in response to the complaint on behalf of multiple plaintiffs, including a Presbyterian pastor who was struck in the head by pepper spray while taking part in a demonstration. The Reverend David Black in Chicago First Presbyterian Church stood in the street offering prayer and urged ICE officers to repent when he was repeatedly struck in the face by masked agents standing on top of ICE facility, according to the lawsuit and the video taken during the protest. Black was visibly attired in clerical garb, the lawsuit said. Moments later, he was doused with chemical spray and ICE agents directed it at his face. Well, that's kind of where they're supposed to direct it, people. I'm not going to go ahead and keep reading all this because it's quite lengthy, but I felt that since somebody requested it, I would. Wow. It does get a little bit dicey. We will not get involved in politics, no politics, but I will read certain things that come about. And this because it involved a pastor who was dressed in regalia, not garb, it's regalia. And that was shot in the face with pepper spray. But I wonder, what did he do to instigate it, if anything? Yesterday in Miami, there was an altercation with a guy and his brother. He killed himself. Unalived, I'm sorry not to be mean. Again, you guys, we do have to be very careful with verbiage, even in chat. I know some channels will let it slide, but I do not feel like, nor do I want to contend with, nor do I want to fight yet another block because of verbiage. Please do not use the KS. Use a self-harmed. Don't use the S word. Use self-harmed. Please use the word self-harmed. That is the word. Unaliving instead of the KIL word. I'm sorry, that's just the way this rolls, y'all. All right, let's get into court. Let me get everything up and going. Let me get everything switched over. All right, let's get going to court today. We're hopping in. We will be having evidence. This is the wonderful plaintiff sitting there, all prettily and dressed, ready to go for her trial. Good for you, boo. She's a pretty woman. Pretty woman walking down the street. Sorry, couldn't go there. Couldn't help but go there. And thank you to our correctional facility directors and staff for their fabulous job in court. I'm skim to the beginning. Let me see. Do we have volume? We have no volume yet. I'll let it go there until we do have volume. For those of you who don't know, this trial has been going on for a few days. Thank you so much for joining me. In court yesterday, we had several witnesses that were talking about the ballistics and the what's the word I'm looking for? Gunshot residue. So here's the defendant. This is the case thus far. Daisy Link is charged with redrum. She is age 30 years old, accused of second-degree redrum on June 25th of 22, fatally unaliving her on-again, off-again partner, Pedro Jimenez. The prosecutors assert that she unalived him after he turned and tried to flee. The defense contends she acted in self-defense, citing years of alleged abuse. We have another Sarah Boone here. She didn't do crazy stuff like Sarah Boone, but we have another Sarah Boone here. Body camera and surveillance video are being used by the prosecution to link links version of evidence. That's kind of funny. Crime scene detective mapped a red liquid trail consistent with Jimenez's movements. The prosecution claims Link misled the investigators. A neighbor, Robert Cinceneros, tried to testify that Link's pacing outside her home around the time of the unaliving, emotionally distressed. Link admits that she fired a shot, but maintains it was in self-defense after enduring abuse. The defense cites prior indictments 5 days earlier, where Jimenez allegedly pistol whipped her, and evidence of his capability for violence. The judge denied the motion to dismiss based on Florida's Stand Your Ground controversial side. Link became pregnant. This is one of the interesting parts of this case. Really interesting parts of this case where Link becomes pregnant in prison or jail, excuse me, after her connection. I don't know the guy. It's a connection. Don't know how they connected, but her and a male inmate kind of created a relationship through the vents. And she convinced him to send his love potion, his lovey juicy juice, through the vent in some kind of receptacle. And she inserted it and miraculously became pregnant and in jail. She has been in jail since, I think, 22. And she gave birth in jail and has a daughter, which is being maintained, which is being taken care of, not maintained, taken care of by her family. Opening statements and trial have underway. Prosecution is focusing heavily on the contradictions between Link's statements and the video evidence that they have. Defense must convince the jury that Link feared for her life and that there was a history of abuse, justifying her actions that day. So let's see what we get. We have no volume yet. It's going to be loud when it hits. Guard your ears, y'all. Why do we not?
So late last night, I finished going through the entire 11-hour statement. I finished around 2 o'clock in the morning. So I didn't want to call Mr. Tomas at 2 o'clock and wake him up. I have timestamps of what I believe are either irrelevant or inadmissible. Mr. Tomas and I spoke briefly this morning. The only actual issue I believe that exists, there is a point in time in which when Detective Janoris walks in at some point, she goes to Ms. Lang, I have a question for you. What happened on Monday? And I can't remember the exact words that are used, but Ms. Lang volunteers that she smashed the window of the truck that we discussed during the Williams rule. Ms. Link's response to all that in context is that was immediately after the victim had pistol whipped her. I can read that portion in time because obviously the court said that could not be used as a Williams rule. I do think it's relevant in this case, in that context, but if the court's order is that cannot come in, I'll mute that entire portion.
So Janoris comes back in and that's an isolated mini conversation.
Yeah, it's I have my timestamp here. It is during the full 11-hour statement. It is at 8:29, 8 hours and 29 minutes, and it goes 8 hours, 29 minutes, and 17 seconds.
But it is isolated.
Correct, yes. That's the only actual portion about the truck that's ever involved, but I do think it goes directly to the state of mind of the defendant. It goes directly to the defense's argument that had been brought out multiple times now that the victim had pistol whipped her prior to, that she was in fear, et cetera, et cetera. I think it goes directly to her state of mind. If the court's ruling still is that I cannot bring that up, I would just ask to revisit it on rebuttal at that point in time, but I understand whatever the court's ruling is.
Let's just work backwards. Do you want that in or out, Mr. Tomas? Okay, so it'll be redacted.
Sure.
Muted, however way. The other parts regarding this person getting arrested, that person getting arrested, are both sides in agreement for those?
So I've muted, well, let me phrase it this way. I have my lit support currently working on muting all specific mentions of any actual acts of domestic violence or arrests that are brought up. I intend to elicit testimony from Detective Janoris that this was a volatile relationship, that there were acts of domestic violence that were occurred, but I don't want to get into the specifics because as Ms. Link mentions,
Let me ask you this, how are you gonna ask Doris about their relationship?
did the defendant tell you that this was a volatile relationship? She actually, the exact words that Ms. Link uses in her statement was this was toxic as hell.
Okay.
Did she tell you that this was a toxic relationship? Did she tell you that it was volatile? Did she tell you that there were acts of domestic violence that were committed by Pedro Jimenez against Ms. Link? She will answer yes.
But all of those words that came out of Ms. Link's mouth were in the report, right?
To a certain extent, yes. Ms. Link gives specific examples. She says she woke up in a bathtub. She doesn't give a time, a date, anything like that, but she says it happened a while ago, which is also
Good morning.
by Ms. Link's statement to other officers that, yeah, Pedro had a past, but that was very long ago. Ms. Link also talks about how with the bathtub incident, she says, well, that was the last time I got arrested.
But why revisit it again with divorce? Why, what's the purpose?
Because as of right now, those things really haven't come into evidence, right? The actual acts of domestic violence that are spoken about are not really.
But what's the purpose of having divorce highlight?
I'm not highlighting.
Half a dozen so.
No,
areas.
I'm not gonna have her speak about any of them, and as we talked about yesterday, the only thing that I'm gonna have her talk about is, did Ms. Link tell you it's a toxic relationship, etc.? Did she tell you there were acts of domestic violence? I don't intend to have her say, yeah, she told me about the bathtub incident. She told me about this, she told me about that.
I'm not answering my question. What's the point of having generic repeat these? The jury's already gonna hear.
Good morning.
No, they're gonna be muted, because again, the court's rulings during the motion in limine that those specific acts were not coming into evidence. The only actual act that was going to be discussed was the pistol whipping incident from 5 days ago. So what I'm asking Detective Janoris to testify to is, did Ms. Link tell you that there were acts of domestic violence? She will say yes, and then I will stop. Did she say that there were acts of domestic violence that Ms. Link also committed against Pedro Jimenez? She will say yes, and then I will move on. And the reason why is because it shows the totality of that actual relationship, and it's inextricably intertwined with my theory of the case that this was a toxic, volatile relationship with domestic violence going both ways.
So, Judge, what I would say to that is, nobody's disputing that this was a toxic relationship. My concern is we have a statement where Ms. Link talks about why it's a toxic relationship, but we're going to mute that, but then we're going to let this person give a secondhand account of a statement that's going to be in, but it's going to be redacted. I don't see why those two scenarios should coexist.
Well, so I don't have to play the statement at all. I don't have, I can publish only even portions of it. The law is incredibly clear that I'm allowed to present evidence as I want to, that this is not applicable to the best evidence rule either. And again, the court has already ruled that those specific acts of violence, either way, are not coming into evidence.
So then why would I allow Janoris to say orally? They can't come in.
I'm not going to ask her about specific acts. I'm going to ask her, did Ms. Link tell you about Mr. Jimenez committing domestic violence? Did Ms. Link say she committed domestic violence? I'm leaving it in a very broad sense because Ms. Link talks about her actual arrest, which I don't think, based off the defense's arguments last week, and the court's inclination prior to, that can come in, right? We're talking about the second phase of the case at that point in time. Same thing with the victim's arrest. She says he was arrested for this, the bathtub. He wrote a letter to his mom. None of that is relevant to this case.
So you want to be able to corroborate that there was domestic violence on both sides.
Correct, which is my theory of the case.
So what we want to do is the half dozen or so specific incidents from the actual video, based on my ruling, should come in. But the state still wants to paint a picture that there were acts, not necessarily criminal acts, acts on both sides. And it sounds like a pretty general, they want to elicit pretty general evidence from the detective regarding that. I think based on the way that they want to elicit it, it won't be a feature of this detective's testimony.
No, it'll be seconds.
So
Well, if it's limited to the very general questions that he just.
Yeah, I misunderstood. I thought you wanted to more say, wasn't there back to this?
Absolutely not, no.
That was my bad.
Okay, so if it's limited to those very general questions, then
Right, and so it goes into their theory of there were ups and downs.
That's
You
fine.
used the word volatile, so I'll allow that.
Judge, I want to give you a heads up. I just sent you an email. I copied the state. So there is an order dealing with the custody of the kids. I did locate it. It's part of the dependency case. The clerk will not give me a copy unless you sign an order. So I'm asking, I sent you a proposed order. I don't know if you want to tweak it a little bit, but I tried to cover all the bases there. They don't have the file right now because it just so happens that just yesterday, they finally quashed that pickup order, which had been outstanding for a long time. So just so the court knows, now that that pickup order is quashed, maybe Ms. Link's mother will change her mind and provide Pedro Jr. I'm going to be at the state attorney's office on Monday morning to conduct depositions anyways. So if she brings Pedro Jr., then we can resolve that on Monday morning. If she doesn't, I have no control over what she decides to do, but just wanted to make the court aware of it.
We'll still need to litigate a few things regarding that child, and then I would also, so I don't know the statute off the top of my head, but there is a statute that says any party, including the court, can move for a hearing on whether or not it'll be traumatic to a child witness to testify in front of the defendant. If we get to that point, I'm going to be moving for that child to be given his testimony, not in the courtroom as well, but we can cross that bridge when we get there.
So I'll go ahead and have the set threaten me a copy of this. And it looks like it's fine based on my review. I'll sign off on it. But this is for your case sheet, right? This is for your presentation of your case, so you may not, hopefully they get it to you today.
They're not going to get it to me today, Judge. They said that if I show up, they're closed on Monday. I show up Tuesday morning at 9 with a certified copy, then they'll give it to me. I'd ask, because they don't have the file because it was in court yesterday, because they just signed that order.
Do you know which judge?
Probably not the same judge anymore, but.
How do I say this now?
I'm sorry, I just emailed this one. Oh, sure, thanks.
I'm not sure which judge it is, Your Honor.
You made some phone calls. But you want to present this when you start your case on Tuesday?
Yeah, it's a self-authenticated certified document. Looks like Michelle Alvarez Barracat signed the order, the old order. I don't know if there's a new judge assigned to it now. It just says cancellation.
Still over there, so it's probably.
Okay.
We'll make some phone calls.
And Judge, I'll send you, if you don't mind, once there's a certified order, if there's a way that you can email it to this supervisor clerk, and I'll send you the email. Just, I don't know, so.
Once my JA gets it, I'll have her send it over to Judge Barracat. She can copy both sides, and I think I can ask for a certified copy, which probably, I'll probably get it before you get it on Tuesday.
I would think you would.
Let's hope they give you that. I'm sure they will. I'm sure Judge Barracat will give me that professional.
Thank you, Judge.
There's one other issue that I spoke to Mr. Tomas about that I think is actually very.
Going back to the statement.
Sure.
We'll just talk about it when we go over lunch.
Yeah, absolutely. I have, like I said, I have my own timestamps. I'm asking Mr. Atala, the reason why I'm doing this is we don't have the actual statement yet. Like I said, I finished it late last night. I have timestamps, but when I went to my litigation support team this morning, their timestamps are used on a different program that is significantly more accurate than the program that I am given. They're off by about a minute or so. So while we're in the trial, Mr. Atala is confirming the actual timestamps, but I have what I have, which I think.
What is he recording?
Basically. Basically.
Your Honor, so there's essentially internal timestamps that are already embedded into the actual interview, so I'm just cross-referencing those.
And then I'll be able to provide a copy of that to everybody, but I can speak to Mr. Tomas about what I'm actually planning on redacting and removing from that video itself.
I wanted to, just gonna tell them what to take the jury on that side. Can I revisit a little bit what we discussed yesterday regarding the,
First Miranda.
yes, but also the, I'd like to file my email with the court as according to the one. My concerns regarding the spontaneous statement, okay? Nothing in this email is anything different than what we generally discussed before, it sort of narrows, it not sort of narrows down my concern about the way that the spontaneous statement came out. And, my belief that the instruction I gave to the jury about, how the jury should view the spontaneous statement, I think I'm correct, so I just wanted the appellate court to see what I was thinking and the case law that I provided to you all yesterday, so that would be Court Exhibit 1. Look, in the context that it was said, it was pretty jarring. I understand it may have fallen into the spontaneous statements category. We haven't heard all the evidence yet, and the jury's supposed to keep it in mind. If Ms. Borrell testifies and more evidence comes out about Ms. Link and her self-defense claims, I think that statement is less impactful. Does that make sense, Mr. Thomas?
Yes, sir.
We still have to look at we're only halfway through the trial, we
Yeah.
still half more evidence, half as much more evidence that needs to be admitted, and there's nothing stopping me from saying something along the lines of the family knew it was quote unquote a bad relationship, and it's not unreasonable to believe that something bad was going to happen to either side, something along those lines, right? Okay. Not yet.
Yes.
All right, did you and Ms. Link talk about the Miranda waiver? Yeah, 40-1.
Yes, she wants the whole thing in, including.
I went back and I looked over the Miranda waiver in the second one. While the police say something along the lines of, so you want to talk to us, we have to go over your rights again. They use the word again over time.
Which, sorry not to cut the cord off, that's muted.
Oh, well, I was gonna say, that doesn't indicate that she has invoked the right to remain silent. Just because they're going over the Miranda rights a second time or again, it's not a comment on the silence. So yes, the state is going to meet that. I don't think they need to meet that because this doesn't indicate that. My concern is a comment on the silence. So,
Yeah, I would just ask they play it, but no commentary, no unsolicited comments from the witness like we had yesterday with that detective.
my point is, it's not necessary for us to talk about the first Miranda.
Yes.
Because the second Miranda doesn't indicate a comment on her silence or the invocation of any rights, number one. And number two, since it's in the benefit of Ms. Link to have this statement come in, I would think that we would want to streamline it.
Yes.
Do you understand what I'm saying? Yes. So if you, as you as a lawyer, believe strategy-wise, it's better for you to have the statement come in, it looks like it's coming in with certain protections. For example, the jury's not going to know that you were arrested. Does that make sense?
Okay.
So what would be the logic in bringing in the first statement where you invoked?
Because they spoke to me outside of the board either way. They were speaking to me the entire time, even though they weren't supposed to. They basically coerced me into signing that second sheet when they took me to the bathroom with an entirely different investigator from the DV department.
But at this stage, you're agreeing that what's in the full interview is better for you.
Correct. Yeah.
For this trial. So why can't we just move on and not from your point of view, understand that you're getting an overall benefit, even though there's parts of it that you don't agree with, the way that they got you to speak, for example.
I can understand that.
You also understand that there wasn't a motion to suppress file. Didn't have the cops come in and prove to me that your Miranda statement was a knowing voluntary waiver. We didn't have that argument. that's a constitutional motion that could have been filed, just like the standard ground, but that wasn't in front of the court either, right? So that, to me, that's also like strategic point of view, strategic move by the defense, right?
Yes.
Okay, so do you want to couple, so it sounds like you don't want to talk about the first Miranda waiver. Okay, because if you do, you and I have to have an in-depth conversation about what it means for this jury to understand that you invoked your rights. And essentially, it's a comment on your silence, which has all sorts of huge constitutional
Interesting.
ramifications that need to be weighed in this courtroom for appellate purposes. Does that make sense?
Yes.
So why don't you just talk to her real quick about
Yeah.
us not going into the first Miranda?
Judge, I'm just gonna step outside.
Yeah, I'll step outside too. And do all the registration, all right, seats.
Okay, so we've got a lot of arguments going on here. We'll see what hits, but dang. Sorry, y'all, I had to get a new cup of coffee. I was so distraught. My coffee wasn't functioning. My coffee wasn't functioning. I didn't have my coffee, and I tasted it, and it was cold. Has anybody, oh, you want to talk about a disappointment? Has anybody ever brewed a cold cup of coffee and it was supposed to be hot? And then you go in and you take a sip and it's like, whoa, not good. No buenos. So thank you for your patience. I went and made me a little macchiato thing and a cup of coffee.
So, yes, ma'am.
How are we proceeding on the first Miranda?
So,
No, no.
so we'll leave the first one out, and like you said, you're gonna say, you're gonna read your rights again. That's fine.
I'm muting the part where they say we're gonna read your rights again. It's just gonna go into Detective Norris. I can show everybody later when I have the actual redaction, because I don't remember it.
Do you think it's,
I just don't want any mention of again or anything like that.
I would ask that again, State. That's the one.
again, it's fine, because it's not a comment on your silence.
Right, but it implies that she was already read her rights, and that's my fear. If Ms. Link is willing to waive that appellate right to at least that portion of it, I'm okay with leaving it in. I'm just very concerned about even going near the idea that Ms. Link had invoked at any point in time. That's my fear, and as we have said a number of different times, I don't want this case coming back, which there is just case law after case law after case law that says any mention about any kind of first indication of Miranda rights is reversible error, and I don't want to even come close to
I
it.
know it's nuanced, but the second reading doesn't, it indicates the second reading, it doesn't indicate.
But Your Honor, they wouldn't even see a second or a first reading.
Right.
It will essentially be cut off.
And
Hold on, I understand where you're going regarding influence, but if
Right.
you make that argument, it is what it is, okay? And you know what I said.
Judge, respectfully, I'm not comfortable playing that if Ms. Link is not going to waive her appellate rights to that specific issue. I don't care about the first part coming in or her waiving there, but if there is a mention of we're going to read you your rights again, I'm not comfortable publishing that to the jury in any manner whatsoever. And the way I'm instructing Detective Norris to limit that is, did Ms. Link approach you while you were fingerprinting her and explaining why she was being fingerprinted? Yes. What did Ms. Link say? Did you approach her? Did she approach you? She said, I didn't mean to kill him. Detective Norris will say I said to Ms. Link, in order for us to talk to you, we have to go over your rights. And then I will discuss Miranda and discuss her waiving of Miranda and publish that portion of it. But I am not comfortable having any mention of again or anything like that, especially since we had a detective testify yesterday about Ms. Link not having to cooperate with law enforcement and objections sustained that were made by defense counsel about any kind of inference about her refusal to cooperate with law enforcement. I'm not comfortable, and I'm just not going to play it.
Understood. Are you agreeing?
So, as far as to there being mention of the word again, yes, I will waive any appellate issues as it relates to that very specific part being put.
And are you in agreement with me that while it says again, and we have to go over your rights again, it's going to be the same form, the state is concerned that there may be an inference that there's a comment on her silence.
Right, so I'm waiving that specific appellate issue, yes.
Ms. Lynn, do you understand?
Yes.
So even though Mr. Tomas believes legally he can waive this, it really is up to you to decide if you're going to allow the state to play the full second interview, the portion we're talking about now, about police going over your rights again. So you understand that no one's going to tell the jury that you invoked the first time. No one's going to tell the jury that you invoked your right to remain silent. No one is going to comment on your silence. But you're essentially agreeing that that is not going to be an issue for appellate purposes. Do you understand?
Yes.
You've had enough time to speak to Mr. Glass about that?
Yes.
Okay, do you need any more time to speak?
No.
Okay. Do you have any questions for me about what we just went over?
No.
All right. Okay, so I think you have a waiver.
Yeah, so I'll talk to Liz support about that later this afternoon when we actually publish that video and have that portion. There's a few other issues that I think are imperative to address. First and foremost, I walked outside, I made eye contact with one of the jurors, I recognized her, I said hello, I didn't realize who it was until I said that, and then there were a handful of witnesses around where the jury is, they're right outside the courtroom. I asked them all to just move away, so that way there'd be no...
That's fine, well, I asked them virtually,
Yeah, they're right there. I just want to make everybody aware of that. The second issue is I want to make sure that we are not proceeding forward on any kind of suppression issue, because Ms. Lynn specifically said earlier that she was coerced into waiving Miranda, so she's going to be...
my understanding based on my conversation with her is she understands that no motion is suppressed.
Right, I just want to make sure that that is also on the record. And then the third
That's
thing...
right.
Yes.
And then the third thing is, I spoke to Mr. Tomas about this. I spoke to Sergeant Crementini on my way into the office this morning. What he informed me was basically this. The phone extraction that is currently in evidence is the entirety of the phone extraction. However, that was done sometime about 2022. Sergeant Crementini, who was working with a team at the time, now has access to better technology. And very recently, within the last week or so, he decided to plug that phone in again and do the extraction again on his computer. Additional data was able to be read at that point in time. He called me this morning and informed me of that. I sent those text messages over to defense counsel this morning. The way he explained it to me was... No,
it sounds like I'm going to have to have Richard.
Right.
Before late turning over the stuff.
Well, so yes and no, and I was going to suggest to the court that we do that, and that's why I'm kind of explaining it in the way I am. The way he explained it to me was this. Technology is ever changing. It's getting better, and as the technology gets better, the actual extraction itself is able to be read more fully by better technology. We now have better technology that is able to read that data and different data. The way he described it was basically like the DNA swab. DNA swabs get better over time. It's still the same blood, it's still the same DNA. However, you're able to read more. I sent over what he sent me today to defense counsel, which is a handful of text messages.
Please have a word to the jury all the way on the side, please. One man will communicate with me. You're too close to us, please.
Those text messages are between Ms. Lynn and somebody by the name or saved in her phone as, I believe, Smoke. Those text messages include references to shooting people, shooting Smoke's girlfriend, etc. As I said, and as the court indicated about the Richardson, I was going to successfully do one. I don't think it actually.
Why is Smoke's text messages relevant to you?
It's not. So that's what I was going to say. It's not a discovery violation because all that data still existed and was turned over. It's just a newer program that is able to read that data more. It's inadvertent because, again, we couldn't read it when this was actually turned over. it's prejudicial because it could affect Ms. Link's cross-examination or her testimony because she says in her statement, for example, that she didn't know anything about firearms, etc., but she's saying this to shoot other people. My remedy to it, I will not use it whatsoever, and it will be excluded entirely, and I'm going to direct Detective Cremencini to discuss on his direct examination the betterment of technology over time, and if he has done anything recently, specifically about the videos on Ms. Link's phone.
So it's only relevant, the betterment of technology is only relevant about the videos on the phone?
Correct.
Have those been played?
One of them.
All right, is there something else that's going to be played?
Yes.
And do you have access to that, Mr. Demas? You know what it is?
I'm not sure if there's any new information that I didn't already have.
So there's a few of them. There's the defendant and there is the defendant and the victim exiting the vehicle together, which I'm going to talk to him about the actual timestamp on Ms. Link's phone on that, which is somewhere in 10:30 time.
10:31, that's the day of the shooting?
The night before. So the shooting happens at like 3 a.m. They get outside of the vehicle at 10, which is corroborated by Ms. Link's own statement. There is a video that I plan on publishing later with the children also, them acting as a family. And then the actual shooting itself, I was planning on talking to him about the timestamps.
And these are all 1 or 2 days before the shooting?
This is the shooting, the night of the shooting. These have already been turned over, and what I'm going to ask Sergeant Cremencini is, were you able to verify the 2022 extraction to whenever you did it recently? Are the videos changed in any way? And he will answer no. He will actually say exactly, I believe he said it was 861 videos that were on Ms. Link's phone are the exact same from a few weeks ago to the day that it was extracted. There's no change whatsoever when it comes to the videos.
So, I guess just so the sufficiency of the investigation, they explain it that, which is why the testimony will come about recency and extraction of videos on the phone, even though they've had it for 3 years.
So it sounds like, at least with the videos, I have all the videos already. The
Yes.
only difference is that they were able to get timestamps from within the data.
No, so if you look at my computer, I'll show you. So if you look at, I know the court can't see it, but just for the purposes of the record, if you look on the actual Cellbrite report, which is what is furnished to me, the shooting occurs and there's a timestamp of when it was created at 6/25/2022, and there is a 6 minute and 57-second video. Part of that was published yesterday. It's created at 3:06 a.m. When this link is seen, it's about 6 minutes into the video. I'm going to have Sergeant Cremencini say, okay, if this is started at 3:06, that means that this occurred around 3:11, 3:12. Then I'm going to show him the call log of the defendant with the 911, showing that 911 was called around 3:21 a.m. All of this has already been in defense counsel's possession. Nothing with regards to the video has changed whatsoever. The only difference is that the technology changed so that we could better read information, and these text messages that were now being able to be read were now furnished to defense counsel. I do not intend to use them whatsoever. I wanted to make sure that that was on the record, that I am giving the remedy of that exclusion of that evidence, regardless of
and the few that you want to play, because you already said that she came looking for him at, what's his name, Brian, what?
Kevin Bonilla.
Kevin Bonilla's house. It goes hand in hand, that they were getting along.
Correct.
Until the time of the shooting.
Yes.
So it sounds like it's relevant.
So I don't have a problem with the better being able to pinpoint the time that the videos happened based on this new data. That's fine.
No. The extraction that I have, this is from 2022. Nothing has changed. What I'm talking about, the data being better and the extraction being better, solely goes to the text messages. I'm just going to ask Sergeant Cremencini, did you confirm when you got better technology, were you able to confirm that the videos that were extracted are exactly the same? There's no additional videos or anything like that.
So Judge, my only concern would be bringing in text messages or anything else that I hadn't seen up until now, but it sounds like they're not doing that.
That's correct. That's
So
correct.
then there's no problem.
Right.
Yeah, you have to be careful with the word confirm. That's a conclusion, right? Why don't you ask him?
Well, he can, because number one, he's an expert. Number two, he will and can testify about hash marks and how you can confirm that the same data that is on the phone then is the same data that's on now. He will say they're the exact same hash marks.
So what, so you will start out by asking him, what's the date, whatever hash mark on this item versus this item? And then he can say factually that they're the same.
Yes.
And then we can ask them, do you confirm that they're the same?
Yes.
Do you understand why?
I do.
I'm concerned.
I do.
You just saying, this and this, are they saying, do you confirm?
I know, I'm gonna lay significant predicates
Okay.
before I even get into that. And we can also go sidebar to make sure, or voir dire him outside the presence of the jury to make sure that everything that we do is in the correct way, so that way there are no issues later on.
I think we take care of, we're supposed to take care of before these next witnesses testify.
Yes, sir.
Who's gonna be the first one?
We're recalling Detective Zapata. Sorry.
All right, so can I start?
Yes, sir.
Yes.
I'm not sure which woods.
I got a fly in the house, y'all. No, this is no joke. She seriously did.
And I also had there's a roll of yeah, I'm moving there.
We have to do these surveys at the end of our coursework in college. And I have to fill it out by today. So. All rise, bring the jury. So yes, I'm filling out the instructor surveys because I am ending my first 8-week classes. I take 2, and then I take 3 at the end of this. So yeah, I am 3 classes and 8 weeks away from being a graduate.
Sorry for the delay, this is my fault.
My apologies. I am 8 weeks and 3 classes away from being a graduate. And so what I have to do right now is I have to fill out these surveys.
At this time, the state calls Detective Zapata. Just call Detective Zapata.
Judge, permission to reposition the podium?
Yes. from the last time you testified. So we're not gonna swear you again, but you're still under.
Survey's done.
Good morning.
Good morning.
I want to go back to photos you took from the scene when you arrived June 25th, 2022.
Okay,
You mentioned in your testimony that you photographed a vehicle.
that's correct.
I want to focus on the vehicle that was in the alleyway. What kind of vehicle was that?
It's a silver SUV.
And did that vehicle have blood on it?
Yes, it did.
And did you also review photo vehicle was in?
Come on, land where I can kill you. Come on. I don't know if I got it.
Mr. Jimenez's license and some other cards and wallet were found also, is that correct?
I would have to take a look at the photos.
Sure. Judge, if I may approach, I'm going to show you what's marked as Defense Exhibit 1. Does that appear to you to be the license of, well, actually, 2 licenses of Mr. Jimenez? There's 3 pages there if you want to take a look.
Yes, it says his name on them.
And there's 2 of them, right?
2 licenses. Ooh.
Yes.
Do both those licenses have the same address?
Nope.
Yes.
And what address is that?
956 Northwest Fort Terrace.
That's not the address where Daisy Link lived on the day in question, correct?
It is not the same address.
No further questions?
Hmm.
Yes, please.
Judge, permission to approach? Ms. Zapata, is the address that was listed on Mr. Jimenez's license to your left the same address that was listed on the mail that was found in the rental car to your right?
Yes, it is.
And does that mail also have Daisy Link's name on it?
Yes, it does.
And was this mail found in the car that Ms. Link was driving the night the victim was shot?
That's correct.
Objection calls for speculation as to Ms. Link was driving the car on that night.
It's the same. You want to re-ask the question?
Oh, yes, Judge. Is that the same car that was found on the scene next to the victim's body in the alleyway the night he was shot?
That is.
No further questions, Judge.
They're just establishing, they just need to establish the vehicle and the contents of the vehicle to establish that it was his. Or hers. Sorry, my bad.
The next witness will be, say, the next witness will be.
And you can see here in the picture the seats of the vehicle where there appears to be some red liquidy stains. Oh, y'all, I do have a paper to write today, so I may be double dutying it today. It just dropped. Some of my professors will give everything all at once at the very beginning of the semester, and some of them kind of piecemeal it out. And this is in lieu of a quiz, so we drops it today, and I have to finish it by 3. So yeah, double duty, double duty.
Testimony about to give the truth, the whole truth, and nothing but the truth.
I do.
Sorry, just 5 seconds with your.
We are doing the. Oh, sorry about that. We are doing the sidebar thing. Let me get the guy up here. I was trying to zoom past the. Okay, we went into a break. So they went straight into a break. So what we're going to do is we're going to hop on over. I'm setting it up, y'all. And I get the wheelie at that.
Okay, not
Okay, so some of this stuff is from yesterday because the witnesses are not allowed to be filmed and broadcasted simultaneously. They will get it at the end of court. So some of this stuff was yesterday's, while today is being filmed.
Ms. Ellis's mental state at the time of the alleged offense. Is that correct?
I did not evaluate sanity. That was not my role.
Okay, so you were not asked to give the opinion of whether or not she knew the wrongfulness or not of her conduct in this case. Is that correct?
That's correct.
Okay. So your report does not address her sanity at the time of the offense.
It does not. I wasn't assigned to do that, and so I did not even ask the questions one would ask to perform a sanity evaluation.
Okay. But you are able to say that her same mental illness would have been present at the time of the offense. Is that
Yes, she had schizophrenia. She was ill at the time, but I don't have an opinion on legal sanity because I did not do that evaluation.
correct? Okay. Even though you didn't do the evaluation, have you ever done an evaluation for sanity?
Yes.
And can you explain to the jurors what goes into doing that kind of evaluation as opposed to something for competency?
Sure. Competency is, when I do a competency evaluation, what I do is I meet with the person that I am assigned to evaluate, and it's an evaluation of them at the moment that I'm seeing them. What is their mental state at that moment? And then do they have what's called adjudicative capacity? So can they understand their charges, how the courtroom works, and can they assist their lawyer at that moment in time? That's what I was assigned to do, and that's what I did twice. A sanity evaluation is very different. What a person who is doing a sanity evaluation will do is they will go back, once a person is competent, they will sit with them, they will gather from them their account of the days preceding the offense, their account of their mental condition around the time of the offense. They'll get their account of the offense itself, and then they'll review extensive records from collateral sources, hospital records, maybe emergency room records, police records, anything from the time of the crime. The role of someone who's evaluating sanity is to look at the time of the crime and make some determinations about how the person was then, why they did what they did, and whether their illness interfered with their ability to know it was wrong. That's a sanity evaluation. That I did not do.
Okay. Is mental illness limited to a particular group?
No, it is not.
Okay. Doesn't matter how much money you have, what color you are, what your age is.
No, we all have brains. It's a brain disorder, so it doesn't discriminate.
Okay.
Hey, now we're back in court. I know we're flipping back and forth, y'all. Okay, June, can you hear me? All of a sudden, I had gotten a warning about a screen share problem. There's no sound. Okay, let me do, y'all hold up. I'm going to reset the browser. Here we go. I'm resetting the browser. I don't know why. Sometimes that happens. It's okay. We're all good.
Qualified as an expert.
Now is there sound?
Forensic pathology.
Now, Dr. Mathis, can you tell the jury what exactly a medical examiner does?
Sure. A medical examiner is a forensic pathologist who works for the government generally. And we're charged with investigating deaths of individuals who die either under circumstances or because of who they are that the state has an interest in. So all non-natural deaths will go to a medical examiner, accidents, suicides, potential homicides, drug overdoses, inmates from the prison, those who die in police custody. And then when we investigate their deaths, we need to determine the cause of death, what caused them to die, and the manner of death, which is how we classify their death. We'll perform whatever investigations or studies we need to do, whether it's a record review, looking at their medical records, to performing a full autopsy, performing special dissections, having special tests run, studies done, also that we can determine what the cause and manner of death is.
And were you working as a medical examiner for Miami-Dade County on June 25th, 2022?
I was.
Are you the original medical examiner who did the actual autopsy on the victim, Pedro Jimenez?
Yes.
So I want to talk about your involvement in this case, Dr. Mathis. When did you perform that autopsy?
June 26, 2022.
Where did you perform it?
At our office, it's a medical examiner department. It's right across the street from Ryder Trauma at Jackson Medical Center next to Miami-Dade College Health Campus.
And when the body arrived for autopsy, what was its general condition?
He was in a fresh state. He had soiling from blood staining on his legs.
And did you observe any signs of medical intervention, such as bandages, anything like that on the body?
Yes, he had a tourniquet on his right thigh.
Now, can you walk us through the steps you take when performing an autopsy, Dr. Mathis?
Sure. So first, we capture the height and weight. We take a receiving photo of the individual. Then if it's a suspected homicide, we'll get pictures of the hands. Then we'll collect fingernail clippings as evidence. The body will then be washed. We'll take photographs, overall photographs of the individual. And then if there are any tattoos or injuries, we'll take photographs of those. Once the photographs have been taken, then the doctor will take any written notes about the external appearances of the body, of the tattoos, of the injuries. And then at that point, an internal examination, or what people colloquially call the autopsy, will begin to be performed.
So you mentioned a lot of steps there.
Yes.
So I want to break that down. Can you explain to the members of the jury what an external exam is?
Sure. So external exam sounds just like that. We're taking note of the external features of the body. First is the routine, their body size, their body habitus, their height, their weight, their eye color, their hair color. And then we will, after all the regular stuff has been documented, then we'll turn toward tattoos and scars. And then then we'll move into injuries. If there are any external evidence of injuries, then we'll document those down as well.
So you mentioned that you document tattoos. Did the victim in this case have a lot of tattoos?
He did.
And was one of those tattoos the name Daisy?
Yes.
Now, you also mentioned you start with external injuries. So I want to talk about those. What external injuries did you observe on the victim's body in this case?
Yes, so he had a through and through gunshot wound on his right thigh and a through and through gunshot wound on his left foot.
Now, Dr. Mathis, you mentioned a through and through gunshot wound through the right thigh and left foot.
Yes.
So I want to break that down. I want to start with the left foot. Your Honor, I now move into evidence what has been previously marked as states 1W by stipulation of the parties.
State Exhibit 1W marked for identification now becomes State Exhibit 20.
Now, Dr. Mathis, is this the victim's left foot?
It is,
Now, you mentioned that he had a through and through gunshot.
yes. Can I come down?
Permission to
Don't
witness
show my
that
glasses.
Can you show to the members of the jury where the entrance wound is on this foot?
Maybe hard for you to see it as well, but the entrance wound is on the bottom of the left heel.
And how do you know it's the entrance wound?
So, in general, entrance wounds are round, they can have a rim of abrasion. In this case, though, his skin is different than the rest of the skin on the body. Regular skin, a lot of it has hair. Foot skin, the plantar skin, the skin on the bottom of the foot, it's thicker, it's more elastic than the rest of the body. Anybody who's done a foot rub can attest to it or had to remove a splinter. So when a bullet goes through the skin of the sole of the foot, the plantar skin, the tissue is very elastic, so it will retract, allow the bullet to come in. So when you have an entrance wound on a bottom of the foot, you're going to see more of a slit-like appearance. In this case, you can even see a halo where the bullet tunneled in, but the skin retracts after it, and it's just the nature of the skin on the bottom of the foot. So
And-
that's the entrance wound.
And in this picture, where is the exit wound?
The exit wound is on the Achilles tendon region on the back of the heel.
How do you know that's the exit wound?
Exit wounds are irregular. Oftentimes you can take them and push them together, the edges together. You can see that this has that kind of split-like irregularity to it, and then the pieces fit together like a puzzle.
And now, Dr. Mathis, looking at the entrance and exit wound, can you determine the path the bullet took when it entered the foot?
Yeah, so since this is the entrance wound, that's where it's entered. It's what we call a perforating wound. So it's entering through the sole of the foot, the left heel, and it is going through the soft tissue and coming out the back of the heel region of the Achilles tendon region.
Now, Dr. Mathis, you also mentioned that the foot is flat and it has tougher skin, is that right?
The sole of the foot, yes.
Would a person wearing a shoe, would that move the path of the bullet when it enters the person's foot?
Move the path of the bullet. So sometimes when you're wearing clothing or shoes, it can change the appearance of the entrance wound. It can add irregularity to it. It can also help us to confirm what we're seeing. So if you're looking at this or you're less experienced and you don't have a lot of experience looking at plantar wounds on the bottom of the foot, you can look at the clothing and you can, or the shoe, and you can interpret the directionality from the shoe or the clothing itself.
And what is this photo here?
That's a close-up of the exit wound on the back of the heel on the Achilles tendon region.
I'm sorry, it's an Achilles.
Achilles tendon region, the back of the heel.
And how do we know that's the exit wound?
It has all the features of an exit wound. So you can see the skin kind of fits back together with like a puzzle piece. If I push the edges together, it has an irregular linear. It's kind of linear, but it's irregular. That makes the features of an exit wound.
And what about this photo?
That is a close-up of the entrance wound on the bottom of the foot.
And how do we know that?
Because of the way it looks. So, like I said, normally an entrance wound is going to be round, but because of where the location is on the sole of the foot and the nature of the skin down there, entrance wounds on plantar surface are kind of look linear. The bullet just kind of separates the tissue, comes in, and the tissue collapses behind it.
Now I want to go back to you mentioned shoes, and that can change the shape or irregularity of a wound. Was the victim in this case wearing shoes, do you know?
Yes,
Did you receive those shoes?
I did.
What kind of shoes were they?
They're like a boot, casual boot.
Judge, I now move into evidence what has been previously marked as states 1X. By stipulation of the parties, Judge.
State exhibit 1X marked for identification now becomes state exhibit 21.
Permission to publish, Judge?
Yes.
Dr. Mathis, are these the shoes that you received from the victim, that were recovered from the victim's body?
Yes. They came with them.
And what are we looking at here with the white, where the white stick is pointing?
So there is a hole, next to the white stick. This is the outer edge of the left heel region of the shoe. And then below it, we have, red discoloration, which looks like blood to me. This is just a further out, photograph, so you can see the entire shoe.
What's interesting about this picture, Dr. Mathis?
So this is the back of the shoe, and if you recall the wound I kept referring to as on the Achilles tendon on the back of the foot, this correlates with it. This is where it came out from. So it came out of the skin, and then it came out of the shoe, creating this irregular defect here.
So that's where the exit wound came out of.
Yes.
And where was this, what part, is this the entrance or exit wound entry?
This is the entrance wound. You can see the fibers of the fabric or leather are pointing inward, and it's creating a defect. So that's consistent with entrance wound from clothing.
Now, you also mentioned that in this case, the victim had a wound to the left foot and a wound to the right thigh.
That's correct.
I want to talk about the wound to the right thigh. Judge, I now move into evidence what has been previously marked as 1Y by stipulation of the parties.
State exhibit 1Y marked for identification now becomes state exhibit 22, Judge.
Now, Dr. Mathis, is this the wound on the right thigh?
Yes. So what you're looking at here is the victim lying on his belly on our autopsy table. So you're looking at the back of his lower extremities, the back of his leg. His buttock would be here, right above where the picture cuts off.
And is the wound to the right thigh, did it have both an entrance and exit wound?
It has both an entrance and an exit.
And this wound is the entrance?
Is the entrance.
How do we know that for the right thigh?
Because of the way it looks. Sorry. Because of the way it looks. We interpret gunshot wounds, entrance, exit based on their morphology, the way they look. And this one, you can even see from this view, better closer up, but even from this view, it's nice and it has a round this punched out appearance to it.
Now, what are we looking at now?
Now, this you're looking, he's lying on his back now. And up here above, that would be the groin region above, and we're looking at from the top of the thighs down. And within the tattoo, there is a gunshot wound there.
Is this a better view of the front of the victim's thigh?
Yes.
And what exit wound is that?
That is the exit wound. That's on the front of the thigh. That's the exit wound. Same thing, just a different orientation.
What about this picture?
So now we're back on the back of the thigh. This is an entrance wound. You can see it has a punched out appearance. You can see the yellow in the middle, that's the fat, the soft tissue underneath the skin. So that's missing, that's the Joe Grancho. You can see it's got like this oval, it can be round, it can be oval, it can be elliptical, depending on the angle that they go in. Around abrasion, some scraping of the tissue around the edge of the wound. These are all features of an entrance wound.
Now, Dr. Mathis, for his right side, were you able to determine the path the bullet was taking?
Yes, so this is the entrance wound, it's on the back of the thigh, so it's going from back to front.
Is the way that the bullet entered through the back of his right thigh consistent with the victim facing his back to the person who shot him?
The back of the victim needs to be facing the barrel of the gun.
So yes,
Yes.
would it be consistent if you were facing the person who shot him?
No, because the barrel of the gun has to be pointing toward the back of the thigh.
Now, Judge, I now move into evidence what has been previously marked as stage 1Z by stipulation of the parties.
Stay Exhibit 1Z, marked identification, now becomes Stay Exhibit 23, Judge.
Judge, permission to publish?
Yes.
Now, Dr. Mathis, what are we looking at here?
We're looking at the exhibit line plot on his back on the autopsy table, and I took hospice probes and ran them through, placed them through the pathways of the two gunshot wounds.
So this is the wound to the foot.
Correct. And now it kind of makes more sense when you saw the shoe and how it looked on him. Harder to appreciate when addressing the whole stuff with the probe. It makes it easier to visualize.
Now, Dr. Mathis, I want to take everything together, what you said. We spoke about the left foot, the path of the bullet. We spoke about the right thigh and the path of that. Judge, I now move into evidence what has been previously marked as 1K by stipulation of the parties.
Stay Exhibit 1K, marked identification, now becomes Stay Exhibit 24, Judge.
Judge, permission for
Yes.
the witness and myself to stand over here? Now, Dr. Mathis, can you explain to the jury what this diagram is indicating?
Sure, so this diagram here in the middle is the notes I take during the autopsy. We call it a body diagram sheet, and that's where I'm marking down his hair color, our tattoos, and then I noted where the wounds were, what their size is.
And how did the bullet first enter the body?
How did the bullet first enter the body? So he has an entrance wound on the left foot. That's coming out the back of the left heel region, and he has an entrance wound on the right thigh in the back that's coming out the front of the right thigh.
How is it possible that the way the bullet entered, how is it possible with that angle? How would the victim have had to have been standing for the bullet to enter the way it did?
From the bottom of the foot?
Yes.
So that's bottom of the foot. So to get an entrance wound on the bottom of the foot, the gun has to be under the foot. So if the foot is on the ground, it has to be, I guess, on the upper floor and coming through the ceiling, or the foot has to be in the air in order for it to get go in. So since that scenario doesn't really make sense, the left foot needs to be up in the air in order for it to be facing the barrel of the gun.
Could that be consistent with if the victim was going to try to run, that his foot was up? Would that be consistent?
Yes.
Now, once the bullet enters the left foot and exit, where does it go?
So then it comes out the back of the left foot.
And then where does it go?
Then it's going to continue in the same trajectory along a straight line until it hits something else,
And then can you just,
or just drops to the ground.
and then for the thigh, can you talk about how when it left the foot and enters the thigh, how that's possible?
So yes, so the same bullet can cause both wounds. It can go from the outer edge of the left foot, the left heel, to the back of the left heel region. And then the foot's up in the air, it can go into the back of the right thigh and out the front. So it goes through the foot and then through the back of the thigh and out the front.
And you're indicating that the record reflects that the witness had his left foot up and his front was facing the judge.
Right, so your right leg has to be forward, your left foot is up, and you could create that pathway.
And your back has to be facing the person who's shooting.
Yes, the back of the foot, yes, but that's where it has to come inside.
Now, Dr. Mathis, looking at the wound tracks, is it possible that a single projectile did this?
Yes, in the way that I just described.
And okay, we're good. We're good with this. Now I want to talk about the internal examination we did. Did you perform an internal examination?
I did.
Okay. And what internal damage did you observe as a result of the gunshot wounds?
So inside the body, his organs, those were all good. I had to do a special dissection on his right thigh to document the injuries going on within the soft tissue. And he had a lot of blood and bleeding in the muscles of his right thigh, in the region of that gunshot wound. And he had holes in his femoral artery and femoral vein.
You mentioned he had holes in his femoral artery and vein. Did the bullet strike or sever those major arteries?
Yes, the bullet struck those arteries.
And now, Dr. Mathis, based on your expertise and experience, would an injury to the femoral artery, such as a gunshot wound, cause rapid or severe blood loss to someone?
It will cause severe blood loss. The blood comes from the heart, is pumping. The femoral artery comes off after the aorta branches into the iliac. The femoral artery is one of the branches that comes off the iliac artery. So, and it supplies blood flow to the rest of the leg. So it's a very important blood vessel, and it will bleed, and you will lose a lot of blood from it.
And are you able to estimate about how quickly a person can lose consciousness or die from such bleeding?
So when we're talking about a femoral artery, it will take longer than, say, if you have a hole in your aorta or a hole in your lung or a hole in your heart. It's a bit downstream. So it can take several minutes, and then there are things that can mitigate it. If you're applying pressure, or if for some reason the muscle tissue is compressed around the wound, anything that's going to apply pressure to that area can slow down the bleeding.
Now, you also mentioned that several things can mitigate that. Let's say, Dr. Mathis, that there was no mitigation. There was no covering or trying to prevent the blood loss. If pressure is not being applied correctly, how fast would the victim take to die from this type of wound?
It can still take several minutes.
And is, based on your knowledge, was that consistent with what happened to the victim in this case?
I don't think there was a long survivability period, but I wasn't aware of that at the time of the autopsy. For us, it didn't matter, but it will take. It's not going to be that you're shot and you suddenly collapse. There is a time period where it will take for the blood to come out of the body, reduce the blood volume so that the heart no longer has enough blood to pump up to the brain to give it the oxygen it needs.
And how is it that the blood is going to come out the body? Is it going to come out rapidly? Is it going to
Ah, thank you. Dang it. Sorry about that. When I reset the live feed, it muted me. Okay, so let me do some explaining. I got some explaining to do about how she got pregnant. Okay, you're in a jail system. They have air conditioning vents. Obviously, theirs are more along the ground floor from what I remember seeing in a photo. But it doesn't matter where, they have AC vents. And inmates talk through the vents, or they toilet talk, which means they use their mattress and they suck out or put a big air pocket in the toilet. They flush it, and they get rid of all the fluid in their toilet trap, and they talk. But this particular incident was through an air conditioning vent. So she's talking to some guys through the vents, and she wants to get pregnant. So what does she do? She coerces one of the guys to send his love potion, his love juice in something, and what I don't know, through the AC vent. And the way they do this is they take string or threads or pieces of their linen or clothing that they can make a chain with, and they fish it through the air conditioning vent. And the other inmates, if it's in front of their vent, they pass it along. It's called fishing. And finally, it gets to the guy. The guy connects to the end of that string his love potion, his love juice, and then she pulls it back through. And then she inseminates herself. Hence, pregnancy. It is not a high chance of success rate, but with her, it worked. I wonder how many times she did this. Interesting. Very interesting way of doing it, but it happens. And she did continue with the pregnancy and gave birth, and the baby is now living with a member of her family. Okay, y'all, we back at it. Just had to give an explanation.
Yes, so you have both an arterial bleed and a venous bleed. So the vein is returning blood from the bottom of the foot. That's a low pressure system. It will ooze, or it'll accumulate in the muscular tissue. The artery, on the other hand, each time the heart pumps, blood is going to be spurting out of that artery. If that artery has a clear path out the hole, the exit hole, then you will get blood coming out of that hole, and that's where you see, like in the movies, the arterial spread. If there's not a clear pathway from the hole in the artery because it's blocked by muscle or tissue, then it'll continue to spurt, but it'll come out. It may not come out as a spurt out of the hole when it leaks. It may accumulate in the tissues and then dribble out.
Now I want to talk about toxicology. Was a toxicology test performed on the victim?
Yes.
And what were the results of that test, Dr. Mathis?
I'm just referencing the toxicology report. So in him was detected ethanol, which is beverage alcohol like you'd find in vodka or tequila. He had cocaine. He had metabolites of cocaine, the breakdown products, and he had THC, which is the active ingredient in marijuana.
And how much cocaine was detected in his blood?
He had, according to the report, 0.274 milligrams per liter.
Would you say that's a lot of cocaine, Dr. Mathis, a little bit of cocaine?
It's a healthy amount of cocaine.
And now, based on your experience, Dr. Mathis, what is it that cocaine does to the body or blood?
So cocaine is a stimulant. So it causes your heart to increase. It will increase your blood pressure. It narrows the blood vessels. That's how it increases the blood pressure. And like I said, it makes your heart race. It keeps you, it's an upper.
Based on your exam, Dr. Mathis, did the cocaine contribute to the victim's death?
No.
Why do you say that?
Because he's got a gunshot wound that went through his femoral artery and he's bleeding out, dying from hemorrhagic shock.
Did any of the substances that he had in his blood system contribute to his death?
No.
So I want to talk about the cause and manner of death. Based on your examination, were you able to determine the cause of death?
Yes.
What was it?
That was the gunshot wound of the right thigh.
So how long would it have been, Dr. Mathis, based on your training and experience, it would take someone to bleed out or die from that injury?
Like you said, it can take several minutes.
Were you able to determine the manner of death?
Yes,
What was the manner of death?
homicide.
Moment to confer, Judge.
Yeah. It's pretty interesting how some of this stuff happens in prisons. I'll be honest. I think I might want to even consider writing a thesis on that for my next level class.
Dr. Mathis, I want to go back to the external injuries you observed.
Yes,
If the victim was running away, I'm doing this.
Yes.
He's running with his left foot up. If he's doing this, is that consistent with what the shot that you observed, the wounds you observed on his body?
if he's in a running position, yes, the left foot has to be in the air and the right foot has to be forward.
So if he's running away, that's consistent.
Yes,
Okay. Now, I want to talk about ricocheting. Is it possible that the person who shot the victim shot into the ground and that it went through his left foot and out through his left thigh? Is that possible what you saw here?
I find that extremely unlikely. So when you have a ricochet, when you first fire the weapon, it has all the energy in it. That's why it can make characteristic appearances of gunshot wounds. In this case, the bullet not only went through the shoe, the boot twice, went in and went out, went through the foot, went through the thigh, in and came out. That takes a lot of energy. So ricochet is not going to be able to do that, and two, the wound on the back of the thigh would have had to have, if it managed to even get out of the left shoe, which I find very unlikely, that you would have a ricochet that actually can go through the shoe, go through the foot, come out the shoe. When it hits that right thigh, it's not going to have that nice oval wound that you saw. So I can't see this being a ricochet, no.
Now I want to talk about, again, the arteries that were damaged. Is a time delay in the time from the time that the victim was shot, if there was a time delay in calling 911 or having assistance, would that also likely contribute to his death?
So when you have a wound like that, those are devastating injuries that require immediate medical attention. The wound needs to the blood flow needs to be stopped. Basically, you need to put a tourniquet tight around the wound to stop the blood flow into the leg. And then, of course, you're on a clock because the leg's not getting the nutrients it needs, and you would have to amputate. But a femoral artery wound is a devastating injury. So yes, if you don't receive medical attention, you will die quicker.
So if there was a delay in calling 911 or getting assistance or putting a tourniquet on the victim, that's going to speed up the time he dies.
Yes,
Now I want to talk about the drugs in his system.
yes,
I know you mentioned earlier that those didn't contribute to his death.
correct.
Would you say, doctor, based on your training and experience, that the drugs slowed down the amount of time he died, that took him to die?
So there are some people who would say, okay, cocaine is a stimulant. So a lot of times when people get shot, they get an adrenaline rush. They may not even feel that they were shot till they look down and they see that they are bleeding. That adrenaline rush, adrenaline is also a stimulant, also causes the heart to beat faster and the blood vessels to constrict, which will increase your pressure. So cocaine as a stimulant could, in fact, actually help the situation because It's causing the blood vessels to be more constricted than they ordinarily would be, which is going to increase his blood pressure, which could theoretically increase his survivability period. But you still have a big hole in your femoral artery, so.
Thank you. Moment to confer, Judge. No further questions, Judge.
Morning, Doctor.
Good morning.
Not to state the obvious, but just to be absolutely clear. We've got 2 entrance wounds and 2 exit wounds on this gentleman,
Correct.
but this is all from 1 bullet, 1 shot, correct?
It's consistent with that. So if the circumstances indicate that there's 1 bullet, 1 firing, this is the most reasonable way it happened.
There's nothing that you're aware of that would suggest to you or indicate to you that there was more than 1 shot in this particular instance, correct?
Right. Look, I have 2 through and through wounds. So could they have occurred through 2 separate shots? If that's what the scene and the circumstances supported, I'm not going to be able to refute you on that. But my understanding is if there's 1 shot, that there's 1 shot, 1 bullet fired, this is how it would occur.
So what we're talking about here is a bullet that went in through this man's heel, came out of another part of his foot, and then went into his leg and came out of another part of his leg. Is that correct?
Yes, the right thigh and then out the front of the right thigh.
How many autopsies have you done?
Probably is 2000.
As best you can recollect, have you ever observed or do you have any knowledge of a single gunshot wound taking that particular trajectory?
I've had single gunshot wounds go through both legs. I've had them go through the arm and the chest, through a foot and then the leg, a foot and then the opposite thigh. One does not come to mind.
You would agree that this is a highly unusual trajectory for 1 bullet, correct?
I wouldn't say unusual. It makes sense. Yeah, I wouldn't say it's unusual. I would say it's not a pathway we encounter every day.
Okay. Now, when someone has an injury like this man had and aid is being rendered, am I correct that one of the first things you want to do is put a tourniquet on the person's leg?
Yes, you want to mitigate the blood loss. So that's going to be pressure, tourniquet, stop the blood flow from stop the blood flow above the level of the injury.
And that was done in this case, correct? That was administered?
There, he came in with a tourniquet on, so at some point one was placed on him.
Now, the amount of cocaine that this man had in his system, you testified earlier that it's not part of the cause of death, correct?
That's correct.
However, that amount, it is a potentially lethal amount, is it not?
Any amount of cocaine is technically potentially lethal.
But this amount, this isn't just any amount, this is
a goodly amount, yes.
Okay.
A goodly amount. It's not just a small amount. It's consistent with recreational use. It's not like somebody you see like a body packer or anything like that. But it's not just, sometimes we'll see people, regular cocaine users, and they're probably coming down and they have just a tiny little bit of cocaine coming along for the ride. He's using, yes.
So this is, we're in Miami, there's cocaine in Miami. But this is not just, like you said, not a little bit, this is a rather significant amount of cocaine that this man took, right?
This is recreational use of cocaine. It's not, like I said, it's not the little bit we see with somebody that's coming down. They're in the active phase of using.
Now, am I correct that that when somebody's using cocaine and they use other substances, particularly alcohol, that increases the toxicity of cocaine, correct?
It can, yes.
Okay. That combination, cocaine and alcohol, it produces a metabolite called coke-ethylene, correct?
That's correct.
And in your autopsy, you tested for coke-ethylene, correct?
Yes,
And he had 0.150 milligrams per liter of coke-ethylene in his blood, correct?
yes,
And when looking at the alcohol, he had 0.108 blood alcohol level, is that correct?
yes, 0.108 in the ocular fluid, 0.107 in the blood.
So if he had been operating a motor vehicle, he would have been driving under the influence,
Correct.
because the legal limit in this state is 0.08.
That's correct.
Right, so he had this very high amount of cocaine in his blood, along with this amount of alcohol in his blood, which would have been enough to trigger a DUI had he been driving.
Objection, prejudice, calls for legal conclusion.
Yes.
And he also smoked some weed too, correct?
At some point, he used marijuana. I cannot tell you how he used it, and I cannot tell you when.
Now, doctor, you were asked about whether or not some of these substances delay or could affect how long it takes somebody to bleed out. Can you explain that a little bit more, please?
Yes, so just as I explained before, cocaine is a stimulant, and it, just like the adrenaline rush that will occur when somebody gets an injury, it will increase your blood pressure through constricting your arteries, and it will cause your heart to beat faster.
Now, when someone's shot, do you expect them to necessarily start bleeding out right away, or does it take a few moments before blood starts coming out of somebody's body? I mean, usually.
When they're shot, they'll start bleeding right away. You may not see it on the outside of the body, but trust me, they're bleeding somewhere. So they get shot in the chest. They are bleeding into whatever space is around them. So in the chest, you have a lot of space for the lungs to expand. They're going to bleed into the chest wall. You get shot in the leg, you're going to be bleeding into the muscles, the soft tissues there. Only when the body is in a position where the hole that leads to the outside is lined up with where the blood is, will it come out. So oftentimes we'll get to a scene of murder. They've got a bunch of holes in their chest. There's not really that much blood out. When we start to move the body and we've tipped it, then blood will start coming out of the holes.
So it might take a little bit of time before you start seeing blood dripping and landing on the floor from somebody who's been shot.
Correct. It just depends how the hole lines up with where the blood is accumulating.
So if somebody's walking or running or in any type of movement, they get shot, but they're moving, you might not start to see a blood trail until they've taken a few steps, correct?
Correct.
Now, so you were asked about whether certain things are consistent with your findings. I want to give you a scenario, and you can tell me if it's consistent with
Sure.
what you found. Okay?
Yep.
So let's assume that we have somebody who is very high on cocaine and alcohol and THC. And that person is running around stalking somebody outside their home. Okay?
Yes.
That person is told to leave. They don't leave. At some point, there's a confrontation, and the person is asked again to leave. The person screams and says, "I want to die, I'm ready to die." And then they run towards a house with the intention of breaking into that house, which they have no right to be in. And a person fires a shot in that person's general direction for the sole purpose of getting that person to leave, which they have thus far refused to leave. Are you with me so far?
Yes.
Objection, evading the province of the jury. He hasn't finished asking his questions. Let me hear the rest of the question.
Fires a gunshot for the purpose of getting that person to leave, which that person has refused to leave up until that point. Once that gunshot is fired, that person starts to leave. You would not expect that person to immediately bleed onto the ground and show where that person was standing at the time he was shot. Is that correct?
He could be bleeding at that time, or he could start to bleed later. I can't tell you one way or the other.
So if blood droplets are found, say, 15 steps away from a front door, give or take, 15 steps away from that front door, would that, or could that be consistent with somebody running away from that front door after being shot?
So you have the front there shot. Are you telling me where the person was shot, or?
So the person's running towards the front door with the intent of breaking into this house, which they.
Objection, legal conclusion. Evading the province of the jury. Overruled. If you can answer the hypothetical, you'll do so. You can't.
Correct.
Go ahead, I didn't hear the end.
The person was told, leave. I don't want you here. You're not welcome here. Get out.
Okay.
I'm not getting out. You're going to have to kill me. Runs towards the door. Shot is fired for the purpose of getting that person to leave. Shot hits.
Sidebar. Good morning, 80 Music Man. Good morning, everybody. I hope you guys are wonderful today. Working on a paper that just dropped that I have to get done by 3. Let me see how long we are in this break. We're not very long. So let's get back into court.
All.
Okay.
Just ask it again.
Yes, please.
This man is whacked out of his mind on cocaine, alcohol, marijuana.
Hold on. Jason, will you do me a favor? Are you in our Discord? If so, can you put the information on breaking news in the members file under breaking news? That way I can click on things and bring up the information. Would appreciate it. You were on top of it. You need to be our breaking news mod. But please go into our Discord and drop that information. Thank you.
He's been asked to leave. He refuses to. He's in a heightened state, very aggressive, screams, I'm ready to die. I want to die. It's not leaving. It's not welcome.
Okay, I don't listen to
In the house.
Sorry.
Doesn't have permission to be in the house. Has no license or has no authority, no right to be in that house. He's going to that house, running towards that door, shots fired for the purpose of getting him to leave, which he has already refused multiple times to do so. Shot goes into his body. Once that happens, he's not going to the house anymore. He's running away. He takes about 15 steps running away from the house, give or take 15 steps before blood starts to drip out and hit the ground. Is that consistent with what you've seen here, with the wounds in this case? Could that have happened?
So you're asking could he have been shot while still inside the house before leaving?
He didn't get inside the house. He
Okay.
was running towards the front door, is shot, and now the shot is what caused him to abandon his attempt to go into that house.
Okay.
So now he's running away from the house,
Okay.
and he makes it about 15 steps, give or take, 15 steps away from the house before you start seeing a trail of blood on the ground.
Okay.
Is that consistent with this? Does that make sense?
It can happen that way, yes.
Okay.
Like I said, he could start bleeding immediately or it could take several steps to begin to start bleeding.
So the scenario that I just laid out for you, this is not a wildly impossible or unlikely or ridiculous scenario. This is consistent with what you've seen, correct?
Yeah, it's what it.
People are missing following this explosion. Multiple people have been taken to the hospital. That's according to the Humphreys County Emergency Management Agency. No deaths confirmed by that agency, but sources are telling us that at least one person is dead. That source is on the scene and familiar with the situation unfolding. If you have family members who work at this plant, and by the way, we should mention the name of this factory is Accurate Energetic Systems, which, so if you're just joining us, we do have breaking news. This is out of Hickman County, where an explosives plant, there's been an explosion there, and we've learned that 19 people are missing because of this. We have confirmed with one source that one person is possibly dead, but the Humphreys County Emergency Management Agency, which is sharing the latest update about the number of missing, has not confirmed any deaths at this hour. Now, we did talk with multiple hospitals in the area. Ascension St. Thomas is one hospital that we've just been able to get a hold of. They say that they're aware of the situation. They have no patients yet, but they're going to keep us updated about whether or not that changes. Our team has reached out to Vanderbilt University Medical Center as well. Of course, we know that they have a trauma center there, and that's where perhaps patients could potentially be going. So if you live in this area, you already know that there are road blockages in effect right now. If you don't and you were planning on passing through, we should let you know that there is a major thoroughfare through that area that's currently closed. State Route 230, also known as Tanyard Branch Road. This is north of I-40, again, in the Bucksnort area. We have some video from Ring cameras that show the tremors that took place when this explosion happened, and we're going to show that to you now. And you can kind of hear in the distance some of that rumbling. You saw ever so slightly the camera shaking there right at the beginning. We're hearing reports from people all over the mid-state who felt these tremors. And then there again, you can see the camera shaking as that explosion happens in the distance. So people in Murray County, Williamson County, Decatur County, Hickman County, and Lewis County all reporting that they felt this shaking coming from an explosion at the Accurate Energetics Systems plant near Bucksnort. A little background on that plant for you. Their website says that they were established in 1980. They say they're dedicated to the development, manufacture, handling, and storage of high-quality energetic products used in both defense and commercial markets. Back in 2020, the Tennessee Department of Economic and Community Development announced an expansion at AES at the McEwen site there at Hickman and Humphreys counties. It's about a 1,300-acre site. That expansion was planned to bring about 80 jobs. And the state in that announcement said that this site is where AES operates a full lab and a test range. We have not been able to get in touch with AES at this point. As you can imagine, things are pretty chaotic, as 19 people are confirmed missing, according to the Humphreys County Emergency Management Agency. So as you can imagine, a lot of work happening right now amongst first responders to try to find those 19 missing people who are unaccounted for.
Is there any chance at all, baby, that you complimented Hugh Grant's wife, Anna, on her movie Barbie? Said, I'm just Ken too. The most fun thing about having Travis out on tour is just like, he would go to the tents and like, give me the tea afterward. Yeah. We'd do the debrief afterward in the car.
Oh, come on. Seriously? Stop. That was a copyright strike. Damn it.
feels like is there any chance at all,
It should stop.
baby, that you complimented Hugh Grant's wife, Anna?
Stop! Damn it. Sorry, my monkey was screaming. I needed to feed her, and it was the only way to shut her up. So our prayers and hearts go out to the families right now. We are waiting to see. We'll be monitoring this today. But yeah, y'all, that's horrible. Absolutely horrible. 45 minutes ago, 19 are still missing, one probably most likely deceased. But at this point, we don't have any other new information. So, mods, if y'all will monitor this. Ooh. Getting absolutely ridiculous with these damn commercials, y'all. You really are. Okay, just here's a flyover video over what has happened. I don't think there's any sound on this because I don't have any sound. This is one big explosion. Yes, our hearts and prayers are with the families and the employees and everybody involved. Oh, Lord, y'all. This is horrible. All right. I didn't get to feed the monkers because my son I'll have him go feed the monkers. I have her food right here, though. She's getting protein, what I call bombs. It's hamburger, equal amounts of hamburger.
For every tear, triumph, and
Oh, I am so dang sick of this. So dang sick of these commercials. And see what ticks me off of these commercials? I get in trouble by them. So anyway, our hearts and thoughts, and we lost screenshot audio too. I don't know why we're losing audio. I don't understand what's going on. It's just what it is. I'm not going to be able to do any more videos for the day. Yeah, that's just really irritating. Irritating as hell. But anyway, we're back into trial. I do have my own captioning running, so I'm going to close off this captioning. Go to click down at the bottom, you'll see, or at the top, you'll see CC. Click on that. The captioning will be up. And then you can put your cursor on it and move it wherever you want on the screen.
It's one way it could happen. I can't tell you for sure that he didn't start bleeding for 15 steps. I also can't tell you for sure, oh, he would have started bleeding immediately.
And nobody knows for sure except for the people who would have been there, right?
Correct.
Thank you, Doctor.
Dr. Mathis, you were asked on cross-examination about if a tourniquet was placed on the victim, it would help slow down the bleeding.
If placed tight enough, yes.
You don't know when a tourniquet was placed on the victim in this case, do you?
No.
So if there was a delay in when the tourniquet was placed, would that slow down the bleeding or cause him not to die?
The delay in the tourniquet, he'll be bleeding the entire time until a tourniquet is put on, tightly. So anytime up until that tourniquet is put on, the pressure's not being applied, the wound's going to be bleeding. You may not be able to see it on the outside, but it'll be bleeding on the inside.
So if a person waits 10 minutes to call 911 and the officers then take some time to get there after, would that contribute to the victim's death as well?
Yes, yes.
Now you were asked about the blood coming out, and they're coming out of holes, and it may not bleed at that time, or it may. If a person is running away, would the blood start coming out?
It should, because now you're moving the leg, you're advancing it forward, you're causing manipulation, just like I told you. When we start flipping the body, the blood starts pouring out of the hole. So as you're moving, the blood should start, you should start leaving a blood trail.
You're also asked about hypotheticals, so I want to pose one to you. If a person goes outside, they're on the steps, they pick up a gun, they point it at the victim sees the gun, in fear for his life, turns around and runs away, and that person shoots. Is that consistent with what we have here today?
Can you repeat your question?
Yes. A person picks up a gun, aims it at the victim in fear for his life, turns around, runs away, and the person shoots the victim. Is that consistent with what we have here today?
Yes, it could happen that way.
Hypothetical. I bet because he's an expert, he can testify to it.
Thank you, Judge. No further questions.
Judge, we agree, cross on that question.
Yeah.
Judge, I would ask that we go sidebar.
I haven't heard anything yet, so not at this time. Go ahead.
You were asked about a victim who's in fear for his life, running away, right?
Yes.
That's the question she just asked. Would you expect somebody who's in fear of their life to say, "I'm ready to die"?
Objection, Judge. Speculation, maybe province of the jury.
Can you answer that question?
I can't.
Okay.
A little dramatic, may we?
Thank you.
I can't. All right, thank you.
But the shit's out of the horse, that's for sure. Someone a little nervous, are we? Pacing in our chair. Do y'all hear the monkey at all? Because she's been obnoxiously loud this morning. I mean, she has been so obnoxiously loud this morning. It hadn't even been entertaining or fun. Let me see. It looks like the jury is leaving. They are on break. We're going to come back.
The cell phone extractions that I've taken, specifically by a company called Cellbrite, which is the primary, one of the primary softwares that are utilized in conducting these extractions. And with those trainings, they're broken up into a few different areas, but primarily in the actual extracting or downloading the data from a cell phone or an electronic device, and then processing that data that's downloaded as well.
Okay. And generally speaking, how do cases get assigned?
Are you asking in the context of myself or in just a case in
cell phone
general?
extraction, I'm sorry.
So in the case of, or in the circumstance of a cell phone extraction, it could be as simple as the detective, whoever it may be, picking up the phone and calling and just informing us of whatever assistance they may need.
Okay. And generally speaking, is this, let's say a detective calls you up and says, "Hey, Sergeant, I want you to extract the phone," or is it randomly assigned?
So within my unit specifically, it's myself and a detective, one other detective that I supervise that has the training and the equipment to conduct that. So within my unit, the phone call would ultimately end with either myself or that other detective.
Now, were you involved in a case PD 220625210513?
Yes, I was.
How did you get involved in that case?
So in that case, I was provided.
Are y'all able to hear this feed at all? What's going on? Can you hear me? June, I need a sound check, please. You can hear me, June? Okay. You hear the video.
With two cellular telephones to attempt to conduct forensic extractions.
Who provided those to you?
The relevant telephone is from a detective, Daniel Morales.
Now, you said relevant phone. What are you talking about there?
So of the two phones that were provided, one of the phones I was able to obtain a full extraction from due to the password being provided. The other phone was an iPhone that was password protected and the password was not known. And due to the state of the phone, an extraction was not able to be conducted on that other device.
Now, I want to talk about that for a moment. Did you attempt to extract that cell phone?
Yes, I did.
Were you ever able to extract any data from that cell phone?
No.
Okay. Were you ever provided a password to that cell phone?
I was, but it was unsuccessful.
Now, when that detective got you the phone or gave you possession of that phone, was that with a warrant or did you just unlock it yourself?
No, it was the device with the accompanying property receipt as well as the search warrant.
Now, how do you identify a phone that you are going to extract?
Well, depending on how it's provided, but typically in an instance where a search warrant is provided, it would be whatever is identifying features are explained in the search warrant, and that then in conducting a physical review of the device to ensure that it's the correct device that accompanies the legal process.
Now, after you confirm that you have the correct phone, what do you do, if anything?
So typically you take that device and you just do a visual of it, ensure that it is that it's working, that it's powered on, and then from there take it to a specialized equipment and then begin the extraction of that device.
Okay. Can you explain to the members of the jury what a Faraday room or Faraday box is?
Yes. So pretty much think of it as a large room that any signal cannot get into. So if you were to take your phone inside, it would be completely shielded from any Wi-Fi, any cellular, or any sort of connection that could communicate with the phone. So it isolates it completely from any sort of outside signal.
Okay. And generally speaking, does data change on a phone?
It can, yes.
Okay. How does it change, or is there anything to stop it from changing?
So with any cell phone, there's always going to be things that change on the phone just by the way that phones work. There's always things happening in the background. There's always applications that are open, and there's always things that are continually evolving. That doesn't mean that the files themselves change, but there are additional files and additional logs and records that occur just with the phone being on.
Now, I know that we talked about this briefly, but once you plug a phone into a computer, what happens with that? Do you download the phone? How do you go about that? Is there a program?
Yes, so in this case, I utilized a piece of equipment manufactured by a company called Graykey. And with that, after unlocking the phone and connecting it to the equipment, it downloads a full extraction of the entire file contents within a phone.
Sorry.
So essentially, you can think of a phone as a library and the contents being the individual sections. So that equipment takes and it stores and copies all of the contents that are on that phone.
Once a phone is actually extracted, do you do anything to verify the data that was on the phone that you properly extracted it?
Yes. So upon all of the data being downloaded, there is a process that's called a generating of a hash. And a hash is pretty much consider a digital fingerprint that can be run or compared against any file. And if just one bit of information, the most minute thing changes, there's going to be a different value that's generated. So that's a way that once that extraction is complete, the state of the extraction and the data that was downloaded can be verified that it is the same and that is continuously the same and does not change.
Okay. Let's talk specifically about when you first extracted this phone. Did you do that and confirm that the data that was extracted was the same data that was on that phone?
So the hash initially is generated automatically in the process of extracting the phone. And then when I take that data and upload it to a second software, which actually interprets the data, the data, a hash is generated again and compared to the initial one, verifying that that it is in fact the same data and that what was utilized to generate a report is from the same contents.
Okay. And once that phone actually is extracted, what do you do with that data? Do you give to somebody? Do you keep it yourself?
Yes, so after uploading it into secondary software that actually takes that file from the phone and turns it into something that you can read, I generate a report and provide that over to the detective to review the contents.
And did you do that in this case?
Yes, I did.
Okay. Judge, permission to retrieve evidence and permission to publish? Thank you. Detective, I do not know if you can see how my screen here, because it's a little small, but can you tell us what we're actually looking at right here?
So this is what's going to be called a Cellbrite reader, and this is it's the end product, so to speak, of what the extraction and the data contained within the phone ultimately, how it ultimately appears.
Now, you mentioned a moment ago that there was a phone that was provided to you by Detective Danny Morales. Is that this data?
Yes, so the case number, there's going to be a case number there at the top left, and that's going to be the digital forensics unit case number that was assigned for the extraction of that specific device.
I want to show you a few specific points from this phone.
You need to step down.
Thank you, Judge.
So, Detective, yeah, if you actually, can you just tell us right here what the date and time that this, where it says created?
Hold on a second, if you need to reposition yourself, you can reposition yourself.
So for this particular file, June 25th, 2022, 3:06 a.m.
Okay, and we see that this video is how long?
6 minutes and 57 seconds.
And we
I'm
see,
sorry, I take you wrong. Is this in evidence?
yes,
Do you have to mark it?
it's already in evidence. It's been moved yesterday.
Oh, what number was it?
16.
16, okay, so remember folks, this is in evidence, so if you need to look at it in the future as you deliberate, it is accessible to you. Go ahead.
So we see how long is this video?
6 minutes and 57 seconds.
And if you tell me what the timestamp is right here.
It's at the 6 minute and 7 second mark.
And we see an individual right here. So at 6 minutes, 7 seconds after 3:06, can you generally tell us what time that is?
Right about 3:13 a.m.
So this video would have been created, or this portion of this video would have been about 3:12, 3:13, you said?
Yes.
Let me just publish this.
Dude, y'all need to turn the volume down before you turn the TV on. How long have you been doing this? How many days? God almighty.
And we see a vehicle and 2 individuals?
Yes.
Okay, and this would have been earlier in that evening?
Yes, the previous day.
Let me publish this video now.
Dude. I can't.
And so again, that 3:06 video that we saw, this was earlier in that evening as well?
I refuse to. I don't care. I refuse to. Can't do it. You know what that feels like? How does that feel on your ears? On my ears, it feels like somebody going, Jesus. I mean, I understand you need to show it, but have some freaking control here. Or hello, sound man, do your job. This is killing our ears. Oh. Really? I mean, it's hideous.
So I'm gonna go back and actually look at a few more things here. Let me open up. Detective, I want to bring your attention to these two items under 13 and 14. Can you tell us number 14 what it says?
It's gonna be an outgoing call, Marcus, or dial, this is 9911.
And can you tell us the date and timestamp there?
June 25th, 2022, 3:21, and a couple seconds, AM in the morning.
And right above it, number 13, can you tell us what that call is?
So same, just 1 9 less, and it's also gonna be an outgoing call.
So it's fair to say that's a call to 911 emergency services.
Yes.
And the date and time on that?
June 25th, 2022, 3:21 AM.
The first video that we saw, that first timestamp was at 3:06 a.m. and it was 6 minutes long, give or take.
Yes.
And you testified earlier that that means with that timestamp of when we saw an individual walking in front, that was about 3:11, 3:12, 13. Is that correct?
Yes.
And obviously 3:21 is a 10-minute delay.
About.
Let me move on here, and I'm going to scroll down to the bottom of this video where it says social media. Can you just tell the members of the jury what these two things are right here?
So the first one would be Facebook and the usage of just the Facebook application, and then we'll TikTok, another social media application.
Sorry, Facebook and TikTok are social media accounts?
Yes.
Let me ask you about Instagram. Instagram also a social media account?
Yes, Instagram actually is currently owned by Facebook.
Okay, if you could tell us what we're looking at right here.
So this is going to be within the user accounts section of the phone extraction, where it's going to categorize, just generally speaking, any accounts that were on the phone. Not limited just to social media, but any email accounts, social media accounts, things like that are going to be categorized in this section. And this one specifically is a Instagram account that had been utilized on this cell phone.
Okay, and this, excuse me, this Instagram account would have been utilized on this phone?
Yes.
Meaning that this is this person's Instagram account?
I'm sorry, ask it again?
This Instagram account would be belonging to this phone or have been accessed by this phone?
Yes, this is indicative of that account having been utilized on that specific device.
And if you could just publish the members of the jury that right there.
Daisy Link.
Great, I have no further questions, Your Honor.
See if there's any process on it.
No, Your Honor, thank you.
Your excuse. Thank you. All right, folks, we'll go ahead and take our lunch break now. Let's come back so that we're ready to start right at 2 o'clock. So I'm giving you an hour and 15 minutes to plan to eat and also travel time. There should be less foot traffic in the building today. We don't have more reserves obviously on Fridays. These are my instructions about ignoring the charges as well as the sleep, you bump into them in the hallways, etc. Please don't talk about this case among yourselves, and please do not do any research about this case. If you become aware of any violations of the orders that I remind everyone every day, please bring it to my attention as well as my daily notes. He will take your notes, just like he's been doing all week, and he'll tell you where to meet him so that we can reconvene and start talking at 2 o'clock.
Third floor, please.
Okay, so we are going, and they show the feet of the jurors. You got one male, one female. That's a male. That's a female. Ooh, nicely dressed female. Those pants, pink pants with leopard shoes. You got a black woman. I got another woman, but don't know tennis shoes and black pants. I'm like, why are you showing their feet? I find it interesting that they're showing their feet.
Well, so this is the phone. What we can do is Mr. Tomas and I can sit down and agree on certain items, put into a demonstrative to send back to the jury. Because obviously there are stuff on this phone that cannot go back. It will obviously be depending on cross-examination and rebuttal, because there are text messages I can publish to the jury from this phone on cross and potentially rebuttal as well. But we can sit down and.
Okay, cross that bridge. Get there, if you guys don't do that, if that's not possible. They just ask to see certain items and then we just publish.
Yeah.
In open court.
Yeah.
All right. Should we come back in about 45 minutes? I'll give everyone a 45-minute lunch break. We'll come back at 1:30 and then we'll go over the statement. Does that work?
We just received it. If you could let me know.
Yes, Your Honor, it's an hour, 32 minutes, and 26 seconds.
So we should be able to rest of that.
All right, fair enough. I just want to make sure that you show the areas that are agreed upon for the redactions, the areas that are not agreed upon for the redactions at 1:30 when we come back. I can give you my ruling.
Sure.
But it seems like it's 90–95% of the parties are agreed, right?
Yes, Your Honor.
And,
I actually don't think there are any disagreements. I'm sorry.
we're not going to be using any, written transcripts for them to follow along.
No, unfortunately, as I mentioned to the court in an email yesterday, Mr. Tomas, the vendor, for whatever reason, did not provide a full transcript. The only thing that we were able to do was generate an AI transcript.
Look, it is what it is. I think at the end of the day, unless it's an agreed upon official transcript, they always rely on the evidence that they're using, right?
Yes.
That's the default instruction. So, okay. Mr. Tomas, unless you agree that this AI generated one can be used as demonstrative, they shall rely on their memory. I'm sorry, or what they, if you want, we can show them the AI generated, transcripts. If you agree, it can be used as an aid. I'll let you tell me that at 1:30.
Your Honor, one of the issues I'd like to raise with that is that that doesn't have the appropriate redactions to match up
Oh, I
with the
see.
video.
All right, then forget that idea. All right, so we'll just look at the.
Yeah, I mean, bringing in a AI generated transcript and telling them it's an aid, that's not going to work because you can't control how they accept that. Some will accept evidence, some will consider it an aid, some won't accept it at all. I mean, you're just opening a big freaking can of legal worm.
So we'll come back at 1:30, okay? Actually, why don't we do, come back at 1:35, so everyone can have the full 45 minutes.
Okay, so we're going to hop on over here and see where we are in the Bianca Ellis trial. Get this out.
Dr. Megan Testa.
Back for Megan.
So when she is giving you these unusual things or saying these unusual things, do you question her about those things? And how they apply or don't apply?
If I will redirect. So if I'm asking her, where she was born and she starts to talk about Jesus or the FBI, I will redirect. I will ask her again where she was born. Sometimes you can get an individual on track in conversation in that way. Sometimes, if the psychosis is heavy, they will continue to talk about those things. During the competency part, I will ask how that's related to the charges. Sometimes you can pull people back. Sometimes they will continue on the psychotic thought process.
But just because they pull back doesn't mean they don't understand the question you're asking.
That's fair. It could be that they don't understand and they don't want to answer, or it could be that they're unable to.
Unable to, or they choose not to.
It could be either or.
So a person can have psychosis. No one is disputing that someone has schizophrenia or schizoaffective disorder. But just because a person has those mental illnesses, that does not equate with not understanding or not appreciating something, correct?
That's correct. It's not a definite.
Now, when you made your diagnostic impressions back in September
Yes,
3rd of 2024, you make some unspecified diagnoses, ma'am, correct?
that's correct.
All right. And so can you tell me those unspecified diagnoses that you make?
I made the psychiatric diagnoses of unspecified schizophrenia spectrum and other psychotic disorder. That diagnosis, it referred to her history of delusional and disorganized thinking, auditory hallucinations, and mood disturbances with insomnia, suicidal thoughts, acts of cutting, schizophrenia, or schizoaffective disorder.
And ma'am, is it fair to say that that diagnosis is corroborating evidence that you had evaluated medical records, you had done your own interview, that was based on corroborating evidence?
That's correct.
And then your other unspecified diagnosis was?
Unspecified cannabis-related disorder.
All right, and how did you come to that conclusion?
That diagnosis was given because there was demonstrated a history of cannabis use in the medical records. It appeared to have been a potential clinical issue for her, but the details of it were not there. It wasn't enough detail in the records to say whether it fit into a cannabis use disorder diagnosis.
But again, based on all the documents you had reviewed, corroboration that would bring you or lead you to that potential diagnosis.
Correct, that was from the records.
And then back on September 3rd, your final was that she was incompetent but restorable.
Correct.
Okay. And so then we're going to move right along to the, I believe it's dated February 1st, which is Defense Exhibit H.
That's correct.
All right. So in Defense Exhibit H, you also provide the same information that you had initially relied upon. All those records, they're all the same. They don't change.
Exactly.
Right?
Yes, the historical information did not change.
And so then, but now it's a little bit different because she has been afforded medications.
Correct.
And now she's at a different level
Correct.
of understanding
Yes.
and cooperating.
Correct. Correct.
Now, on page 4 of the report, I believe you had a conversation with Miss Ellis about her own psychiatric history at the very bottom.
Yes.
And what does she tell you during that interview?
She told me that she had been a client of Murtis Taylor, and she said that she was treated at the agency for schizoaffective disorder. She said that she described her illness as manifesting with illogical thinking and mood swings.
All right. And so did she know what Murtis Taylor was?
Yes.
And that she had attended Murtis Taylor?
Yes.
So she's able to tell you where she was seeking her medical care.
Yes.
Or psychiatric care, I should say, to be clear. So let's go on to page 5 here. I believe you and Mr. Mack talked about January of 2015 when she went to, I believe that one was, it's a little confusing here. It says January 2015 through October 2023. The reports.
And we're going to slip in a commercial break. We'll have more from Ohio, the cross-examination of the defense expert next.
Okay, let me zoom.
Witness, a forensic psychiatrist who evaluated Ellis, now on cross-examination by the state.
I believe you and Mr. Mack talked about January of 2015 when she went to, I believe that one was, it's a little confusing here. It says January 2015 through October 2023. The reports were summarized for you with regards to the emergency department at Lutheran and then Fairview Hospital. And then I would like to talk about in January of 2015, Miss Ellis's case manager.
Sorry, guys. I got an email that StreamYard has been adding a bunch of new wonderful features, which is great. I love the updates, but we're having a little glitches. I went in and clicked on this, as Amy calls it, bumper pick of Ellis, and it showed it was up on my end, but when I looked on my live feed up there, I had it over here, now it's up there. When I look at my live feed, it still showed the old one, so I had to come in and double click it. So we've been having a little glitchiness. As comes new technology and updates, which can make life a whole lot better. Till the little kinks are worked out, it can make life a living hell. Thank you for your patience.
Took her to the emergency department at Lutheran Hospital.
That's correct.
All right. So if we just go back to, well, I guess in January of 2015, why did her manager take her to the emergency department?
Her case manager took her to the emergency department because she had not slept for 5 days. She was hearing voices and she was seeing visions. So the case manager brought her in seeking help for her.
Okay. And what happened?
She sneaked out of the ED on that day. She did not end up being evaluated. She was able to elope from that emergency department.
Okay. And then in December of that year, Miss Ellis went back to the Lutheran Emergency Department. Can you tell us about that?
Yes, she was there for treatment of a wound. There's no description of her mental health state at that day. They didn't discuss it.
Okay. On February 2016, did she again go to the Lutheran ED?
Yes.
And why did she go there?
She went there with the physical health complaints. She said she was feeling faint and dizzy. She was taking medications at that time. She was taking an antipsychotic medication, Seroquel, that was noted in the medical record. She was cooperative with care and had a workup for medical issues on that day. She was noted to have normal behavior and was able to be discharged from the emergency room.
Okay. And so, and we go through the whole history from 2015 to 2024.
Yes.
Right? And so you've got inpatient psychiatric treatment and outpatient psychiatric treatment. Is that fair?
That's correct.
All right. So not every time that she went to an emergency department was it for psychiatric issues.
That's correct.
Now, turning to page 7 of your report, ma'am.
Yes.
You review the records from the Cuyahoga County Jail, the medical treatment that she was receiving there.
Yes.
Paragraph number 4, her interactions with Dr. Baskin. And
Yeah.
what were his observations of her?
He described her as initially being limited in her willingness to engage with him. He said that she spoke to him in a curt manner. She conveyed annoyance with him. He described her as bizarre in many of her answers, disjointed, and paranoid. That was on June 6th, 2024. He diagnosed her with schizoaffective disorder. He prescribed Haldol and Cogentin, but she refused to take the medication. He then did a series of follow-up visits. He saw her on June 14th, July 5th, July 26th, and August 21st. He described her as standoffish, guarded, irritable, eccentric, and he continued those prescriptions, but she declined to take them.
And why didn't she take them?
He said that she didn't give a reason, but what his exact words were was, she declined to take them without discernible reasons, apart from believing she did not require them.
All right. So, Dr. Testa, you had all this corroborating evidence during the first interview of Miss Bianca Ellis, and then the second interview of Bianca Ellis, when you deemed her to be competent to stand trial.
That's correct.
All right. Now, Mr. Mack just touched upon it, but let's talk about it a little bit. Because, ma'am, you are a forensic scientist,
Yes.
right?
Yes, ma'am.
Forensic psychiatrist, I'm sorry.
Yes, ma'am.
And being one, you also sometimes have the opportunity to evaluate folks for insanity.
That's correct.
And insanity is a legal definition. Would you agree with me?
That's correct, yes.
All right. And so, ma'am, you started talking with Mr. Mack with regards to what are the method and mode of providing a insanity evaluation? What kinds of things do you look at?
So what you would look at, what your role would be to provide an opinion about the person's mental state at the time of the offense. So a person would do an evaluation and a diagnostic evaluation, but their main focus would not be on the day you're seeing the person. Your main focus would be to review records. You would get a lot of records from police. You would get records from any outside sources. You would review witness reports describing the person's behavior on the day of the offense. And you would review all of that. You would also do a very detailed interview with the defendant themselves. You would ask them a lot of questions about the event. What happened? Why did you do what you did? Were you taking meds at the time? You would get a history of how the preceding days leading up to the crime went. You'd get that history in great detail, and you would learn all of that from the defendant themselves. And you would have to put all that information together and synthesize all that to form an opinion.
And ma'am, is it fair to say that self-reporting is not enough?
Self-reporting is not enough. You would get their self-report. You would need that self-report because only that person knows certain things. But you have to look at a lot of extraneous information as well, contemporaneous information. You would want to know, look at the witness reports and look at observations from others.
And doctor, when you're assessing, you consider the symptoms of the severe mental disease or defect, correct?
That's correct.
The knowledge of the wrongfulness of the offense?
That's correct.
And then there would be a causal link between the symptoms and any unimpaired knowledge of the wrongfulness of the act
That's correct.
or offense.
Yes.
And then the motive for the offense, would that be considered?
We do consider that because that tells us the why, and that tells us if it's related to their mental illness and if they know it's wrong. So that's a key to look at as well, whether it's rational or irrational.
So you'd look at the rational or irrational component.
That's correct, yes.
But you didn't do it in this case.
I did not do any of that.
No. We're just talking in generalities of what a forensic scientist does.
Correct.
All right. And so you can be psychotic, yet still know the wrongfulness of your actions.
Of course.
But you can also be psychotic and not know the wrongfulness of your actions.
Absolutely.
All right. Doctor, does mental illness equate with legal insanity?
Ooh, we're treading on very careful ground. This is some good food on that. Yeah, that was a little bit.
Let's go ahead and bring in our guest for this hour to discuss from Martinez, California, criminal defense attorney Alan Kagawa. Alan, nice to see you on this Friday. Alan, listening to this doctor on the stand, she is neutral, a neutral party in a way. She was appointed by the court to take a look at the defendant here and provide some information. What do you think of the cross-examination so far? Defense obviously has said they initially just said not guilty, then they eventually changed their strategy here and said not guilty by reason of insanity. What are you taking away from the cross by the prosecutor?
I'd say the cross by the prosecutor is, as of right now, I think things are leaning quite in favor of not guilty by reason of insanity. The cross-examination really covered, Ms. Ellis's history of schizophrenia, history of hallucinations, history of psychosis, and in particular, that last line of questioning, can someone be psychotic but still know, distinguish right from wrong? I believe that is rather a weak leg to stand on when ultimately trying to find that someone is guilty of this.
Yeah, we'll have to see what else they come up with. One thing that I'm kind of thinking about in this case when we take a look at it, the one surveillance part, the surveillance video, when she is hitting the knife against that concrete column to check, according to the prosecutor, the viability of that knife. From my perspective, it appears that maybe in that moment she is able to understand what she's doing. She wants to know if the knife is working enough to do something with it, and then drops the one that clearly isn't as strong as the other one. And I just wonder what the takeaway could be from that, how the prosecutor will argue that in her closing, because if I was prosecuting this case, I would take that particular incident and talk about it.
Absolutely. I think you touched upon one of the strongest arguments for the prosecution, which is, it seems like she's understanding things. She's not in full psychosis. She's aware of potentially, just how this knife is working. I'd say definitely that goes to potentially her understanding of, what she's up to. I'd say I know the defense is going to try to focus on, some other explanation, but I think that's definitely the strongest argument for the prosecution, or at least one of them.
Yeah, one of them, definitely Alan. All right, that sidebar that was going on in court, that's over. Let's get back in now for the redirect.
Doctor, psychosis, insanity, same thing?
I'm hesitant because it was objected to before. Go ahead with it. Psychosis is a medical term.
Thank you.
And insanity is a legally defined term.
Thank you. Okay. You recall that Ms. Haraya had you go to, I believe it was page 6 of Defendant's Exhibit I, your September 2024 report.
Yes.
There was some mention of the May 26th, 24th interaction with one of the doctors regarding normal eye contact. You recall that? Did you learn that 3 days later, May 29th of 24, that Ms. Ellis was jailed in North Olmsted?
Yes.
Okay. And would it surprise you to know that a corrections officer identified her appearance and mental health status as The question was, is the inmate's conduct, appearance, and mental health status normal? And the answer was no. Would that surprise you?
It doesn't surprise me.
Okay. Again, just make sure the jurors have it. Why is it such a high rate of noncompliance with medication for this population?
Individuals with schizophrenia often have what's called a lack of insight into their illness. So the symptoms that individuals feel and perceive feel very real. They often don't agree with their diagnosis, and so they will make a choice not to take medications because they don't believe they have the illness. So it, just like if you or I, if someone told me to take medications for diabetes and I did not have diabetes, I would decline that medication. Is it a voluntary decline? Of course, but if my mind's not in reality, I can voluntarily decline. It's really not a good choice. I wouldn't have had the capacity to truly consider that and make a good decision for myself.
Do you have any reason to believe that Ms. Ellis was not a mentally ill schizophrenic prior to June 3rd of 2024?
No, the records disprove that. She was ill for years before.
Okay. Is there any reason to believe that she was not ill during the month of June of 2024?
No, I would not believe that. She was not taking medications, and there would be no reason to believe that she was not ill.
Okay. Judge, may I take one moment, please?
Sure.
All right, well, that concludes that testimony from the doctor on the stand. And again, this took place yesterday. The court for today has already started back up. But due to that court order, we are unable to air today's testimony until the end of the day. So in the meantime, we are going to switch gears and head to Florida, where a woman is on trial for fatally shooting her boyfriend in the leg. Testimony in the toxic relationship murder trial is coming up next. Stay with us. You're watching Court TV.
My two best friends were just murdered.
Join me.
Back in June of 2022, the couple shared 2 children together and by all accounts had an extremely toxic relationship. The defense says Jimenez was particularly out of control that day, forcing Link to shoot in self-defense. Before we get you back into that courtroom, here's Court TV affiliate WPLG with a closer look at this case against Daisy Link.
Daisy Link cringes at the sights and sounds from a sergeant's body-worn camera captured during the wee hours of June 25, 2022, when Homestead police responded to a call about a man bleeding out. The state says Link made that call herself moments after she fired the single shot that killed Pedro Jimenez, her on and off partner and father to 2 of her children.
In a fit of rage, she pulled out the gun, and the facts will show he had turned around and was running away in fear.
The state and defense both agree Link's relationship with Jimenez was tumultuous.
Arguments, anger, and even jealousy.
But the defense paints Jimenez as downright abusive. They say Link shot Jimenez during an argument in fear for her life.
The evidence will show this man was out of control. He was unhinged and he was dangerous. And she fired a shot to get him to go away.
A Homestead sergeant testified to Link's behavior at the scene, where she implied she didn't know what happened to the victim.
She was screaming. I believe at one point she stated she was asking me what happened.
Contrast that with what she's caught saying with the gun still in her hand.
A gun was located inside an areca palm.
Link made headlines for other reasons last year when she was impregnated by another inmate while behind bars. But jurors are not expected to hear those details during her murder trial.
Let's go into the courtroom now, right where the attorneys, they are arguing over the defendant's statement to police. This is outside the jury's presence. Let's go ahead and listen to that.
Did you and Ms. Link talk about the Miranda waiver?
What is it going on?
Yeah, 40 is the one.
Yes, she wants the whole thing in, including,
I went back and I looked over the Miranda waiver in the second one. While the police say something along the lines of, so you want to talk to us, we have to go over your rights again. They use the word again a couple times.
Which, sorry not to cut the court off, that's muted.
Well, I was going to say, that doesn't indicate that she has invoked her right to remain silent. Just because they're going over the Miranda rights a second time or again, is not a comment on her silence. So, yes, the state is going to mute that. I don't think they need to mute that because this doesn't indicate that. My concern is a comment on her silence. So,
yeah, I would just ask they play it, but no commentary, no.
Yeah, we've already seen all that. We're going to zoom. We saw her. Zoom. This is another view of the court. This is another view that we have not had.
And then you see that there is what we call abrasion, some scraping of the tissue around the edges of the wound. These are all features of it.
Daisy confessed to shooting him, but it was in self-defense. Jason, have they confirmed that the 19 people are deceased? I know, we're looking for something more positive ourselves. So, do we have confirmation, Jason?
Now, Dr. Mathis, for his right eye, were you able to determine the path the bullet was taking?
Yes, so this is the entrance wound and from the back of the thigh, so it's going from back to front.
Is the way that the bullet entered with the back of his right thigh consistent with the victim facing his back to the person who shot him?
The back of the victim needs to be facing the barrel of the gun.
So yes.
Yes.
Would it be consistent if you were facing the person who shot him?
No, because the barrel of the gun has to be pointing toward the back of the thigh.
Now, Judge, I now move to evidence what has been previously marked as stage 1Z by stipulation of the parties.
Stay Exhibit 1Z, marked identification, now becomes Stay Exhibit 23, Judge.
Judge, permission to publish? Yes. Now, Dr. Mathis, what are we looking at here?
We're looking at the exhibit line plot on his back on the autopsy table, and I took plastic probes and ran them through, placed them through the pathways of the two gunshot wounds.
So this is the wound to the foot.
Correct. And now it kind of makes more sense when you saw the shoe and how it looked on him. Harder to appreciate when adjusting the hole, but with the probe, it makes it easier to visualize.
Now, Dr. Mathis, I want to take everything together, what you said. We spoke about the left foot, the path of the bullet. We spoke about the right thigh and the path of that. Judge, I now move into evidence what what has been previously marked as 1K by stipulation of the parties.
Stay Exhibit 1K, marked for identification, now becomes Stay Exhibit 24, Judge.
Judge, permission for
Yes.
the witness and myself to stand over here? Now, Dr. Mathis, can you explain to the jury what this diagram is indicating?
Sure, so this diagram here in the middle is the notes I take during the autopsy. We call it a body diagram sheet, and that's where I'm marking down his hair color, our tattoos, and then I noted where the wounds were, what their sizes.
And how did the bullet first enter the body?
How did the bullet first enter the body? So he has an entrance wound on the left foot. That's coming out the back of the left heel region, and he has an entrance wound on the right thigh in the back. That's coming out the front of the right thigh.
How is it?
Let's go ahead and bring in our guest for this hour to discuss. Joining us now from Denver, Colorado, criminal defense attorney Eric Faddis. Eric, great to see you. I've seen you all over the place talking about the Charlie Kirk situation, Sean Diddy Combs. So thank you for making some time to talk with us today as we watch this case and listening to the medical examiner on the stand. All right, well, that doesn't look so great for defense counsel here, because the prosecutor has the medical examiner on the stand talking about the path of the bullets. So, Eric, what would you do as defense counsel here on cross-examination with the medical examiner?
Well, as defense, their defense is self-defense here, right? So they've got to establish that there was a reasonable fear of imminent bodily harm that the defendant had, and that's why she discharged the firearm. One point I would highlight is that, hey, this was one shot. It is not 5 shots. It's not 6 shots. It was one single shot. And even if the alleged victim did have his back to the defendant, a person could easily turn around, especially if things were getting heated, especially if things were escalated, especially if threats were made. And so there still is fodder for cross-examination, although that is a problematic fact for the defense.
Yeah, absolutely. Eric, what did you think? We had some arguments earlier outside the presence of the jury, and the defendant wanted, the statement kind of talking about saying it was forced. When she went and she talked with the police, there was coercion and force. What do you do with that when you're a defense counsel and your client is telling you, yeah, I said things, but they forced me to say that?
What you want to try to do on the defense side is show possibly the coercive nature of this interrogation and how it can influence a person's responses. If a person feels compelled, feels like that they couldn't make the choices that they wanted to make for themselves, and instead that the police were really driving the ship and sort of forcing her to do things, that can have an influence on what those responses are and the weight of those responses. A person could get nervous, they could misstate something, they could in the moment try to fabricate something, and while that's also problematic, it's not the same as someone being guilty of murder.
Yeah, good point, Eric. Okay, we're going to squeeze in a quick break, but don't go anywhere. We're coming right back with more of this case that we have been watching out of Florida.
Sorry, guys. I am ravishly trying to finish this paper in time. I am writing a paper. Oh, yeah, it's joyful. Someone asked what was my paper about. Oh, the question is, after reading Berman's ILO 24, please answer the following questions. In Figure 1, the author introduces 4 types of network structures. Which one or ones do you think most fit the drug network, and explain why? You may want to incorporate the 3 modes you've read from June's 2016. What are the nodes and edges of the network in this study? How are the edges measured? And if you forget that the nodes and edges are, please refer to the slide's basic social network. Yes. We're all talking about drug trafficking. And I said the word, but that's okay. I'm already demonetized.
going to be hearing, or not expected to hear anything about that, at least during this trial. So let's head back into the courtroom now. We are listening to some testimony. This is from the chief medical examiner. His name is Dr. Benjamin Mathis.
How is it possible that the way the bullet entered, how is it possible with that angle? How would the victim have had to have been standing for the bullet to enter the way it did?
From the bottom of the foot?
Yes.
So that's bottom of the foot. So to get an entrance from the bottom of the foot, the gun has to be under the foot. So if the foot is on the ground, they have to be, I guess, on the upper floor and coming through the ceiling, or the foot has to be in the air in order for it to get. So since that scenario doesn't really make sense, the left foot needs to be up in the air in order for it to be facing the barrel of the gun.
Could that be consistent with if the victim was going to try to run, that his foot was up? Would that be consistent?
Yes.
Now, once the bullet enters the left foot and exit, where does it go?
So then it comes out the back of the left foot.
And then where does it go?
And then it's going to continue in the same trajectory along a straight line until it hits something else.
And then can you just...
Or just drops to the ground.
And then for the thigh, can you talk about how when it left the foot and enters the thigh, how that's possible?
So, yes. So the same bullet could cause both wounds. It can go from the outer edge of the left foot, the left heel, to the back of the left heel region. And then the foot's up in the air, it can go into the back of the right thigh and out the front. So it goes through the foot and then through the back of the thigh and out the front.
And you're indicating that the record reflects that the witness had his left foot up and his front was facing the judge.
Right, so your right leg has to be forward, your left foot is up, and you could create that pathway.
And your back has to be facing the person who's shooting.
Yes, at least the back of the foot, yes, but that's where it has to come inside.
Now, Dr. Mathis, looking at the wound tracks, is it possible that a single projectile did this?
Yes, in the way that I just described.
And okay, we're good. Now I want to talk about the internal examination. Did you perform an internal examination?
I did.
Okay. And what internal damage did you observe as a result of the gunshot wounds?
So inside the body, his organs, those were all good. I had to do a special dissection on his right thigh to document the injuries going on within the soft tissue. And he had a lot of blood and bleeding in the muscles of his right thigh in the region of that gunshot wound. And he had holes in his femoral artery and femoral vein.
You mentioned he had holes in his femoral artery and vein. Did the bullet strike or sever those major arteries?
Yes, the bullet struck those arteries.
And now, Dr. Mathis, based on your expertise and experience, would an injury to the femoral artery, such as a gunshot wound, cause rapid or severe blood loss to someone?
It will cause severe blood loss. The blood comes from the heart, is pumping. The femoral artery comes off after the aorta branches into the iliacs. The femoral artery is one of the branches that comes off the iliac artery, and it supplies blood flow to the rest of the leg. So it's a very important blood vessel, and it will bleed, and you will lose a lot of blood from it.
And are you able to estimate about how quickly a person can lose consciousness or die from such bleeding?
So when we're talking about a femoral artery, it will take longer than, say, if you have a hole in your aorta or a hole in your lung or a hole in your heart. It's a bit downstream, so it can take several minutes. And then there are things that can mitigate it. If you're applying pressure, or if for some reason the muscle tissue is compressed around the wound, anything that's going to apply pressure to that area can slow down the bleeding.
Now, you also mentioned that several things can mitigate that. Let's say, Dr. Mathis, that there was no mitigation. There was no
covering or trying to prevent the blood loss. If pressure is not being applied correctly, how fast would the victim take to die from this type of wound?
It can still take several minutes.
And is, based on your knowledge, was that consistent with what happened to the victim in this case?
I don't think there was a long survivability period, but I wasn't aware of that at the time of the autopsy. For us, it didn't matter, but it will take. It's not going to be that you're shot and you suddenly collapse. There is a time period where it will take for the blood to come out of the body, reduce the blood volume, so that the heart no longer has enough blood to pump up to the brain to give it the oxygen it needs.
And how is it that the blood is going to come out the body? Is it going to come out rapidly? Is it going to splatter a lot?
Yes, so you have both an arterial bleed and a venous bleed. So the vein is returning blood from the bottom of the foot. That's a low pressure system. It will ooze, or it'll accumulate in the muscular tissue. The artery, on the other hand, each time the heart pumps, blood is going to be spurting out of that artery. If that artery has a clear path out the hole, the exit hole, then you will get blood coming out of that hole, and that's where you see, like in the movies, the arterial spread. If there's not a clear pathway from the hole in the artery because it's blocked by muscle or tissue, then it'll continue to spurt, but it'll come out. It may not come out as a spurt out of the hole when it leaks. It may accumulate in the tissues and then dribble out.
Now I want to talk about toxicology. Was a toxicology test performed on the victim?
Yes.
And what were the results of that test, Dr. Mathis?
I'm just referencing the toxicology report. So in him was detected ethanol, which is beverage alcohol like you'd find in vodka or tequila. He had cocaine. He had metabolites of cocaine, the breakdown products. And he had THC, which is the active ingredient in marijuana.
And how much cocaine was detected in his blood?
He had, according to the report, 0.274 milligrams per liter.
Would you say that's a lot of cocaine, Dr. Mathis? A little bit of cocaine?
It's a healthy amount of cocaine.
And now, based on your experience, Dr. Mathis, what is it that cocaine does to the body or blood?
So cocaine is a stimulant. So it causes your heart to increase. It will increase your blood pressure. It narrows the blood vessels. That's how it increases the blood pressure. And like I said, it makes your heart race. It's an upper.
Based on your exam, Dr. Mathis, did the cocaine contribute to the victim's death?
No.
Why do you say that?
Because he's got a gunshot wound that went through his femoral artery and he's bleeding out, dying from hemorrhagic shock.
Did any of the substances that he had in his blood system contribute to his death?
No.
So I want to talk about the cause and manner of death. Based on your examination, were you able to determine the cause of death?
Yes.
What was it?
That was the gunshot wound of the right thigh.
So how long would it have been, Dr. Mathis, based on your training and experience, it would take someone to bleed out or die from that injury?
Like you said, it can take several minutes.
Were you able to determine the manner of death?
Yes.
What was the manner of death?
Homicide.
Moment to confer, Judge.
Okay, we've already gone through all of that. We've seen him. It looks like we're caught up.
So of the two phones that were provided, one of the phones I was able to obtain a full extraction from due to the password being provided. The other phone was an iPhone that was password protected and the password was not known. And due to the state of the phone, an extraction was not able to be conducted on that other device.
Now, I want to talk about that for a moment. Did you attempt to extract that cell phone?
Yes, I did.
Were you ever able to extract any data from that cell phone?
No.
Okay. Were you ever provided a password to that cell phone?
I was, but it was unsuccessful.
Okay. Now, when that detective got you the phone or gave you possession of that phone, was that with a...
Okay, we're going to go over to the Soto Escalada sentencing phase. They just started. So now we're going to see the sentencing phase of Jose. Jose Suevo, you are a friend of mine. No, just kidding. You're not. I'm just in a weird mood today, y'all. Just gonna have to put up with it. Okay, they're gonna bring in, I guess, the jury. We have no sound. Yep. There we go.
May be seated.
All right, all parties are present. We're going to read the sentence of the court into the record at this time. In doing so, there are portions of the sentencing order that are case law citations that I will not be reading, but they do appear in the written order. Police found the body of 23-year-old Tanya Wise face down in a culvert ditch on the side of the road in a remote rural area of St. Lucie County. She suffered a significant blunt trauma blow to her skull, fracturing it and causing internal injury to her brain. Her throat had been cut. There were 2 deep lacerations on her neck, going right down to the bone. One from the midpoint of her throat to just under her right ear, and the other from the middle of her throat to her collarbone. The medical examiner could not specify the sequence of the injuries. Therefore, the degree to which Tanya experienced terror from this horrific murder could not be proven. The blow to her head was so devastating that if it was the first blow, it would likely have rendered her unconscious and in and of itself could have caused death. The slashing of her throat was so violent, deep, and penetrating that it in and of itself was a fatal injury. There were no defensive wounds found on her body. Tanya was in the very late stages of pregnancy of a baby boy whom she was going to name Josiah. DNA analysis proved the defendant to be the boy's father. As a result of her murder, the baby also passed. The defendant, a man in his 40s, plotted and planned her murder for days. His days of planning and plotting were caught on audio and video. Could you please silence your phones? He drove a garbage truck for a living. The trucking company had installed recording devices in all of its trucks for liability purposes. His working companion on the truck was his nephew, Eric Alvarado. As reflected on the recordings, he told his nephew that Tanya Wise was going to destroy his life by exposing their illicit affair and the resulting pregnancy to the defendant's wife. Well in advance of her murder, he chose a location to kill her and dispose of her body. The location was along the street path of his garbage truck work route. After the murder, he recounted the events to his nephew, telling him how he covered it up. In planning the murder and recounting it, he did so in a remarkably callous, carefree, and nonchalant way. When police later interviewed him, he feigned surprise to hear of her murder. He claimed he only knew Tanya as an acquaintance and never had sex with her. He completely denied the possibility that the baby boy was his child. The jury convicted the defendant of the first-degree murder of Tanya Wise and the first-degree murder of her unborn child, Josiah. Unanimously, the jury made a written finding of the existence of the following statutory aggravating factors. 1, as to both victims, pursuant to section 921.1416B, that the defendant was previously or contemporaneously convicted of another capital felony or of a felony involving the use or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. 2, as to both victims, section 921.1416I, that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. 3, as to the unborn child, section 921.1416L, that the victim of the capital felony was a person less than 12 years of age. By a vote of 8-4, the jury recommended a sentence of death as to the murder of Tanya Wise. Also, by a vote of 8-4, the jury recommended a sentence of death as to the murder of Tanya Wise's unborn child, Josiah. After receiving the jury's recommendation, the court allowed the defendant a separate hearing to allow for an opportunity to argue and present additional mitigating evidence pursuant to Spencer v. State. Weighing of aggravating factors as to the murder of Tanya Wise. Pursuant to section 921.1416B, the defendant was previously convicted of another capital felony for violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. This aggravating factor was established as a matter of law as to each victim by virtue of the jury's convictions for 2 capital murders. Violent felonies committed contemporaneously with a capital crime can qualify under the prior violent felony aggravator, whereas here, the criminal episode involved multiple victims. The prior violent felony conviction aggravator is one of the most weighty in Florida's sentencing scheme. The court assesses its weight as to Tanya Wise as follows. To understand how weighty this aggravating factor is in this case, it is noteworthy that this aggravating factor could be satisfied if the defendant had premeditated the murder of one person, but simultaneously and spontaneously committed a violent felony upon another person, such as an aggravated assault or aggravated battery. But here, there are 2 simultaneous premeditated murders. This is the much more extreme scenario in which this aggravator can be established. Therefore, it is entitled to very great weight. The court affords it very great weight as to Tanya Wise. Pursuant to section 921.1416I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The cold, calculated, and premeditated aggravating factor focuses on whether the defendant had a careful plan or prearranged design to commit murder before the fatal incident. Calm reflection is often involved. The evidence of calm, cool reflection and planning well beyond what is required for premeditated murder is overwhelming in this case, and the court finds it proven beyond a reasonable doubt. To maximize the chances of avoiding detection, the defendant coldly contemplated in advance every aspect of these murders, including the location and method of killing. He did so in a remarkably callous, carefree, and nonchalant way. As to Tanya Wise, the aggravating factor is entitled to very great weight. Weighing of aggravating factors as to the murder of the unborn child of Tanya Wise. Pursuant to Section 921.141(6)b, the defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. As to the unborn child, the court's analysis of the weight of this aggravating factor is the same as to the murder of Tanya Wise. The court affords it very great weight as to the unborn child. Section 921.1416I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. As to the unborn child, the court's analysis of the weight of this aggravating factor is the same as it relates to the murder of Tanya Wise. As to the unborn child, the aggravating factor is entitled to very great weight. Section 921.1416L, the victim of the capital felony was a person less than 12 years of age. The court finds this factor proven beyond a reasonable doubt. The child in this case was unborn, yet fully formed and about to be born within days. The premeditated murder of this baby deprived him of ever experiencing life outside of the womb. The premeditated murder of an unborn, fully formed human being still in the mother's womb, about to be born within days, is by its nature extremely abhorrent, reprehensible, and strikingly revealing of a malevolent mind. The court affords this aggravating factor very great weight. Findings regarding mitigating factors reasonably established in ways to properly carry out its important duty and to allow for meaningful appellate review, this court must expressly evaluate herein each statutory and non-statutory mitigating circumstance. In addition to the mitigation presented to the jury, the court has also considered any suggested mitigation from the Spencer hearing. Any proposed mitigation, whether statutory or non-statutory, must be reasonably established by the greater weight of the evidence. If a statutorily listed mitigating circumstance is supported by the evidence, it must then be weighed as to its significance. Unlike statutory mitigation, the court must first determine if proven non-statutory suggested mitigating circumstances are truly mitigating in nature. Once truly mitigating non-statutory mitigation is established by the greater weight of the evidence, the court must weigh it. It is within the sentencing judge's discretion to determine the relative weight given to each established mitigator. Because of the overlapping and related nature of many of the mitigators, the court has grouped some of them to ease and clarify the analysis. The court has still individually contemplated and considered the nuances of each of the suggestions in weighing them. The court has carefully applied its reasoned judgment in this regard. Statutory mitigating factors. Considered statutorily listed mitigating factor. The defendant has no significant history of prior criminal activity, and considered related non-statutory mitigating factor, the defendant has no prior history of violence. These circumstances were established by stipulation as to no prior criminal history in general, and by testimony as to the lack of violent history. This included specific instances when the defendant maintained his cool when others might have reacted more aggressively. Adding to this mitigation is that during the defendant's life, he was faced with stressful circumstances similar to those posed by the threat of exposing his infidelity in this case. Specifically, he was on more than one occasion taxed with his self-created predicament of supporting children he fathered out of wedlock. On those occasions, he did not respond with violence or criminal activity, rather he responded responsibly. Additionally, during the breakup of his relationship with Madeline Cologne, she put him in a situation where many men might respond aggressively, but he did not. When she discovered his involvement with another woman, she burned his clothes, broke his phone, keyed his truck, and flattened its tires. Despite this, he remained calm and did not act violently. According to her, he handled it perfectly. Childhood reports of the defendant's behavior were consistent with him being non-aggressive. Family members reported that they had to stick up to bullies on the defendant's behalf. This mitigator was established, and it is entitled to moderate to great weight. Non-statutory mitigating factors. Considered related non-statutory mitigating factors. While in jail custody awaiting trial, the defendant has been a peaceful, mostly compliant inmate. The defendant can positively contribute to society as an inmate worker if sentenced to life in prison without parole. The defendant has demonstrated exemplary jail-prison behavior. The defendant will be required to work 60 hours per week in general population at the Florida Department of Corrections if sentenced to life without the possibility of parole, and he would adjust well in that general population setting. He would likely contribute to the prison system. The defendant poses no danger to prison, jail staff, or inmates. The defendant will be completely incapacitated and pose no danger to the community with a sentence of life without the possibility of parole. As listed by the defense, the defendant, quote, can be redeemed, unquote, which the court takes to mean that he would prove to be a good inmate. Since his arrest in 2018 for these murders, while in the county jail, the defendant has only committed 3 disciplinary violations, and they were all minor and virtually insignificant in nature. He's had no fights with other inmates or violent encounters with guards. The testimony did credibly establish a significant probability that the defendant would be a model prisoner if placed in general population. The defendant's personality and work skill set would suit him well in general population. The court finds these mitigators to be proven and affords them moderate weight. Considered non-statutory mitigating factor. During a previous romantic relationship with Lucinda Cook, the defendant acted like a gentleman and was nonviolent in the face of instigating behavior by Ms. Cook. Ms. Cook was a gas station attendant and the mother of 3 young children when she started dating the defendant approximately 10 years before the murders. They dated for a year and then lived together for a short time. When she met the defendant, she had just come out of an abusive relationship and as a result was impatient and verbally abusive to the defendant. There came a time when she decided to end her relationship with the defendant for reasons unknown to the court. During the term of their relationship, she described the defendant as acting gentlemanly to her and her children. Her children were fond of him. The defendant made her and her children feel safe. According to her, despite his model gentlemanly behavior, she found fault with everything he did and argued with him for essentially no reason. She described that during their time together, it was common for other women with whom he was also romantically involved to come around her and cause problems. She went out of her way to emphasize that this was no fault of the defendant. When she decided it was time for him to leave their relationship and presumably their domicile, she pushed and damaged his fancy motorcycle and spat in his face. Despite her aggravating behavior, he never argued, got mad, or did anything to retaliate. She never saw him act violently, even though he was apparently employed at that time as a club bouncer. To the contrary, rather than describe him as violent or ill-tempered, she described him as behaving, quote, like a clown, unquote. She never saw him angry enough, quote, to do something, unquote. She described him as exemplary and that in hindsight she should have treated him better. On cross-examination, she conceded that since the time of their separation she avoided all contact with him. However, recently his family persisted in making phone calls to her in an effort to make her come forward as a character witness for him. Her first contact with the defendant after their separation was approximately a month prior to trial. The court's conclusion regarding this witness and what her testimony establishes is as follows. Her overall credibility is low. The court believes she exaggerated the truth. However, there is enough truth in her testimony such that she established this mitigating factor. The weight of the mitigating factor is reflective of the source that established it, her testimony. Therefore, the court affords it moderate weight. Considered non-statutory mitigating factor. The defendant was abandoned by his father as a child. At trial, there was scant evidence of this other than a mention that the defendant, quote, never really spoke to his dad, unquote, by Miss Cologne. There was also testimony from Joanne Stone that the defendant's father was a bus driver and apparently lived with him in Bridgeport, Connecticut. However, the Spencer hearing evidence established that the defendant's father moved out and played an insignificant role in raising him. Therefore, the court finds this mitigator to be proven and affords it little weight. Considered related non-statutory mitigating factors. The defendant was raised in chronic poverty. The defendant left school early and lacked the opportunity to complete his education. The defendant was resilient and overcame his lack of education through consistent work ethic. The defendant began working and earning money to help support his family at a young age. The evidence established that the defendant was raised in a low-income environment and likely had less opportunity to further himself than most other people. However, as testified by Monica Ropiza, his cousin, they were low income, but, quote, had what they needed, unquote. These circumstances were proven. The court affords them little weight. Considered related non-statutory mitigating factors. The defendant suffers from transgenerational family trauma. The defendant experienced chronic exposure to trauma during his childhood. The defendant's mother had a traumatic upbringing because she was abandoned by her father, causing her to leave school. When she was only 15 years old, she got pregnant with a son who died in her arms from illness about a year after birth. Naturally, the death of her son was traumatic for her. The defendant's father was older than she, making their relationship illegal. After the death of her first son, at 17 years of age, she became pregnant with the defendant. The defendant was raised in a low-income, crime-ridden neighborhood. Early into his life, his parents separated from each other. His father was largely absent, but did live nearby. At some point during his youth, the defendant's mother developed a drinking problem. This caused her, to some degree, as a single mother, to be emotionally or physically unavailable to him. The defendant did have a large extended family immediately available to him. Some of them were drinkers too. His aunts, who lived in his public housing project, to some degree helped raise him. There was broad, general, non-convincing testimony that the family was exposed to, quote, drug dealers, fights, and crazy people, unquote. The court finds these mitigators proven and assigns them little weight. Considered non-statutory mitigating factors. The defendant has established and maintains long-term substantive, meaningful relationship with friends. The defendant has established and maintains close family bonds, relationships with his cousins. The defendant has maintained a close relationship with his mother. These were established by the evidence. The court considers this mitigation also in the greater context that the murders in this case, as aggravated as they are seemingly out of character. The defendant's life relationships are not typical of the type of antisocial person one would expect would commit the murders in question. The court finds these mitigators proven and affords them moderate weight. Considered related non-statutory mitigating factors. The defendant has established and maintains close family bonds, relationships with his children. The defendant provided support for his children. The defendant has established and maintains or maintained before his incarceration close family bonds, relationships with the mothers of his children. Aside from committing the murders, the defendant has been a positive influence on family members. The court finds these mitigators proven. There is a huge contradiction between how the defendant responded to the prospect of fathering his child to be born of Tanya Weiss and how he supported his other children. The defendant supported his other children generously according to his means and without compulsion. He was very active in their lives. With regard to one of his children, his support continued even when he learned after years of support that the child was not in fact biologically his. The court affords these mitigating factors moderate to great weight. Considered related non-statutory mitigating factors. The defendant was a positive influence on his former girlfriend and her children. The defendant helped his former girlfriend's son's mother escape a dangerous domestic violence situation. Defendant fathered a child with Madeline Cologne. His relationship with her was short-lived due to his two-timing. However, after they split up, they stayed friends, and the defendant supported their child, Antonio, by regularly bringing groceries and school supplies and by paying the child's social fee for the Boys and Girls Club.
Oh, I love how they're painting him out to be a saint.
Madeline had just come out of a violent domestic relationship. The defendant's calm presence assisted her in transitioning from the trauma of her prior situation. He made her and her son feel secure. The court finds these mitigators to be proven and affords them moderate weight. Considered non-statutory mitigating factor. The indirect effect of racism against Puerto Rican Americans on the defendant. The existence of racism of this nature, no doubt at some point in his life, filtered down to the defendant. However, there were no direct instances of discrimination or racist behavior directly pointed at the defendant. The court finds this to be proven and affords it very little weight. Considered related non-statutory mitigating factors. The defendant has always been a hard worker in manual labor fields such as furniture delivery and security work. The defendant has always been self-supporting, not a drain on society. There was scant evidence of the exact nature of the defendant's jobs over the years. However, the record is overall consistent with him being a hardworking, contributing member of society. The court finds these circumstances to be proven and affords them little weight. Considered non-statutory mitigating factor. The defendant escaped a high crime, high poverty area, independently moving to Florida when he was just 15 or 16 years old. The defendant exhibited resiliency in overcoming early life challenges. The evidence does establish these circumstances. However, there were no credible direct instances proven of the defendant personally witnessing any extreme violence such as gang violence. There was no strong evidence of the negative effects of living in a low-income environment. the court affords these mitigating factors little weight. Considered non-statutory mitigating factor, the defendant exhibited excellent courtroom behavior. Overall, the defendant was well behaved during the trial process. However, when the court received their sentencing recommendation verdict from the jury, when his conduct counted the most, the undersigned did observe the defendant expressing his disagreement to the jury. He noticeably shook his head in disapproval rather than remaining still and accepting the judgment of his peers. This came after the defendant heard the court admonish all audience members not to react by showing joy or displeasure so that jurors would not have a negative experience and be dissuaded from serving. The defendant did the very thing that he heard the court admonish the audience not to do. The court finds this factor to be proven and affords it extremely little weight. Considered non-statutory mitigating factor. The defendant will continue to offer a positive life influence on his children, other family members, and friends who have become emotionally dependent on him. Given the circumstances of his family's reaction to his conviction by distancing themselves, the degree to which the defendant's family will stay in touch with him is uncertain. However, the court does believe that if given a chance, the defendant would remain in contact with and support his relatives as best he could. The court finds this to be proven and affords it little weight. Considered non-statutory mitigating factor. After the jury recommended the death penalty for him, the defendant expressed empathy for his victims to his mitigation specialist. The court finds this to be proven and affords it very little weight. Suggested and rejected non-statutory mitigating factors. The negative effect of a prolonged appellate process on the victim's family and the dangerousness of general population as opposed to death row. The court does not find that the negative effect of a prolonged appellate process on the victim's family is a proper consideration, nor does the court find that the dangerousness of general population as opposed to death row is a proper consideration. In the defense mitigation expert report, neither of these were connected whatsoever personally to the defendant. Rather, they were framed as general policy arguments. Neither of these circumstances meet the definition of a mitigating factor under the law, that is, matters relevant to the defendant's character or record or the circumstances of the offense proffered as a basis for a sentence less than death. Conclusion after the weighing process. The court has carefully weighed the aggravating and mitigating circumstances as to each murder individually. The court's weighing process can be summarized as follows. As to Tanya Wise, there are 2 aggravating factors that are entitled to very great weight. As to the unborn child, there are 3 aggravating factors that are entitled to very great weight. As to the mitigating factors, the cumulative weight of the mitigation is entitled to moderate to great weight. As to each murder, the court finds that the aggravating factors outweigh the mitigating circumstances. As required by law, this court has given great weight to the jury's recommendation. The court's weighing analysis in this case, with its acknowledgement of significant yet outweighed mitigation, is a reflection of the jury's 8-4 vote for death as to each of the murders. The court's independent evaluation of the case herein leads to the conclusion that the death sentence is the appropriate and just sentence as to each victim. Therefore, Jose Soto Escalera, I hereby sentence you to death for the first-degree murder of Tanya Wise. I also independently sentence you to death for the first-degree murder of her unborn child. I hereby order that you be taken.
I know I'm muted for a reason because I'm screaming. I thought they were going to give him life. He gave him death. Yes. Sorry. Not sorry.
By the sheriff of St. Lucie County to Florida State Prison for close and secure confinement until the date of your execution, at such time as scheduled by the governor of the state of Florida, at the place of execution named in his warrant of execution, you shall be put to death by the means provided by Florida law at that time, and may God have mercy on your soul. You are hereby notified that the sentence of death is subject to automatic review by the Supreme Court of Florida. The court finds you continue to be indigent and hereby appoints the office of the public defender to represent you on appeal. And that is the sentence of the court, and that will end this case. Thank you all.
Should the defendant be found guilty, we would then do a enhancement portion of this, as noted, the state filed.
Okay, we are having a glitchy button with this. Sorry about that. It's not like I told y'all. I warned y'all. StreamYard said they're glitchy today, because they're updating something. And I don't know why I never use that button to mute. I use the button over on this machine. What I said is that, yes, I thought the judge might be giving him a life without the possibility by the way it was reading. But when he came down with the life, I think it's great. Yes, it's going to take time, but it's much deserved. Much deserved. It really, really is. I just can't imagine that poor family, and I would not want to be them. But at least they have some sense of resolve. Thank you, beloved. They have some sense. Did you nuke them? You didn't heat up the meatballs? Okay. So, but anyway, I made what I call protein balls. It's equal hamburger sausage with bacon, cream cheese, regular cheese, protein balls last night. So, yes, I'm glad. Later, Tater, you're going to get baked. He ain't going to get baked. He's going to be injected. They going to inject him. I know the explosion scene is heartbreaking. We're watching it, but I can't overdo it. I'm still raw from our own. All right, here, let's go back into court.
This call is entirely relevant to that, because she talks about her prior convictions. The portion that I want to elicit in testimony for during Detective Jim Morris's testimony is a portion of time in which the defendant, there's conversations about what essentially she is facing, but there was a conversation about 15 years, and she says the prosecutor changed their mind and they said no, 25 years. the defendant says, well, if I would have known that, I would have chopped up that motherfucker and spread them all around Florida.
Why would I let the jury hear that she admits her crimes?
No, I'm not introducing that portion. Like I said, the only portion that I'm intending to introduce for this portion of the testimony is what I just said. If I knew how much time I was facing, I would have done this. The reason that I want to introduce that is because, number one, it goes directly to her intent and will directly refute the statement that I'm about to introduce as well, that this was a mistake, that this was a misunderstanding, that she was protecting herself. This goes directly to that, and specifically elements 3, I think, of this crime that she depraved mind that goes directly to this.
That's on the jail.
Yes.
Okay, what's your response?
So Judge, this jail, I don't know exactly when it was, but it's my understanding that it was, what, in the last month?
Last couple weeks.
Last couple weeks. So we've got that, a lot of time has passed. She's talking about what she's facing. So first of all, this conversation, this very small part of a 15, 20-minute conversation, I would submit that it's far more prejudicial than probative. I don't think it's probative of anything, but if the court were to allow it, then it opens up, or it opens the door for her to explain her state of mind and why she said it. And if you do that, then we're talking about, well, facing life. This other guy got 25 and he was charged with a lot more.
I don't have an objection to that.
Said that in jest, things of that nature. So I think it just opens up. It opens up for a lot of problematic issues.
I don't have an objection to her talking about that. About the time that she's facing and the state of mind in which she said.
You don't have a problem.
I have zero problem.
I have a huge problem with
Judge, there's no pending.
When I use the word jury
Yep.
in front of the jury, why did I go through that? And I use that very diplomatic, neutral word instead of prison, minimum mandatories, enhancement.
We talked about that during voir dire, that they would not be a part of the sentencing phase. Your Honor brought it up. I brought it up. I forget the gentleman who mentioned that something about how he would be uncomfortable sitting in judgment of it because he could potentially be taking somebody's life away. And then we discussed that this was not a capital case, that she is not facing the death penalty,
So
etc.
why would I now allow them to hear potentially facing?
Judge, I'm not making, nobody has made a motion of limine to limit that portion of this case. Normally, the state brings that up in a motion of limine because it is inflaming the passions of the jury to say, well, this woman's life is in your hand, and if you convict her, she's facing this. I do not have a problem, and I am not making a motion in limine to limit that. I don't think that it would be a compelling closing argument to make, but regardless of that, this call is, number one, a business record. Number two, it is the defendant's statement, so it's not being introduced for the truth of the matter asserted for a statement by party opponent as well as a business record. So it's admissible as such. And then number two, the reason that it's more probative than prejudicial is because, again, element 3 of this crime is that the defendant committed this act with a depraved mind, which goes directly to this case. The defense's argument, theory of the case, I'm introducing her statement in which she says this is self-defense. Mr. Tomas, during a number of different testimonies, has elicited the testimony, especially with Dr. Mathis, about how the victim was charging at the defendant, screaming at the top of his lungs. I think during opening statement, he said this was a guttural, vicious, almost demonic statement that the victim made, which Ms. Link, in this jail call, in this portion of the jail call, and it's about 30 seconds, says, well, if I knew how much time I was facing, I would have chopped him up and spread him all around Florida. The reason why that's so important,
wow,
she says this was an accident. She didn't mean to do this. This wasn't her intention. This goes directly to that and the depravity of her mind at the point in time that this crime was committed. I have zero problem with Ms. Link when she testifies, because I think we're all on the same page here that she is going to be testifying. I have zero problem with her explaining that call, and she should.
Okay, your request is denied. It is highly inflammatory, highly irrelevant. It happened 3 years she was arrested. The context of which she's making that statement is during a breakdown of plea negotiations. It's also not connected in any way temporally to the commission of the crime or any statement she made post Miranda.
Well, Judge,
It's also more, nope, pleadings are closed, no more argument. You started first, you went second, you're going third, and that's it. It's also more prejudicial than probative. That's my ruling.
I understand your ruling. I just want to put two things on the record. Number one, during the court's ruling right now, I can see it on the computer screen. Ms. Link is rolling her eyes every time I open my mouth. I would ask the court to admonish Ms. Link once again. I know that we had a conversation sidebar about that in the next of kin. I think that this is becoming a feature of what Ms. Link is doing during this trial and trying to, I don't know, get her 15 minutes of fame. And number two, I think this goes directly to the defendant's consciousness of guilt, of what he would have done.
Thank you. You have asked, sir. Ms. Link, I cannot go in the mind of the jury. I think they're paying attention. I think they're dedicated. The fact that they're here early almost every day and they come back for lunch. We've been doing the case, not them. You're not allowed to make any facial expressions. I already said it before. This is a tragedy all around. You're allowed to be emotional. You have to control it. Because I literally told the next of kin through Mr. Bermuda that I could see their emotions, and I asked him to have them limit their emotions. It was cumulative over a few day period. I haven't been looking at you. I don't know if you're rolling your eyes or anything of that nature. I know that you got emotional when the body worn camera was played, just about everyone did. But the jury needs to decide this case based on the evidence and not from any outside influence. It's actually in your best interest to control any facial expressions you may be doing, because if they don't like what they're seeing and they don't tell me, I don't know what's in their heart, and I don't know what's in their mind. Does that make sense? Yes. Okay.
So just the only other thing that I wanted to inquire about is the order that you were able to get a certified copy of. Can I use that, or do we need to get like an original from them?
I don't have an objection to the introduction. I still think that the court needs to take judicial notice that a termination of parental rights does not exist in this
You have
case.
an objection to me doing that? I think I was inclined to do that.
That's fine, and I would seek to admit that order as a certified document.
I have no objection.
He has no objection to that.
All right.
Yeah. But you realize that what you gave us is not a termination of parental rights.
Yes, I didn't use the word terminated. I said he lost his rights, and that's actually true. He has a pathway to get his rights back, but he would need to get drug treatment, which the order says he hasn't, and he would need to curb his domestic violence, which the order says he hasn't. And we already know from what happened that wasn't happening. So Ms. Link was the custodial parent, and his rights were limited to Zoom calls that were completely at her discretion, and one visit a month supervised with his mother, who did not live in the state.
So if we do play back the record, Mr. Tomas did say that his rights were terminated.
I didn't say terminated, I said lost.
All right, fair enough. All right, fair enough. I just want to make sure we're all on the same page and what that document actually showed. Since it's a document that my JA was able to get from the Bearcats JA in the dependency/juvenile division, I think the state is satisfied. It is a business record, and I would take judicial notice that there's
I'm going to give you a copy.
order terminating his parental rights. It seems like, Mr. Tomas, what we have is an order limiting his parental rights, correct?
Yes.
Limiting.
If I could just have a moment to step outside to inform my officer.
We can go off record for a few minutes.
This is the other one. This is the order.
While he does that, state orders back here. 2.2, can you look to see? Mr. Tomas, can you pull 2.2 from the jury instruction on edited recording?
Wow, what a heated back and forth. Wow. We are back in recess. Now we're going to go back to court. Y'all, I'm about 5 minutes away from submitting my paper. It was due at 3 o'clock. I love it when they post something at 10 and say it's due by 3. What about those of us who work and can't work and do school at the same time?
We're starting with the next.
I am.
No, I understand, but this is part of the course.
I understand, you can revisit it later on.
That doesn't have to be right now, like, we want access to the court and the record to revisit for the case law.
What case law?
Well, Judge, that's what I'm.
Right, so I'm not gonna play this back and forth where I am, Mr. Brigida, you all have case law, you wanna bring it up, it's not relevant to the next witness, right?
It's part of it.
Part of this next witness?
Yes, this is.
So, okay. How am I going to now look at this case law without reading it first?
Well, Judge, so what we're asking, Judge, is once we have the case law, we'll have it printed, and we're asking for access to the record to make arguments specifically on the court's ruling that the jail call is not, the court did not allow jail call.
The jail call, where she talks about her prison sentence that she's facing?
Judge, it goes to consciousness of guilt. If I can I make
No,
arguments to court?
no, we're done on this. Mr. Brigida started the argument. I went to the defense, I went back to Mr. Brigida, I allowed him some leeway after I ruled, but as far as I was concerned, the pleadings on that issue were closed. I'm not allowing you access to the record. We're gonna be in trial 2 days next week, file your motion for reconsideration. Thank you.
Understood, Judge.
All right, this next witness's name is Detective Janora. I'm gonna bring them back in. I'm gonna bring them in, so.
The statement.
For what it's worth, the jury's been outside for 11 minutes. And I know I was 10 minutes, but these are issues that are being brought up in the middle of trial. So let's just try to streamline it so that we don't waste this jury's time.
All right, adjourned.
Here we get the jury foot parade. Male, male, female, female, male, female, female, female. I don't know. I don't know. It's only 6 of them.
All 9 views accounted for.
All right.
9?
All jurors are accounted for. The lawyers are still present. See it. Thank you. This should be the last witness for the day. It's Sergeant Melanie.
Detective Melanie Denars.
Detective Melanie Denars.
This is. Messed up. Yeah, thank you.
I get the name, just.
Melanie Denars. She's
Oh,
on the
Raise your right hand and sign to affirm that the testimony is about to give the truth, the whole truth, and nothing but the truth.
I did.
Thank you. Good afternoon, Detective. Can you please introduce yourself to the members of the jury?
Good afternoon. My name is Detective Melanie Denars.
And where do you work?
I work in the Miami-Dade Sheriff's Office.
How long have you worked there?
I've been there now for 8 years.
And what department do you work in?
I'm currently assigned to the Homicide Bureau.
And can you just briefly walk us through your training and experiences?
When I started, I was on road patrol in our South District. After a year and a half, I became a field training officer. So I would train the new recruits that would graduate the academy. After some time doing that, I was transferred over to the Homicide Bureau in 2021.
Were you working in your capacity as a police officer on June 25th, 2022?
Yes, I was.
Now, how did you first become involved in this case?
I was contacted by Detective Danny Morales, who advised that there was a homicide that occurred in the city of Homestead, and I was requested to respond.
Did he advise you who found the victim?
He told me that the victim was found by his wife.
Okay. And did he advise you what, if any, injury he was suffering?
He had a gunshot wound to the leg.
Okay. Are you aware if the victim was declared deceased on scene?
I believe he was.
Did you arrive to the scene?
Yes, I did.
Was that scene at 1237 Northwest 14th Street in Homestead, 33030?
Yes, it was.
Is that in Miami-Dade County?
That is with the Miami-Dade County.
Okay. When you first arrived on scene, excuse me, who, if anyone, did you make contact with?
I made contact with my supervisor, Sergeant Jason Waite.
And what, if anything, did he advise you of?
He advised me that Detective Joseph Cruz would be the lead investigator on the case.
Now, before we move on, can you explain how homicide teams actually work?
Yes, so we are a team consisting of one supervisor who's a sergeant, and we have between 3 to 5 detectives on that team. When we are assigned a homicide investigation, there's always going to be one detective that's the lead investigator. And because the multitude of the cases and the amount of work that needs to be done in a homicide investigation to be thorough, the whole team will assist and handle different leads that are assigned by the lead investigator.
Now, you said that the lead investigator in this case was Detective Cruz, correct?
Yes.
Now, are you making decisions on your own, or is he giving you assignments?
No, all decisions are made by Detective Cruz. Prior to me making any decision, I would advise Detective Cruz what I came across, what I have. And at that point, he will guide me in what he would want me to do.
So it's fair to say that everything you learned, Detective Danny Morales, Detective Suyapa Hubbard, everything that they learned is flowing to Detective Cruz?
Yes.
So that he can make a decision on what to do?
Yes.
Now, did you speak to Detective Cruz on scene?
Yes, I did.
Were you given a brief on the investigation and facts as he had them on scene?
Yes.
Did he make any requests of you?
He requested that I respond with him to headquarters to interview Miss Daisy Link.
Okay. Did you respond to headquarters that day?
Yes, I did.
And was that to potentially interview the defendant?
Yes.
Okay. Now, at the point in time that the defendant was transported to headquarters, was she a subject of the investigation?
No.
Why not?
She was merely a very important witness. She was also the wife of our victim, which is very important for us because we believe she would have very relevant information as to what the victim was doing prior to him being shot, if he had any enemies or anything of that sort.
Did you believe it was a good idea to bring her in?
Yes.
Now, when you first got to headquarters, is that where she was brought in for an interview? Is that recorded in any way?
Yes, it's a video and audio recorded.
Okay. And everything that happens in that room is going to be captured more or less?
Yes.
Now, when you first interacted with the defendant in the interview room, did you contact anyone to assist you?
Yes, I contacted our Crime Scene and Evidence Bureau so they can have an investigator respond.
Why did you do that?
To take pictures, and also she had clothes that was full of blood. I didn't want her sitting in the interview room for a long period of time in clothes that had blood that was potentially her husband's. So I wanted to make sure I could get her to change and photograph her before that.
Can you explain what the defendant's demeanor was like when you were first interacting with her at headquarters?
She's very defensive during that interaction.
Did she say anything to you?
She said, and not exact quoting, but something along the lines of...
Objection, speculation.
Just the words she said. Okay. So the objections will rule.
Why was I treating her as a person that shot the victim?
Okay. In your mind, were you treating her as the person who shot the victim?
No, I simply wanted her to get out of bloody clothing that she had on.
Did you attempt to give her clothing?
I did.
When you attempted to give her those clothing, what was her reaction?
Excuse my language, but she said, I'm not going to put that shit on.
Did you offer her anything to eat or drink at that point in time?
I did multiple times.
Did she accept?
No.
Showing defense counsel has been pre-marked for identification purposes. Permission to move into evidence, Your Honor. Absent objection.
Stay Exhibit 2C, marked for identification, now becomes Stay Exhibit 25, Judge.
While at headquarters, other than interviewing Ms. Link or attempting to interview Ms. Link, did you do anything else? Thank you.
Yes, I did. I documented a body search warrant.
What is a body search warrant?
A body search warrant is a warrant to gather DNA, clothing, and this particular incident was for the DNA and the clothing.
Okay. What DNA and what clothing?
It was going to be for Ms. Link's DNA and for her clothing.
Okay, we briefly talked about this yesterday, but can you explain to us what the process is of obtaining a warrant?
Yes, so us as detectives, we document a statement of facts, which is the facts that are known to us at the time of us writing that search warrant. Once we type that, we submit it to our supervisor who reviews it. Once our supervisor is done reviewing it, we will submit it to a state attorney. The state attorney determines whether or not we have enough probable cause to move forward with that warrant. Once they determine that we do, we submit that warrant to a judge who gives a final approval on it.
Okay. And was a warrant for Ms. Link's DNA approved in this case?
Yes.
Was that executed as well?
Yes, it was.
Okay. Now, at that point in time, after doing the body warrant, what, if anything, did you do next?
Fingerprinting.
Fingerprinting who?
Miss Link.
If Ms. Link was not a subject at this point in time, why were you fingerprinting her?
Because we were made aware that she did touch the victim at that time when she found him. So we wanted to make sure we did have her fingerprints in the instance we had to rule it out and use it for that.
Okay. Was she under arrest at this point?
No.
Was she a subject at that point?
No.
Now, if she wasn't a subject, she wasn't an arrest, why are you fingerprinting her?
In case we found fingerprints that she mentioned about touching the subject, his property that was on him. So we find fingerprints, we have to submit those fingerprints for testing in case it could have been someone else that touched the phone. So having her fingerprints will help us in ruling out, okay, these are Miss Link's fingerprints, and we know that these are her fingerprints because she did touch the victim at the time.
Now, to be clear, the defendant does not have to speak to you at any point, correct?
Correct.
When you were fingerprinting her, were you prompting her to speak to you?
No.
Did she ever speak to you while she was being fingerprinted?
She did.
What, if anything, did she say to you?
She said, I did not mean to kill him.
Okay. What did you say to her in response?
I advised her to please stop talking. That if she wanted to speak to me, we would have to go into the interview room, go over her rights. And at that point, we can determine whether or not she really wanted to speak to me. But I did tell her multiple times to not speak to me.
Can you explain to the jury what Miranda rights are?
Yes, it is a form that we use. It explains the right to individuals that they have a right to not, they don't need to speak to us, whether they want an attorney present or not. And that pretty much a little summary of what Miranda rights are.
Okay. Judge, by stipulation of the parties, state moves into evidence that's been pre-marked for identification purposes is 2D.
All right, go ahead.
Stay Exhibit 2D, marked for identification, now becomes Stay Exhibit 26.
And permission to publish. Thank you. I'm using a demonstrative which is pre-marked for identification purposes as 1J. I know this is very far and the writing is small, so I'll read it. And if I could have that as well. 26. Thank you. So Detective, I'm going to put this in front of you real quick and use the same form here. The top of this, is this the Miranda form that you read to Ms. Link, or Ms. Link read?
Yes.
Okay, let's start at the top. Before you are asking questions, you must understand the following rights. Let's start at number 1. You have the right to remain silent. You do not have to talk to me if you do not wish to do so. You do not have to answer any of my questions. You understand that right? There's a yes, there is a no. There, what appears to be a D and L next to yes. Whose initials are those?
Miss Link's.
Okay, so she responded yes to that question?
Yes.
Number 2, should you talk to me, anything which you might say may be introduced into evidence in court against you? Do you understand that right? There's a yes, there's a no. Again, a DL on yes. Is that Miss Link's initials?
Yes.
And she initialed yes?
Yes.
Number 3, if you want a lawyer to be present during questioning at this time or any time hereafter, you are entitled to have the lawyer present. Do you understand that right? Again, yes, no. Again, initials. Is that Miss Link's initials?
Yes.
Miss Link understood that right?
Yes.
Number 4, if you cannot afford to pay for a lawyer, one will be provided for you at no cost if you won't. Do you understand that right? Yes, no. Again, a DL. Miss Link understood that right?
Yes.
Those are her initials?
Yes.
Knowing these rights, are you willing to answer my questions without having a lawyer present? Yes, no. Again, DL. Miss Link's initials?
Yes.
Miss Link understood that right?
Yes.
She agreed to speak to you?
Yes.
Did you threaten her in any way?
No.
The statement is signed of my own free will without any threats or promises having been made to me. There's a signature and a date and time. That date is 6/25/2022, and the date appears to be, it's either 4 or 6:22 p.m. Is that correct?
4:22 p.m. Yes.
Okay, and whose signature is that?
Miss Link's.
And on the left-hand side of this, I have, it says advising officer. Who was the advising officer?
That was me.
And can you tell us the rest of it? It says 6/25/22 with what appears to be 6567 above it?
That's my badge number.
Okay. And then right underneath it, there's a witness, J. Cruz.
Yes, that's Detective Joseph Cruz.
Thank you very much. I can take that. Now, I want to briefly talk about the defendant's statement. What, if anything, did she tell you? Just briefly.
She told me that her and the victim were involved in an argument.
Judge, I would object best evidence from what we're going to hear this.
Oh, this is summary, correct?
Yes, ma'am.
Okay, and states it, planning on introducing the statement?
Yes.
Go ahead.
Well, here, let me ask you this. Did she advise that she knew who the victim was?
Did she, at the time of the interview, did she advise that she knew who the victim was?
Yes.
Yes, she did.
Who did she say the victim was?
Her husband.
And that would be Pedro Jimenez?
Yes.
Did she advise of any domestic violence between her and Pedro Jimenez, in which Mr. Jimenez was the aggressor?
Yes.
Did she also advise of any domestic violence, prior domestic violence, where she was the aggressor?
Yes.
Did she also advise you of an
So they both beat each other up.
incident that happened a few days prior,
Yes.
in which Mr. Jimenez, she claimed pistol whipped her?
Yes.
No. No.
Did she advise that she picked up Mr. Jimenez
No.
that day?
Yes.
What did she say about that?
That she responded to one of his friend's house because it was getting late to go pick him up.
Did she say if he threatened her at that point?
No.
Did she say that he had any weapons on him?
No.
Or him?
No.
And she said she went and picked him up on her own volition?
Yes.
Did she say whether or not he asked her to pick her up?
No.
Did she ever tell you about any conversations that they were having that night?
Yes.
And what was that conversation about?
Conversations about the victim making allegations that Miss Link cheated on him.
Did Miss Link deny that to the victim?
In the beginning, yes.
Okay. Did she advise a little later on about what continued to transpire that night?
Yes.
And what was that?
They continued to argue about the same situation until eventually Miss Link advised the victim that she did cheat on him.
And did Miss Link advise that the defendant had left at that period of time before she admitted to the infidelity?
Yes.
Did Ms. Link advise that she had a firearm?
Yes.
And at what point in time did she say she had the firearm?
She was looking for the victim, didn't know where he was at. She grabbed the firearm from inside and then sat outside to smoke a cigarette.
And so the victim was nowhere to be found at that point in time?
No.
Did she say why she grabbed the firearm?
She believed that by grabbing the firearm, it would instill fear in him from confronting her.
Even though he wasn't around?
Yes.
Did she say if the victim showed up later on?
Yes.
And what happened there? Did she say?
They continued to argue. The victim at one point pushed her, which is when she grabbed the firearm. As soon as she grabbed the firearm, the victim began to run away from her. She says that he was running to lock her out of the house. And in order to stop him from locking her out of the house, she discharged the firearm.
Did she say that she was in fear for her children?
No.
Did she say she was in fear for her safety?
No.
Did she merely say that she didn't want to be locked outside?
Yes.
Did Ms. Lincoln advise what, if anything, happened to that firearm?
Judge, at this point, I'd ask best evidence rule, we can hear.
Same, we're not sorry.
Did you ask Ms. Link to draw anything for you?
Yes.
And why'd you do that?
For me to better understand where she was when she discharged the firearm for purposes of attempting to locate a casing on scene.
Okay, state now moves into evidence which has been pre-marked for identification purposes as 1B. 2B, I'm sorry.
The exhibit 2B marked for identification now becomes state exhibit 27.
That's my stipulation, right?
Yes, sir.
And I also have a demonstrative of this. Detective, if you don't mind just taking this from me, so I'm going to give you a couple of markers here. Truthfully, just use whichever one works a little better. Thank you. Or both. If you don't mind just holding that up for the jury. What exactly are we looking at here?
So here we're looking at the street.
Oh,
These are two duplexes.
Jason, I love you, boo, but don't spoil it for us. Arr, arr. All right. Thank you for telling me. Hey, Jason, let me give you a little tip. Did you verify your account in Discord? You just got to click the green box with a check, click on it, verify it. Then in members chat, that's where you put that kind of stuff that way. So it's okay now. Just don't put verdicts. We don't want to know verdicts. We'll be in verdict watch. We'll monitor everything. Oh, no hate. No hate. Just teaching you. Just teaching. It's okay. We have to teach everybody. So you've got a section called members channel, and it has breaking news. That's where you put the breaking news information. And just below that's called chat. Go ahead and put your comments like that in chat. Now, if you want me to go see it immediately in here, you can say Ada to chat. Ada, breaking news. And then I'll go over that. That's okay. We'll teach you. It's really a good thing. It's a good thing. I'm new to Discord myself, and I've become addicted. But we're all good. I have Court TV up and running, but they haven't said anything. I have it running, so I don't know why you're seeing it. I'm not. Because right now they're playing the Daisy trial.
This one in particular is a duplex where
Love you, Jason.
Recited.
Okay, and this is the drawing that Ms. Link made?
Yes.
Okay, can you just walk us through exactly what Ms. Link told you about this and mark where she was standing and where the victim was standing?
Yes, so she says she was sitting here on the porch where the staircases. The gun was directly next to her. The victim was standing here in front of her.
And there is a circle at the top of it. What was that?
This is where she said the victim ran towards this way and she shot the firearm when she was approximately by this circle.
Okay. And there's like a little line right next to that as well. What's that?
That's where the victim continued to run.
Okay. Did you find a casing ever?
I did not.
Do you know if anyone found a casing for this firearm?
To my knowledge, nobody did.
Now, while on scene, and I've moved to. This is a demonstrative. Just preserve it for closing.
Come here, baby girl. She's all like,
Now, while all this is happening, you're interviewing Ms. Link. Are officers still on scene at that 1237 address?
Yes,
Why?
they are still conducting their part of the investigation, which is the scene, the body, whatever portion everybody was assigned. Sorry. They were documenting they were documenting the scene, the body. They were still conducting their investigation on scene.
Are you aware if canine officers responded to the scene?
Yes, they did.
Are any other detectives on scene as well?
Yes, our homicide detectives on scene.
And that would have been Danny Morales, Yapa Hubbard, whatever other officers were on scene?
Yes,
And are you guys speaking while you're interviewing the defendant?
yes.
Why are you doing that?
They're relaying information that they're finding on scene that's relevant for us in case they have any questions that they need us to ask Ms. Link.
What, if anything, did they tell you was going on scene?
They found a,
It goes to state of mind, effect on listener as well.
they advised me that they discovered a Ring video camera footage where Ms. Link made a statement on it. Yeah.
what? Well, I don't think Discord themselves may be under investigation, but the use of Discord between persons who committed the crime may be under investigation, but I haven't heard that. Interesting. Sorry.
Permission to publish evidence previously admitted, Your Honor?
Oh my God. Eddie love it going on. Ooh. Here we go again, y'all.
Now, that video that we just watched as a portion of State's Exhibit 16, is that the video that was relayed to you?
Yes.
And did you relay that video to Ms. Link?
Yes.
What was her reaction to that?
She said that she did not say that.
Now, do you know when exactly, or a rough estimate of when that incident occurred?
That was approximately 10 minutes prior to the 911 call.
Okay, so there was a 911 call in this case as well.
Yes.
Did officers learn who made that 911 call?
Yes.
Who made that 911 call?
Ms. Link.
And permission to publish, what's the name?
Okay, guys. Sorry, that was my food my daughter, she was going to work today, and then she, what's the word I'm looking for? Well, what's Soxy? What's Soxy? Really? Oh. So anyway, oh, that's not what I want. She started leaving. Why is that? That's not what I want. She went to go to work today, and their entire water heater broke down, and so unfortunately they can't work. So her business is closed for the day. I mean, it's kind of cool because she can turn around and she can be here earlier. We're getting ready to go dress shopping. She's got a wedding to go to. Oh, thank you. And oh, thank you, baby girl. What, you want to get up and fold? Oh man, I was getting all cozy and warm. Oh, see if they were getting all nice and warm. Uh-oh. Okay. I'm getting a dispatch from the fire department, but I can't go. So anyway, the business can't open at all. Okay. Jason, where did you post it in breaking news? I don't see it. Not in our group.
Playing now.
But I'll Google it.
Saturday, June 25, 2022, 03:21 and 57 seconds. Are you ready for anything to fire? What is the emergency?
I don't know why I just hear a guy screaming and then around and just blow everywhere.
Okay, stand on line when you're going to check your phone to see where you are.
Okay.
Do you know what happened to him? Stand on line with me. Is he awake and breathing? And the says here at 1300 1858. Stand on line with me.
Where?
I'm going to do a breaking news real quick.
Joint Base McGuire-Dix Lakehurst. The facility was on lockdown this morning. We are just hearing word there's all clear. At this point, it's not clear why the lockdown was placed initially on this, but let's take a look at this new Facebook post from the base. It says all clear, all clear, all clear. So just around 11 o'clock this morning, the Joint Base McGuire-Dix Lakehurst was placed in lockdown. For those of you that aren't familiar with the base, it is huge. It spans more than 20 miles, spread out over 42,000 acres in both Burlington and Ocean counties. The Lakehurst portion that was the most recent one where the lockdown was lifted is in Ocean County. Let's get a live look right now from Chopper 3. We just spoke with Ocean County Sheriff, who says there is.
Okay, so right now all is clear. So we'll go. We'll dive into that in a minute.
What is the phone number you're calling from? 7656095939. Correct.
Before we move on with the rest of the call, that phone number, whose phone number was that?
That I don't know.
Did Daisy Link give you her cell phone number?
She did during the interview. She did.
Have When you get home, then release on the line as well. Violence is already confirmed. Do you know what part of his body he entered or?
I think it's inside there.
If you have a clean dry cloth or towel, apply pressure to where it's taken from. I know that is a Friday, please. The address is Adakay. She lives. The address is 1300 not 1153. She's alleged that she found a nail down on the floor, bleeding all over. And curious to see if she can look and see where his blood, the blood is coming from. She said that they know what happened. I have her on the line.
And do you have the contact number just in case?
She's calling for 786-562-9539.
And where are you sitting today?
I'm in position 1502.
And what about, and I'm running here, right?
Yes.
Okay, perfect. Thank you, County.
Yeah.
Ma'am? Ma'am? Hello? Okay, you said it looks like he's by the alleyway? He never sees an alleyway. Is he breathing? He's breathing, he's saying that he can't breathe. Okay. About how old do you think he is? I don't know, maybe 30, 25, I don't know. So between like mid-20s to maybe 30? Yes. Is he able to tell you anything, like when it happened or anything like that? Hello? Yeah, did he tell you? What happened? No. He said he doesn't know. He doesn't know? Okay. Police on the way, I'm the ambulance on the way, just stay on the phone with me, okay? And you said it looks like it's mostly from his legs? Hold on, I'm trying to start right now. I think it is. Hold on. Let me see. It is. There's a. Hold on. I see an entry. Hold on. One. And I see an entry.
Was he shot?
It looks like it is. Yes. He's bleeding off of his leg. I can't pick you up. I can't pick you up. So just let them know that help is on the way, but you can't pick them up, okay? Just let them know that help is on the way. I agree.
Ma'am, were you able to get a clean dry off the towel to apply pressure? And then
I took his shirt off and I tied it around his leg.
you tied it around your head.
Hey, hello, hey, Delvin, are you okay? What the fuck happened?
Is he still breathing in?
Yeah, hey, he's breathing out. Or not yet. They're coming through now. I see I'm coming through now.
Just let me know when they make contact with you, okay?
Yeah.
Do they see you?
Hey, down here, right here, down here. Hey, down here. Hello, down here, hey.
That's you. You're the way?
Down here.
And you see the
Down here. I see him here. Down here. Down here.
And you can still
They're here.
Okay, ready? I'll go ahead and finish. Okay, thank you.
Saturday, June.
Detective, did investigators find out who made that phone call?
Yes,
Who did?
Miss Link.
Now, after Daisy Link admits to shooting Pedro Jimenez, what, if anything, did you do with her? Was she under arrest at that point?
Yes.
And I know we talked about this briefly before, but that body warrant, the DNA warrant, that was executed as well?
Yes, it was.
Did you author any other warrants at that time?
A ring search warrant
Why?
to obtain video that was captured on the ring camera.
And to be clear, that warrant was through the same process that we talked about beforehand?
Yes.
The video that we saw a few minutes ago, that was part of that warrant?
Yes.
There's a few other videos that I want to show you and ask you if those were also part of that. This would be part of State's Exhibit 16.
Yes, what do you want Yep. Get on my YouTube. I can't. My YouTube is different, so I can't access that. I'm sorry, dude. I'm working on it. I don't see community on mine. Why not? I don't know what they're watching. I don't know why I can't see the community on my channel. I have videos, short, 5 podcasts, playlists, post memberships, and store. I'm working on it. Thank you, love.
With a person exiting that vehicle, multiple people exiting, and small children involved as well. That was part of State's Exhibit 6, or excuse me, the ring camera that you executed?
Yes.
Wow.
Why not?
I'm not going to sit and listen to air all day.
That video where we see see an adult male walking back into that vehicle, go through it a little bit, and then leave. Was that part of the video or the ring camera warrant that you also executed?
Yes.
Now, after you arrest the defendant, is that where the investigation ended?
No.
Why not if you've made an arrest?
In the homicide investigation, there's a lot of moving parts, and we conducted a very thorough investigation. So now it's going through the defendant's statement and then proving or disproving things that were said in the statement, ensuring that we have all the physical evidence and the facts correct to back up everything that occurred.
Did you yourself speak to additional witnesses?
Yes, I did.
And that was after the fact?
Yes.
Did you respond to 1300 Northwest 15th Street?
Yes.
Did you meet with the homeowner?
Yes.
Was that Robert Cisneros?
Yes.
Were you with anybody when you responded to that scene?
Yes. Detective Danny Morales and Detective Chiapa Hubbard.
Why did you respond to that scene?
To gather video surveillance footage.
Okay. And did you watch that video surveillance?
I did not.
I don't want to talk about any of that specific surveillance, but what I do want to ask you is, did you see anybody cut any wires, delete anything?
No.
Going back very briefly, Detective, this is a silly question. Do you have a personal cell phone?
Yes.
Does that have reporting capabilities?
Yes.
When you are investigating a crime, do you take out your phone and report things on your phone?
Absolutely not.
Why not?
Because my personal phone is my personal phone. It is not subject to anything that I do that is work related.
Do you have standard operating procedures that allow you to use your cell phone?
For my personal cell phone, no.
So it'd be fair to say you are not allowed to do that.
Correct.
Is there anybody that you reach out to in order to gather any kind of video surveillance evidence as well?
Yes, we have a video forensics unit that is certified and takes specific trainings in retrieving video surveillance footage.
If you have the capability to record something on your phone, why are you reaching out to them to collect evidence?
That would be the proper way to do it. These individuals are trained. They take trainings how to properly extract video and maintain its integrity.
Now, Detective, I know you weren't here, but Danny Morales and Ciapa Hubbard and yourself all wore suits while you testified. Why are you not in a uniform?
This is my daily attire for work.
So as a detective, a homicide detective, you are wearing a suit as your uniform?
Yes.
Do you get body-worn camera?
No, we do not.
Why not?
That is simply only assigned to road officers.
Showing defense counsel has been pre-marked for identification purposes as states 2E. Yeah.
All right, we're gonna take about a 10-minute coffee break. It'll be a coffee break. The video that will be played is about an hour and a half long, so just be prepared. If you need to take a coffee break in the middle of that hour and a half, you can do so. You all will just raise your hand. Just so you know what's coming after this is now. Okay, it's the video that will be played.
Judge, can I just move it inside?
All right, so the jury.
I'm sorry, real quick, we move this evidence, let's just have Green mark it.
State moves into evidence with some pre-marked for identification purposes is 2E.
State exhibit 2E, marked for identification, now becomes state exhibit 28, Judge.
Thank you, that has to be said on the record, in front of you all. All right, we can go back to there.
I can't pull it up, Jason. I've sent Discord to my mod watch.
Thank you. No, I do not.
And FYI, live court TV was on break as well. So we're going to pop over here. I'm going to read this to you. I don't see anything new. I'm looking, guys. On my YouTube, I'll share it so we're at that point. See, I don't have community. I don't even have it up in my pads here. I don't have community, see? I don't know. Explain to me why I don't have it. I mean, I literally don't. I guess I won't be able to see mine. Okay, now we're back.
Are you sure you don't want to go to the hospital? I have nothing further on.
Some of the last words from the defendant, Daisy Link, to her boyfriend just moments after she shot him in June of 2022.
Let's go back.
Brady, in this video, it's a lot more clear when I watched it, but it talks about hitting a major artery. It talks about Daisy Link saying, "You'll be fine," and then asking, "Are you sure you don't want to go to the hospital?" I have nothing further on.
Okay, we're going to go back over here. Let's bring their break. Those were some of the last words that her victim spoke. I guess that's why. It's okay. Get a blanket. I'm cold. I'm hot. I'm cold.
Members of the jury, you are about to view and listening to a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that do not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and listen and consider this evidence. Go ahead, Mr. Rubio.
Thank you, Your Honor.
Yes.
Yeah, I'm here, y'all. No.
I just want to briefly pause here at 42 seconds to stage 28. We saw Ms. Link enter and she has these brown paper bags on her hands. Why?
That is to preserve, because she touched the victim, is to preserve if there was any gunshot residue.
I've got a question. Are y'all hearing this as loud as I am? Do I need to gain it up and turn me down?
So you can change and then put it back, okay? If you need to get off the,
just a heads up, we will be viewing the actual scene where he was shot. We will be viewing that in a minute. I mean, they stripped his butt naked. Poor guy. It's blurred. I can visit community here.
We're gonna take it back, hold it, and put the clothes on. And you wanna keep clothes on the blood, we can't get take off the shirt. And you can do the stitch. If there's no blood on the shorts, then I gotta see, but I don't want to be blood. Can you stand there and take pictures, please?
Do me a favor, listen to my instructions. Just use that, I'm gonna take a photo of you, okay? Very simple.
You're not gonna dress in front of me.
Why are you guys shooting hands if I know this?
I'm not like, you're blood all over me.
Why are you having these pictures of me like I did for?
Daisy, I'm taking pictures of you because you have blood all over you and you're gonna use. You're losing your hair.
That is in the car accident. I don't
So
know
that's
that.
fine. Let's take pictures. We're gonna take pictures. You're gonna do something to your hands.
Okay.
And then you're gonna change your clothes so you can have not bloody clothes on. I don't want you to sit here and clothes is clothes on. Right? You know what I'm saying? There's no sense in you sitting here with clothes on. With a monster.
I'll do a favor, look towards this way, so we can decide what we want to do. And then just look the opposite way. Look straight ahead. And you can face the wall. Okay, you can face me. Aside from that, but I see where you have some kind of mark here. Do you have any other mark anywhere? Do you know?
With the phone. My kitty. Hey, G14, how you doing? How you doing, love?
That boots that you have there, you can just lift it.
Hope you're having a good day at work, boo.
Because you have been on our care, correct? You have been in our care, right? So there's no confusion later on down the line, or take pictures of the injuries you already have, so later on someone doesn't say they were caused while they were in our care. That's the only reason. No one's denying anything at all. Okay? No one at all is denying anything. That is the reason why we're doing this. Okay?
So aside from that, is there any other, do you have any other injuries that you know? No worries, no worries. Do me a favor, just put your hands together like this. And then just put them together like this. There we go. Can you take a deep breath? And 40.
Sorry, I had to use the bathroom and I needed coffee. This is my partner, Joe. Did you meet him already?
No, I said, I know that you said in that video, well, let me ask you this, to be clear, that's you.
Yes.
And you said this is my partner, Joe. Is that Joe Cruz that we were talking about earlier?
Yes.
The lead detective in this case?
Yes.
Thank you.
I'm sorry for everything that you're going through right now, Casey. And I'm sorry bear with me, we're just giving you all your information and misinformation. Kids, everything. What's his date of birth?
8714.
And you said that you guys another son?
Yeah.
Zero. MIA?
Detective, the 911 call that we listened to earlier, which I believe is State Exhibit 1, in that, whoever the person who made that phone call, they said that the victim in the case had an injury, but they weren't sure. Is that correct?
Yes.
Ms. Link just gave an actual date of birth for the victim, though. Is that correct?
Her son. She gave the date of birth for her
I
son.
apologize.
What's his last name as well? How old is he?
She's sick.
What's his birthday?
She's 24, 16.
Does anyone else live with you guys? Just you guys.
So we just me and the kids. He's always on the road. He comes on like 4 days, 5 days out of the month.
And how long have you guys been living at that address for?
So he works alone. When we stay home, maybe we stay home, maybe quit my job and everything. So I decided to stay home with the kids. My son is ADHD and don't know his eyes, so
Where did you work at before you did that?
logistics coordinator.
Logistics coordinator? Oh, wow, so you're doing what? All over. For what company? Silver base?
So I just work at a shipper in the United States.
Oh, wow. That's in Lexington?
Around state, around, yeah.
And how long have you looked at the shipping market? That's it?
Yeah.
How long have you worked there for?
3 years, 4 years.
What high school did you go to?
Something.
Really? What do you think you're better at?
I'm easy when I'm 16.
Oh,
Something college.
so you left something? Did pay you go to something too?
Lisa, he did.
Yeah. Where did you guys meet?
Taking up on the 2017 with the permanent, and he drove her to pick me up. And then I
Hold it to that, right? Hold it to that. I want to make you relive that situation over and over again, okay? Where did you guys live before you guys moved to this house? 5 years ago, where did you live?
if you remember the address of the house across the street from work,
Question about Mark. Was it in Homestead as well, or Forest Street?
just leave the room says,
Okay. And he's always been a trucker. How long has he been a trucker for?
about 3 years.
Detective, you just asked the question before you both lived at the address. Who are you referring to?
Miss Link and the victim.
Did Ms. Link deny living with the victim,
No,
that the victim lived there?
no.
Thank you.
And what did you do before that?
He passed, he was drugs and stuff like that.
I just want to just stay there. I will feel comfortable. Issues, okay? So, this is some subjects. Yeah, what?
Before we move on, Detective, you asked a bunch of questions about the defendant's children, where her and the victim lived, a couple other things, how they met and things like that. Why were you asking those questions?
Those are preliminary questions that we ask.
Is there any specific reason to get some background information or anything like that?
Background information as well to know, at that point, we were aware that the children were in the residence at the time of this incident, and that's something that we need to document.
Thank you.
Do you know what it amazes me? And I'm sitting here thinking, going, I can't believe that when you have surveillance camera videos that are going to be used in a court of law to potentially convict somebody, this is the quality that you get? Really, Boo? Look how washed out that is. It's black and white. I get it. But these people, I mean, these departments get grants and everything for maintenance and updating of technology. Why in the hell have you not updated your camera and audio system? Just saying.
So, and we're gonna go over your rights again. And of course, we have to talk to the friend over your rights again, okay? It's gonna be the same form. I'll read it to you.
The audio's so bad, the captioning said, we're going to go over your legs again.
Again,
Funny.
and we'll go over there, okay?
I wish I could zoom through this, guys, but I cannot because we are at their point. So we're just going to have to sit and be patient, y'all.
Their mercy?
Hey, G14, I hope you're doing well. I hope you're enjoying your job. I hope it's going well. Thank you for listening in the background while you work. I greatly appreciate it. That'd be a crappy place to be, y'all. Have any of us ever, you don't have to tell me, but rhetorical question. Have anybody of us been in that situation where you're sitting in a room, you know you've done, not necessarily a police office or interrogation room, but you're sitting there and you know you've done a bad thing and you got to sit and wait for the crap to hit the fan. Here, I'll mute that. Isn't that just the most horrible feeling? Gut-wrenching feeling to just sit there and know that the crap is going to hit you and it's going to hit hard and there's nothing you're going to be able to do to stop it, boo, because you've done messed in your nest. Miss June, how you doing this afternoon? How you doing? G14, thanks for joining. Amy, thank you for being here. Thank you, thank you.
Detective, we just heard the defendant whisper to herself, "I killed
Y'all,
him.
I have Miss Diane on.
At that point in time, had the
Instagram.
defendant made a confession of killing
They
Pedro
can't see
Jimenez
you, boo.
No.
to any detectives?
No.
But she could hear that. Oh my God, it's horrible. The audio video on this is the most horrendous thing. And it feels
What's
like
up?
you're going shh in my
What
ears.
what is
It's
that?
video surveillance of the defendant in a holding cell or an interrogation room.
Well, they noisy. I can give them that.
No, it's the static. It's them turning it on and off. It's just like brutal. All right, Miss Diane, I guess you can't join us, but we'll see you later.
Get rid of that. Get rid of that. There.
Did you hear me?
Something about laters is all I got.
Yeah, I know you can't join us, but we'll see you later. Love
Oh,
you. Thank you.
I love you
Join us
too.
when
I
you
got
can.
to do some billing.
Oh, joyful. Now you can.
Oh, me, I really can't because I'm not billed nothing for this session.
Okay, go bill it. Bye, love.
All right.
The Wi-Fi network. You might
Oh, for the love of God. For the love of God. Oh, today, y'all, is Mental Health Awareness Day. And look, we're watching.
First time the defendant ever admitted to killing the victim.
Yes.
Okay, so a few minutes ago, you knocked on the door and said you wanted to talk. Okay, so and we're gonna go over your rights again. And because we have to talk to, we're gonna go over your rights again, and then I'm gonna go over your rights again, okay? It's gonna be the same form. I'll read it to you again. And we'll go over there, okay? Okay, so if you're asking any questions, you must understand the following rights. You have a right to remain silent and you do not have to talk to me if you do not wish to do so. You do not have to answer any of my questions if you understand this right. Should you talk to me, anything which you might say may be introduced into evidence in court against you. You understand? If you want a lawyer to be present during questioning at this time or any time hereafter, you are entitled to have a lawyer present. Do you understand that right? If you cannot afford to pay a lawyer, one will be provided for you at no cost if you want one. Do you understand that right? present. This statement is signed of my own free will, without any threats or promises having been made to me. Do you understand what that means? So you're gonna sign right here. And the date is 6/25/22, and it is 4/22 p.m. I want to verify your phone number. What is your cell phone number? I'm 60. And you have that with what carrier? And what kind of phone do you have? An Android iPhone. And to your phone? No one else uses it besides you? Okay. Watch YouTube. Okay. Just to clarify something, because when we went downstairs to do the fingerprinting, you told me that you didn't mean to do it, that you were just trying to scare him. What did you mean by that, and who were you speaking about? Okay, Pedro. And what did you mean by you didn't mean to do it? Just wanted him to stop hitting me. So I grabbed his gun and I shot it, but I didn't aim it. Nothing, I didn't mean to hit him. I just wanted to scare him, I didn't want to scare him away. So let's rewind a little bit. Okay. How long have you been dating for? Last month made 9 years. Last month made 9 years? Okay. And both of your kids are his? Yeah. What was your relationship like? I loved him so much. I don't know why I was just never enough for him. I could never leave him. I couldn't have friends. I couldn't have any social media. I couldn't have anything. I was isolated for a very long time. Why were you isolated for a long time? I wouldn't let me. I wouldn't let me. I was very good. I didn't have friends. I had to stay in the house all the time. Couldn't talk to anybody except for my mom, maybe. I tried to leave before, but all I did was wreak havoc on everything. And what's your relationship with him always like that? No, not at first. He's a different person. He's on drugs. Every time he would come home, before it was always dead because he was with him every day, when he worked here. But when he would come back after 3 weeks or a month, he would be anywhere from 4 to 7 days. And he would just get strung out the whole 7 days on cocaine. Did he use anything else? Cocaine, marijuana, butter. That I
like 4 or 5 days ago. Did you report that? You were in the hospital. I was in the hospital, but they started asking me a lot of questions. I got scared and I got. I went to the hospital, but before I got a chance.
Detective, briefly, I just want to back up from the statement. We heard Ms. Link say that Pedro did not let her have social media. Is Facebook social media?
Yes.
TikTok?
Yes.
Instagram?
Yes.
Thank you.
I actually go ahead and say how they said that they said they have a MRI or something done. Family brain. Did they register you? Did they get your information and stuff? What hospital is it? Thompson Hospital. You said a couple days ago, you remember what day? My mom flew down the very next day. So I'm gonna say 3 days ago. She flew down to try to get arrested because I wouldn't do it. She even said, he said they better say he's going to get it. He's always on this to you. And where were you when he gave you that? I was out with my cousin David. And he had David too. At the house? At your house? What's David's last name? Perez. Do you know his birth? No. He's a white man? He's dark. He's Puerto Rican. Okay. Do you know where he lives? Not exactly. He usually comes down. That was the first time he's ever been in my house. So he's seen me since we were kids. And he's your cousin? I have no idea. My mom's brother's son. And where did Pedro hit him with the gun? His face. He was trying to push him off me. And Pedro turned back and he hit him with the gun too. And David didn't report it either? No. How old is David? David is probably about, let's see, like 29, maybe 30. This house that you live in now, where we're at, how long have you lived there for? 5 years. 5 years? Walk me through yesterday, Friday, so today's Saturday, Friday. What was going on with you guys yesterday? Let's start from the morning. Has he been, well, because I know you told me that he travels a lot with his job. Yeah. Okay, how long has he been home? He was supposed to leave tomorrow. He was here for 7 days. Because he did the month. He was supposed to leave tomorrow on Sunday. So when did he get back from his last work? Coming out there, when did he get back? Last Tuesday? Okay, so today's yes, I was talking how long was taking on last. So he got back last Tuesday. Yeah. So he's been here about a week already. Yeah. What's he? When he comes back now, he'll write for whatever fucking reason. And he literally fabricates it in his head and actually believe it. He would believe he had a severe mental disorder. I know he did. I know he did. Nobody normal would do shit like that. Nobody normal would make stuff up in their head and actually believe it. What do you make up? What do you mean by that? Like, he would tell me how all of the fucking sweat I'm cheating on him. Or I'm a fucking warrior, I know. Cheating on him. Oh yeah, I know that you've been taking naked pictures of yourself. Bullshit stuff. And he would just continuously say it over and over again. And he would get mad and be like, yeah, sending these fucking niggas pictures and shit. Hey, you know, stupid bitch, yeah, I know what you're doing. I know, like, you could genuinely tell he didn't believe the shit he was saying. You could tell he did. So he would just leave sometimes, take the truck to his dad's house. And then he would have maybe his friends pick him up from there. And then if I was at bars, do whatever he was doing. One of the nights he told out to come home. 1 in the morning, and whenever he would get home. Northwest, Florida. So that's what he would say was the same with you? That's where he would go to school. That's where I used to go to school all the time. Okay, so Friday yesterday was the other day. He was with his friend. He was with his friend's house. Okay, and then I remember I drove by the fence and my sister's house and my mom. Do you remember what time that was? I don't know, 5. In the afternoon or the morning? Afternoon. My mom flew now, so she went to the cement and my sister because my mom takes care of my sister's kids. And she's very sick, she's big, she's a to go see her. Then we went over there, and then, just talking, shit like that. We were supposed to do a barbecue in my house there with all my sisters and stuff. Then after that, I went home, I had to go home. I went home, and then it was about maybe 10 or 11 o'clock. And then he said, at this point, you were home alone with the kids? Who was home? I was home. Okay, and what were the kids? The kids were, so you, your mom, and the 2 kids were home? Yeah. Okay.
They will be.
After that, I went and I picked them up. Well, where did you pick them up from? Friend's house. Do you know the address? No. I just know it's, well, I'm the street behind Homestead now. Sorry, I don't know the precise address. And what's his friend's name there? Manriquez. Manriquez? Manriquez. Is he white or not? He is white, he's fine. Okay, and how did you know to pick him up from there? Because I knew that he was over there. Before he left, he was with, it was him, I mean, the brother, and a couple of other, when I see that group of people, the group of boys there, I know he's forget. But where did you see him with these people? At their house? Well, first they came to my house. Okay. And then they went to their house. Why did they come to your house? I guess he was, his mother, I don't know. So he was home. I don't want to say your house then, because you told me you were home with the kid and your mom. Yeah, that was when I got back. Okay, got it. Okay. And then after that, I guess we're gonna go back, we're gonna go a little bit to the, because I know he's kind of drunk on the back, and he was just on the phone and shit. Did he ask you to pick him up, or you decided to go pick him up? I decided to pick him up. Okay. Wasn't an issue. Okay. I picked him up, he was going back, okay, and I'm not even. It was one. He took it on the side, so I went inside. And he said, oh, I'm coming. He's drunk on his ass.
Like today can't end quick enough with this video. You know what I'm going to do? I'm going to let this play because it's so horrible. I'm going to mute it, let it play. We're going to hop on over here and watch what they have. It's much more understandable.
Do what you got to do.
Myself, 54 and 41 road.
Don't move. Do not move.
Units arrival at 327, all units check.
Hey, what's going on, man? I see a hole from the back and a hole from the front. You were shot in the I took off his shirt. Is he related to you? No, he's actually my husband. Oh, okay.
I thought they were divorced. I'm confused.
Where is it at? Right here. And you can see all this from the front. You can see the hole from the front. Hey, just stay right there, boss. Are you okay? Hello? Stay with me.
439.
It appears to be a GSW. It's going to be into the right leg, into the right thigh, and out the right thigh. No, hey, just stay stay down, there, boss. stay down, Hey, lay on your back, please. Hey, stay on your back. Stay down. Stay down. Go in my trunk, grab a...
He's probably trying to get away from the one who shot him. I eat her.
Right there's my trauma kit. Grab me gauze and all that. Pedro, what the happened? Pedro,
What did you do?
Where's the ambulance? They're coming, Mama. They're coming. Look at there's a lot of blood there. Open it up. I got my hands are dirty, bro. Grab me two. There's more. Check and see if there's anything else. We're gonna have to cut off this stuff. Just cut it off. Do what you gotta do. Just sit down, bro. My hand.
439 is hard arrival.
What's the best way for to come through? Hey, are you okay? Pedro. Hey. Hello. I don't see you. I'm in the alleyway.
Somehow get from your tail. Units for.
Pedro. Pedro, stay with me. Hello. Look at me. Pedro. Hello. Look at me. Are you here? Are you with me? Pedro. Hey, boss. Oh my God. Let me see, Mama. No.
The skin is changing colors, y'all.
He's all right. He's still. Pedro. No. Hey. Mama, I need you to relax. I need you to calm down. Give me a second. No. Pedro. Hey, put pressure on that. Edwards, put pressure. Hey. Pedro. They're coming. Hey, I need you to calm down, Mama. I need you to calm down.
What's the GSW at?
Right there in the top.
Pedro! Hey, no, hey, look at me, please. 439, please. No, Pedro! Pedro, hey, look at me, please.
Pedro,
Pedro, I need you to get up. Pedro, please. Pedro, please. Where the is the ambulance,
They're
please?
coming, ma'am. They're coming.
Hey, stay with me, please. Pedro, please. Pedro, please, stay with me. Oh my God. No. Pedro, please.
Don't push.
447. Hey, no.
Ma'am, I need you to back up, please. I need you to back up. Back up, please. Pedro. Still got pulse. I hear fire. Where are they?
Sounds like on 50th Street.
Is he okay? Is there a pulse? No! Pedro, please!
Ma'am, I need you to back up. Pedro.
All right. Warning. Content warning. You are going to hear and see some very unsavourable sights. The gurgling you're hearing is the air expiring out of his lungs. I mean, yeah, that's bad.
Don't give up, buddy.
No, please, don't let him go, please. What the
Ma'am, I need you to back up.
Please don't let him go, please.
Back up, please. Pedro.
147, I can't reach you.
Just tell them we were starting CPR.
Got a pulse?
Hey, did rescue see where we're at? I heard the truck. No, I heard the truck. The truck should be on that side.
Yeah,
Try to run up to them and guide them in here.
Pedro.
Oh my God.
Pedro. Come on, Pedro. Stay with me. Yeah, relax. There you go, Pedro. Come on.
Don't give up, Pedro. You got this, bro.
Come on, boy. Hey. Pedro.
454 for fire, they're showing arrival.
Pedro.
I'm waiting now. Kids on fire arrival, the mail at 333.
Pedro. Ma'am, I need you to back up, please.
You have a pulse?
Yes, relax. Back up.
I need you to relax. Look, come over here.
Pedro. Hey, boss. Need you to tell me what happened? Pedro.
Who did this to you, bro?
Come on, Pedro. Pedro. Hey. Pedro. Pedro.
No, does he have a pulse? Where the is rescue? Where the is rescue?
Hey, he's got a weak pulse. GSW to the right thigh. It looks like a through and through.
What? No, I didn't. Oh, that's really he left about 45 minutes ago. My house. I live down the street.
She just confessed right there that she did it.
No, I didn't. I saw him laying there.
There's a pretty large blood test. She got other units response.
Yeah, she found him here.
Like laying here like this?
Yeah. When I got here, this is where he was.
I got no pulse.
Edwards, I'm gonna follow it down.
Okay.
433, 423. 433, that's all. Both units arrival, 33, 15. Right, 447. There is the alleyway that runs in the large little tree. If you can have this area. 23 reference. Right, units are started moving off the area just in case.
Yeah.
And we're gonna need to find out.
Back her up. Come on. What? Just have her back. Where she live at?
Just start roping off the area.
Let's start roping it off.
Just all units to start roping up the area. Find out the LZ. 23, I'll work on LZ. Have a unit trying to rope off the area.
You got safe?
Yeah.
Unit that's roping out the area.
Hey, Chevy. Pull my car back. Pull my car back. Pull it back. Pull it back in this open spot for now.
Open it?
Yes, I'll open it.
Go ahead.
I'll show you assisting in arrival at 336.
Hey, get it back to the opening, Chevy. Watch your feet. He's backing up. Go ahead, Chevy.
So show me this one around. Northeast 12 right now.
Watch out, LT. He's coming back. Let me see if I got one in my car.
Can you show me a knife and I'll be around.
Charting route 157 North 8th Street, reference four males that were previously arrested. No weapons. 454. 347.
Apparently he just walked around the house.
Bro, he didn't just walk around the house, bro. He walked all over there.
Yeah, there's blood all around the car.
Bro, there's blood everywhere. There's blood in the SUV.
Oh, there's an SUV over there?
Yeah. Hey! Kern! Is rescue out there? Is rescue out there? Can you get their info? for the last several hours. At one point, she said about, last time she saw him was like 45 minutes ago when he was walking in circles all over the street. She said earlier today he left in a white van. I know make a mom, I don't know if it's a passenger van or a work van. She said it was a white van with a couple of his friends. When he got back, he seemed agitated. That's when he started walking around in circles, walking all over the place. And then she didn't see him for about 45 minutes, so she started driving around. That's when she found him back. That's all his info there? Yeah.
You know, Judge, it's interesting because I'm very sensitive to domestic violence claims. It's clear that there was some domestic violence in this relationship.
Yeah.
But seeing this video, it's having a little bit of a different effect in terms of what happened that night anyway. What do you think?
Well, there's not a lot on that video that does make me think or believe it's domestic violence other than her own words. And part of my concern for her defense is her behavior when they first get there and she's kind of leaning over him, and then as it progresses and she gets exceedingly emotional, makes me question if it was really self-defense. I think if it was self-defense, she wouldn't be that calm. She'd be freaking out a little bit.
Yeah, there's a calmness there. There's an approach to the situation by the defendant that belies that claim that she was, you know, in fear for her life. But there's another part of me that says, you know, again, we talk about this many times, you know, judging people on how they respond to tragedy or how they respond to threats is difficult, you know, when you talk about someone's liberty being taken away. So there's more we need to see. But this certainly raises questions.
And you're right. You can't tell what you would do in a situation, what they are doing in a situation. You're absolutely right. I think we now have defense attorney, former prosecutor Bob Bianchi to help break all this down. Bob, tell us, I mean, body cam video, best evidence, right, of the scene, of her demeanor. And I think her demeanor is going to be a huge part of this case for the jury.
Gosh, I was hoping you weren't going to ask me an open-ended question because I was unable to listen to that while we were trying to get ourselves hooked up with the technology problems. But in general speaking, Judge, body cam, like I always go back today and think about, gosh, I wish I had this 30 years ago when I was trying murder cases and we had no DNA capabilities and no phones and no body cams. Yeah, the demeanor is so important because a picture is worth 1,000 words. And let's be honest, I mean, when I look back on it today, 30 years later, there was a lot of creativeness in terms of how people testified when they would testify about somebody's demeanor and how they were acting. I myself, as the prosecutor, when we would investigate a homicide case, I'd be listening to someone telling me how the demeanor of a person was. But then when you saw it on video, I had a different opinion than the person who was interpreting it for me. So I think that these things are just tremendous insights for the jury not to have to listen to how someone else viewed how the person reacted, but literally to see it themselves. When I first started out, if I may use an example, who would ever confess to a crime they didn't commit? Well, the fact is, it happens, and it happens with a greater degree of frequency than we would care to believe or admit.
That's true. For me, just speaking of myself, gentlemen, with age comes wisdom, that I'm now able to have that perspective, because I did not have that younger either. I would say this is what they thought, or, you know, whatever it was. Okay, let's do this, Bob. We want to show a little bit more. This is of some of the bloody items. Let's take a look at this together.
Traffic warning.
Where was there also blood-stained money when you photographed in the alleyway? Where was also money?
There was also a blood-stained bill on the alleyway pretty close to where the victim was located.
And were these the items that were located in the driver's side of the vehicle detector?
Excuse me. Yes, those are the items.
And this credit card, whose name is on it?
The victim, Pedro Jimenez Gonzalez.
All right, if we're looking at self-defense, domestic violence claims by the defendant, and you hear that there was a blood-stained bill, a blood-stained credit card belonging to the victim, does that give you enough to start painting any kind of picture in your mind, evidence-wise, or not really?
We're going to go to a part in her testimony here. She's getting to a part that she's calmed down. She's more understandable.
He was all the way to my cousin David, and David too. And you're in the house, and
your house? What's David's last name? Do you know his date of birth? No. Okay. He's a white man? He's dark, he's Puerto Rican. Okay. Do you know where he lives? Not exactly, he usually comes down. That was the first time he's ever been in my house, so he's seen me since we were kids. And he's your cousin? No, not you. My mom's brother's son. And where did he hit him with the gun? His face. He was trying to push him off me and pick him up, turn back and he hit the gun to him. And David didn't report it either? No. How old is David? David was probably about, maybe 9, maybe 30.
Do we have sound? There it is.
This house that you live in now, or how long have you lived there for? 5 years. 5 years. Walk me through yesterday, Friday, so today's Saturday, Friday. What was going on with you guys yesterday? Let's start from the morning. Has he been, well, because I know you told me that he travels a lot with his job. Yeah. Okay, how long has he been home? He was supposed to leave tomorrow. He was here for 7 days. Because he did nothing wrong. He was supposed to leave tomorrow on Sunday. So when did he get back from his last work? Coming out there, when did he get back? Last Tuesday? Okay, so today is yes, I'm talking how long since you thought I was taking last. So he got back last Tuesday. Yeah. So he's been here about a week, right? Yeah. What's he? When he comes back now, he'll run for whatever fucking reason. Could be anything. Literally, he fabricates shit in his head and actually believe it. He would believe he had a severe mental disorder. I know he did. I know he did. Nobody normal would do shit like that. Nobody normal would make stuff up in their head and actually believe it. What would you make up? What do you mean by that? He would tell me how all of the fucking sweat I'm cheating on him. Or I'm a fucking warrior, I know. Cheating on him. Oh yeah, I know that you've been taking naked pictures of yourself. Bullshit stuff. And he would just continuously say it over and over again. And he'll be back and be like, yeah, sending these fucking niggas pictures and shit.
believe the shit he was saying. You could tell he did. So he would just leave sometimes, take the truck to his dad's house, and then he would have maybe his friends pick him up from there. And then if I was at bars, it was like he was going. One of the nights and told I would come home. 1, 2 in the morning, and whenever he would get home. So that's what he would say he was saying to you? That's where he would go to school. That's where I used to go to school all the time. Okay, so Friday yesterday was the other day. He was with his friend. He was with his friend's house. Pretty good. And then I remember I drove by the fence and my sister's house and my mom. Do you remember what time that was? I don't remember 5. In the afternoon or the morning? Afternoon. My mom flew down, so she went to the cement and my sister and my mom takes care of my sister's kids. And she's very she's big, so she's a big kid. And we went over there, and just talking, shit like that. We were supposed to do a barbecue in the house there with all my sisters and stuff. Then after that, I went home. I had to go home. I went home, and then it was about maybe 10 or 11 o'clock. And then he started having. At this point, you were home alone with the kids? Who was home? I was home. Okay, and what were the kids? The kids were. So you, your mom, and the 2 kids were home? Yeah. Okay. After that, I went and I picked them up. Well, where did you pick them up from? His friend's house. Do you know the address? No. I just know it's. Well, I'm the street behind Homestead now. Sorry, I don't know the precise address. And what's his friend's name there? Manriquez. Manriquez? Manriquez. Do you know his brother? I think I'm paying him. RIQ. He, I believe. Is he white or not? He is white, he is Hispanic. Okay, and how did you know to pick him up from there? Because I knew that he was over there. Before he left, he was with it was him, I mean, the brother, and a couple of other, when I see that group of people, the group of boys there, I know he's gonna be there. But where did you see them with these people? At their house. Well, first they came to my house. Okay. And then they went to their house. Why did they come to your house? I guess maybe it was get blood. I don't know. So he was home. I don't want to say your house then. Because you told me you were home with the kids and your mom. Yeah, that was when I got back home. Okay, got home. Okay. And then after that, I told my mom, we're going to go back, we're going to go a little bit to get it up. Because I know he's coming drunk on the back, and he was just fucking falling and shit. Did he ask you to pick him up, or you decided to go pick him up? I decided to pick him up. Okay. Wasn't an issue. Okay. I picked him up. He was wearing black cocaine, and I'm not again. He took too long to go inside, so I went inside. And he said, oh, I'm coming. He's drunk up his ass. And then you can see he had like coke bags on and stuff. When you got there, how did you tell him to come outside? His friend, he normally they sit outside. I went and I was like, well, where's Pedro at? Oh, he's inside the house. Okay. He was out there. I don't know, my niggas is the only one I know his name. There's about 5 or 6 of them. I was there. The boy went inside. I waited like.
Sorry, guys.
His phone out of the way, it's like a fine. I guess his phone was literally right there where the wound was, so I couldn't get it. And his belt was too tight, it was over the phone. So I took the phone out of the pocket trying to get the belt off. And then it happened. Are you sure he had a belt? Yeah, he has a belt, yeah. Because he was holding the phone down. He had a belt on. What if I tell you he didn't have a belt? He has to have a belt on. Unless he has to. He has to have a belt on. Because someone was holding the phone, unless the pants were just that tight. He has to have a belt on. Because something was holding the phone tight as hell. Right? Do you physically remember seeing a belt? Now you're saying, oh my God, I can't remember. But even earlier today, I gave him the belt and everything, so he has to let it on. If not, so either the legs were tight, I don't know. But so you put his money and his phone, you put it in the car. Yeah, he still has his stuff in his pockets and other pockets and stuff too. At what point do you put all that in the car, before or after the cops arrived? This is when the cops come. They were there already though? The cops were there, and that's when I started screaming because the guy said he was breathing. So that way my car was on the whole time. The car was on, so the officer came and he tried to tell me to walk backwards to the house. Come, like he should calm me down. So I went, I put the stuff in the seat of the car, I turned the car off, and I got the keys and I went with the officer. But he still had other stuff in his pockets too. I don't know what the hell it was. But my only concern was really to move the phone out of the way. Why? To find out to see where I couldn't see a bullet wound anywhere. It had to have been where the phone was. What was the phone? The phone was like right here, like on his pockets. In the pockets, but it was so tight. It was tight in his pants, like I literally had to dig it out to get it out of the way. And that's where I seen where the wound was. And maybe I was looking for it to see if he had a belt on. Maybe. But it ended up being his shirt there with all the gear. I ripped the shirt off, and then that's when I tied it around his leg trying to stop the bleeding. The gun that you shot him with by the house. Are you familiar with My back porch is right here.
Okay, and this is the front.
Okay, right here should be right there. This is the front, this is the back, this is the neighbor's side. This is where the white car is. It should be like right here. On the edge of the property, on the edge of the house.
This is the street.
Yeah.
So this is the street. When we come in, there's a tree here, right? Is that the tree? Where the gun was thrown? Okay. You shot him on this side of the house then?
Yeah.
You didn't shoot him on this side of the house?
No.
Okay. And after you shoot him, what way do you walk?
Because he's running around saying he's gonna go to the front door.
So you go that way? And then after you go that way, where do you continue to walk?
After I'm right here, and I shoot him, he runs this way, so I'm walking this way. So but I see him from one side. I see that he kind of screamed and ran towards the front part of the neighbor's porch and started running through there.
Where are your cameras that you have?
My cameras are right here, facing the street.
Okay. I need to go to the bathroom, and then I'll be right back, okay? Is that okay? Do you want anything? Okay.
And they have the volume off. Nothing I can do about that.
Where did this pistol get hurt?
Man, I'm worried now.
Okay, so just to clarify this, so this is the street, this is 14th Street, right? This is the neighbor's house, and there's this in between, and this is your house, right? Okay, and you're telling me that the shooting did not occur in between here? Okay, what did I tell you that you're lying right now?
Seriously.
I'm pollution?
I know where I was.
Okay, that's nice. What did I tell you that I have somebody that told me shooting happened? No?
Detective, a moment ago, we heard Ms. Lincoln say that she had to remove some items because the defendant's pants were so tight. Permission to publish states 12. I want to show you what is in evidence as states composite 12, which is 7 of 15. You just take a look at the shorts in that photograph. What kind of shorts do those appear to be?
Basketball shorts?
And would you agree with me that basketball shorts are not so tight fitting?
Yes.
What did I tell you that I have you on camera? Okay, and I'll quote exactly what you say on camera. So you know that I'm not bullshitting. That I'm not bullshit, as you said. Okay, I'm not gonna hit an artery, you'll be fine. That was 10 minutes prior to you calling the police. And you're walking with a gun in your hand. You walk towards back to the inside your house. You walk back out with the gun still in your hand again. Then you walk by the tree.
I shot him right here.
I'm saying is, what about that comment that you made?
I don't even remember saying that. Honestly, I don't even remember even saying anything at all.
No, he didn't say anything. You said that. He didn't say anything. You're right about that.
He said I might have been an artery and I said you would be fine. I don't even remember saying it at all.
No, you said that.
You said it.
You said that.
He was looking, he's over right here by the corner. And I'm right here.
So you were standing on the opposite side of the house when you fired? And was he near anything?
There's nothing right there, like except for chairs, maybe another tree that was in front of him.
When he was by a tree?
There's another like bush. There's a right here. The tree was a bush and a tree and then it was like maybe the someone that was next to him. That would have been next to him at least. Because I know it was right here.
Okay, so he's trying to get away from you at this point then?
He's trying to run the house. To help me out.
Okay. At this point where you're standing with the gun, aiming at him, as he's running away from you,
No, I'm not aiming at him.
where are you aiming the gun at?
Because the gun was just in my hand.
Okay.
It was down. And then once he said, oh, you're gonna sleep outside tonight, bitch. That's when I literally just lifted it up and I just cocked it and I shot it. It was already cocked and everything. I shot it.
And he's running or walking away from you?
He was running into the house. He was trying to run into the house. He's not running away from me. He was running into the house to lock me out.
Okay, did you physically see no one inside the house?
No.
Okay, you're telling me this, right? You're here. He's here, right?
I'm right here in front of the house.
Okay, and he's here.
Yeah.
Where is your front stand at? Where is your front door?
The front door is right here.
Okay, from here.
Okay, guys, we're going to take a little bit of a breather. Thank you, June. I did see that as it popped up. Thank you so much. We have a trial that is popping out of San Antonio, Texas. We're going to, I'm going to, it won't let me. Okay, June. I'll have to find it on YouTube.
To here. He's running away from you.
He's running into the house.
The door is here.
Yeah, it's in the house.
Okay, so let's,
I know what the fuck this guy was doing. I know exactly what he was doing.
alright, so,
Saying he was doing something else. He wasn't. I know exactly what he was doing. He told me he was doing, where he was going, and exactly what he was gonna do. When he was gonna go outside as many times as I have, and when you see the shit that he's done to me, and the shit that I've gone through, that I know he's able to do it, I know exactly what he was gonna do. Exactly what he said he was gonna do. He was not running away from it.
Thank you so much, hon. You're so good. I think what we're going to do is probably go on over into this starting Monday. If I may do a Sunday catch up, I don't know. Please tell me their court cases.
you come this way. After you shoot him, and you walk around this way, and you come this way, what do you do when you come back this way, you come this way? Before you walk back over here to dump the gun? Did you go back inside the house?
I don't remember. I don't even remember. I could have sworn I went from what I can recall that I went this way. I thought I took the gun as soon as I did it.
You didn't.
And I walked onto the sidewalk and I started calling out and telling him too that I was taken to the hospital, but that should be on them too. So I didn't like him. The first time I went and drove around, I didn't see him again. That's when I came back, I parked the car, and I think I sat on the stairs and I could hear the window. So I got back in the car and drove back around here.
How long did that take you to get back in the movement? You said it's hard.
Literally, right, it was not even a minute, 2 minutes behind each other. When I got back in the car, I moved on to the window, right down.
So just go back. So you fired, right? And you get in the car, you search, you stop, you get back in the second time.
Yeah.
How long do you think that was?
Between the two say 5 or 6 times. Maybe 5 or 6 times. It wasn't all after at all.
After you fired, did you notice that he was bleeding?
No. I heard him it wasn't even a scream, it was like, ah! It wasn't a scream like how you normally hear a scream, no. So I thought he was fucking around at first. But I wasn't sure if I hit him or not. But when I saw him laying there, no blood everywhere, I thought maybe his arm, somewhere, maybe at the bottom of his leg or something.
Do you know where you were shot? Did you ever see where you were shot?
Yeah, when I did the tourniquet.
Where? What's your shot?
On the right, on the side, his upper side.
Where you got, like, point on your leg where you got shot?
I really hear it. Am I wrong?
It was lower. That's what I was a little confused when you said about the phone thing, because it wasn't my word, it was phone word.
His side of his hand. He was laying on the floor. Well, but maybe his hands were turned sideways. I don't know what to tell you. Because the phone was over, it was definitely over, it was overflow. And, I don't know, it was so little bit. If I'm not mistaken, it was right here. I think it was there. I thought it would have been somewhere else, maybe to the grave, with some flesh or something. When I saw him laying there, I didn't think at all that that's what it was.
At any point did you try to put the gun inside your house?
I don't think so. No.
So, at what point did you know that you did it? That you actually shot him? At what point?
I saw him there.
When you saw him? So, if you're telling me that you knew you hit him when he was on the floor, then why did you say what you said on camera about hitting his artery? And it looked fine.
Talking shit, I don't think that he actually did it.
So you were just talking shit when you said that?
Yeah, I didn't really think I hit him at all.
So you remember saying that?
No, I don't. But I'm saying if I did, I was talking shit. I was mad as fuck. Okay, you already fucking turned with the shit out of me to back to the house again. Locked me out of my fucking house. My kids are asleep. I'm tired of this shit. I was mad as fuck. I'm not saying I did say I probably did. But it wasn't literally intentional. I really didn't think I hit him at all. I really fucking didn't think I hit him at all. Until I saw him laying there. I don't know if anything really was fucked up. I did. Those little like he was.
We're going to step out and be right back. If he is, come on in and hold it.
Detective, was anybody ever arrested for the murder of Pedro Jimenez?
Yes.
Who?
Daisy Link.
Do you see Daisy Link in the courtroom today?
Yes.
Can you please identify her by what she is wearing in the courtroom?
Yes, she's wearing.
If she is in the courtroom.
She is. I can't.
And if you can stand up.
Floral top.
Can you please be a little more descriptive?
Black long hair, floral top, tattoo on her right eyebrow.
Your Honor, let the record reflect that the witness has identified the defendant. I have no further questions.
Anybody needs a break from them out, otherwise it's cross-examination. Nobody needs a break from it.
Just so I don't need to. No.
This video, I'm sorry I've been quiet, but I can't. It's almost like I'm starting to get a migraine from this video. Just saying. And of course, they're mowing next door.
So, Detective, a little while ago, before we played the interview, if you recall, the state played a couple of videos for you with a similar angle. Do you recall that?
Yes, sir.
Does this appear to be a video from the same camera that you saw those two videos a little while ago?
Yes, sir.
And you remember the individuals you saw in that video?
Yes, sir.
Go ahead, Larry. See that man running from the left side of the screen to the right side of the screen?
Yes, sir.
Does that appear to be the same man that you saw in the videos that were played? Does that appear to be the same man that was in the videos that you saw earlier?
Yes, sir.
That woman on the right side who just opened that car door, does that appear to be the same woman that you saw in the videos we saw earlier?
Yes, sir.
Before she came on screen, did it seem to you like she was yelling something at the man who just ran across the screen?
Yes.
So, hold on.
How are y'all doing? It's been interesting. I will say that. Been interesting, y'all. Okay, we're going to come here for a minute. Figure out what's going on over here.
Stab murder trial of Bianca Ellis. The trial is nearing its end after the defense called its last witness another forensic psychiatrist. The defense argues that Ellis is not guilty of murdering a 3-year-old boy by reason of insanity, saying she was schizophrenic and had been off her meds at the time of the stabbing and couldn't really appreciate the nature of her actions. However, the prosecution claims that Ellis knew what she was doing when she followed Margot Wood and her son, Julian Wood, out of a grocery store and stabbed them, both killing Julian. Well, today the defense called another forensic psychiatrist who testified.
In her investigation as it relates to evidence she obtained, and it might is in the video and what is said in the video is up to the jury. So in other words, opinions of witnesses as they testify about what is, what isn't, what is said, what isn't said in the video, that is going to be related to this witness, to the sufficiency of her investigation. But ultimately, you all will decide your opinions as to what the evidence has shown and what the evidence has not shown. So with that limitation, we're going to continue with this detective's testimony, but please view her testimony from this limitation instruction. If someone doesn't understand it, let me know. Yeah.
So we have to read a transcript.
There isn't one available. I know it's long. What was your last name again?
It's more about being clear about what was being said so we can be objective.
Understood. So I can tell you it's in evidence, and I know it's long, but you all can take as long as you want to review it, to amplify it, to put it closer to you, things of that nature. So it is available to you at the time that you do it. Okay? I wish I had a transcript. There isn't anything written. But even at the end of the day, let's say the transcript, you all think there's an error in the transcript. The evidence is what's in the video, not necessarily the transcript. Does that make sense?
Okay. Yes. Like, isn't there like some kind of app that would make transcript like
So,
something?
So right now, there isn't one available. Okay? All right. Thank you.
Stop it there. So apparently, based on your observation of that, there was some type of interaction, voices were raised, things of that nature, correct?
Yes, sir.
Now, would you agree that this video that we just observed had to have happened prior to the video where you hear a shot, correct?
Considering the victim was in it, yes.
And would you agree that the car that's there on the right side of the screen was in a different position at the time that the shooting occurred, correct?
Yes.
It was facing the opposite way, correct? Car?
I don't recall.
This is moments before the gunshot, correct?
Yes.
Now that we're looking at this video, would you agree that the car is facing the opposite direction?
Yes.
Based on the video I showed you before, had you seen that video before during the course of your investigation?
No.
So the video I just showed you where the car is facing the opposite direction, where Mr. Jimenez is running around, you've never seen that video before?
What I can recall, off the top of my head, I remember all the videos. I reviewed multiple videos during the course of the investigation.
Okay. During the course of the investigation, did you Did it ever occur to you, or did you see anything that would corroborate Ms. Link's notion that Pedro Jimenez was running back and forth outside the house and would not leave after being told to leave?
Okay, sorry. So say the question again, one more time. It was very long.
During the course of your investigation,
Okay.
did you see anything that would corroborate the notion that Pedro Jimenez was running around, loitering, stalking outside the house, refusing to leave, and he did that for and he did so for a lengthy period of time before the ultimate confrontation where a shot was fired?
Oh, yes, that particular video, he's running away from the residence.
Okay. So he's running around. Obviously, at some point he came back.
Yes.
And right before the shooting, you heard him screaming there, right?
Yes.
Now, we know that when rescue arrived, there was a tourniquet on Mr. Jimenez's leg, correct?
Yes.
And Daisy Link put that tourniquet on his leg, correct?
Yes.
She's also the person who called 911, correct?
Yes.
Now, we just heard her say that she didn't know that he had been shot when we were listening to her statement a few moments ago, correct?
Yes.
Okay. So she didn't know that he had been shot at the moment he was shot, and she ultimately discovered him and called 911 roughly, what, 10 minutes later?
Yes.
So if she didn't know that he had been shot, is it consistent with her finding him about 10 minutes later? Is that consistent?
Yes.
Okay. So in other words, there's nothing to indicate that she purposely waited 10 minutes. I mean,
Answering based on your investigation.
there's nothing to indicate that she purposely waited to call 911, correct?
Correct.
As far as we know, she called 911 as soon as she realized what was happening, that he was shot, right?
Yes.
And she took measures to try and help him by putting a tourniquet on his leg, correct?
Yes.
Now, you testified earlier that when she was transported to your headquarters, she was not a suspect, but she was an important witness. Did I get that correct?
Yes.
Who transported her?
A patrol officer.
Did you know which one?
I do not.
When somebody is not a suspect, what is the procedure as far as transporting them to headquarters? Are you supposed to put them in handcuffs? Are you supposed to, what's the procedure?
If they're being transported in a patrol vehicle, it's a marked patrol vehicle, yes. Procedure is they need to be handcuffed.
Why is it? If they're not a suspect, why is that?
Safety reasons for officers. Anyone riding in the rear seat of a police vehicle needs to be handcuffed, whether you're under arrest or not.
So it's a safety measure specifically outlined for transport, is that correct?
Inside a patrol vehicle, yes.
Okay. So what is the actual procedure? Are you supposed to put the handcuffs on right before they get in the car, or how does it work?
Prior to putting them inside the vehicle, yes, you handcuff them and then you place them inside the vehicle.
But there's no procedure that mandates that they need to be handcuffed for any period of time prior to the transport or after the transport, correct?
Not to my knowledge.
So am I correct that it would be proper procedure to only, because she was not a suspect at the time, to only place her in cuffs for the transportation, and that's it? The cuffs can be removed once the transportation has been completed,
Yes.
correct? Okay. So, as far as you know, was she not in cuffs prior to the car ride and after the car ride?
By the time I arrived on the scene, she was already inside a patrol vehicle. I don't know what happened prior to that.
Okay. If she had been held in handcuffs prior to being in the patrol vehicle for an extended amount of time, would that have been incorrect procedure, as far as you know?
I don't know what occurred prior to me arriving. When I arrived, she was already inside a patrol vehicle.
I understand that you weren't there, so I'm not
Okay.
asking you to speculate on what happened. What I'm asking you is, given that you're familiar with the procedure, would it have been incorrect procedure to place her in cuffs and hold her for an extended period of time when she wasn't being transported?
Depends on the circumstances.
Okay, so procedurally, what would be a circumstance where you would handcuff somebody who is not a suspect, who's not being transported?
If somebody is combative and is posing some kind of threat to themselves or others, or acting in a threatening manner, then yes, so they will be placed in handcuffs.
As far as you know, did Miss Link pose any type of threat to any law enforcement officers who were there before she was transported?
When I arrived on scene, she was inside a patrol vehicle.
Okay, so you don't have any information. You're not aware of anything that she did which would have justified her being placed in handcuffs for an extended period of time prior to the transport, correct?
Correct.
Before you conducted the interview, what other members of law enforcement had interaction with Miss Link, if you can recall?
Aside from myself and Joseph Cruz, I do not know.
Was there ever a domestic violence detective, female detective, who?
What's the question?
The question was there a female domestic violence detective who interacted with Miss Link while she was fingerprinted and before she gave her statement?
Oh, good answer. A female domestic violence detective? No.
There wasn't.
No.
Just when you're asking, no, sorry.
I don't know about y'all, but I am done. I am so done with this case on that scratchy crap. I'm sorry. I'm not trying to be witchy, but y'all, it's getting to be too much. So it looks like Court TV ended their stream. So when this ends, we'll be ending. My daughter has a wedding to attend, and Mama gets to go with her to help her shop for a dress. I don't get to do that often with my daughter, so that'll be nice.
There was another female homicide detective that assisted me taking her to the bathroom whenever she needed to go to the bathroom.
Just for the bathroom? What about during fingerprints?
And she came down with me to fingerprinting as
A
well.
female homicide detective?
Yes.
What is her name?
Detective Angel Wilson.
Angel Wilson? And were you present for all the interactions?
Same objection, Judge.
Were you present for all the interactions that occurred between Detective Wilson and Daisy Link?
Yes.
You were?
Yes.
Now, based on the investigation that you conducted here, isn't it true that when Mr. Jimenez first arrived at Daisy Link's home earlier in the evening before the morning of the shooting, there were other family members of Daisy Link's at the home as well?
Yes.
Her mother was there, right?
Yes.
And were other people there too?
Her children?
And her children. Are you aware of anybody else who was there?
No.
At some point, the mother left.
Yes.
And when the shooting happened, nobody else was there other than the children, correct?
Correct.
And the children were inside the house sleeping
Yes.
when all this was happening.
Yes.
Now, you were asked at some point, and I know this was a while ago, but you were asked at some point about whether or not you're allowed to use your personal cell phone to record something that you deem is of evidentiary value. Do you remember that question?
Yes.
And do you remember what your answer was?
Yes, that I am not.
You're not permitted to do that?
Correct.
Do procedures account for a situation when a detective such as yourself deems it necessary or important to record something? I mean, what are you supposed to do when you're in that situation?
We are not allowed to use our personal cell phones for that.
Okay, so what are you supposed to do? Are you issued another phone?
Some individuals are.
Who's issued a department phone?
There are certain detectives that are issued. It depends how many phones they have available, if they have even phones available.
Are those smartphones?
Yes.
And typically are those phones used to make recordings, take
They're not killing each other.
Take pictures for evidentiary purposes, things of that nature?
Yes.
So you, for whatever, do you know why it was that you weren't issued one of these phones?
I don't even know where they are.
Don't have one though.
Okay. How many other detectives were working on this case? I know it was Detective Morales was one, right?
Yes.
Detective, who's the other one?
Detective
Some of them are.
Hubbard.
I'll give you.
And Detective Joseph Cruz.
Okay, so 3 other detectives.
Sarah.
Were any of them issued phones?
To my knowledge, no.
Hey,
To your
guys.
knowledge, no? Okay. Is there a procedure lined out for what you're supposed to do when there's evidence that should be collected, which you could collect with a personal phone, but since you don't have one, what are you supposed to do in that situation?
There's nothing written in stone for that one.
What?
No procedure.
Well, what would happen if you just took your phone out, collected this important evidence, and then sent it to evidence? What would happen?
This is for indirect examination. You can answer.
What would happen?
If I were to take my personal phone and
And
record
collected
the same
evidence, and then you turned it over to evidence.
Depends on the circumstance. Sometimes they want to subpoena our phones, our personal phones. So that's the biggest reason why we don't use our personal phones is so our personal information does not get subpoenaed along with evidence.
Okay. So it does happen. It has happened.
It has happened to certain individuals, yes.
So is it fair to say that if a need arises, you could use a phone to collect evidence if there's no other way to do it, correct?
Yes.
How long was Daisy Link in that room for, the room that she was given that interview?
Approximately 11 hours, I believe it was.
11 hours. The shooting happened at 3-something in the morning, right?
Yes.
How long after the shooting was it that she arrived to the room?
Well, I didn't arrive till approximately 4:20-ish. So by the time we got to the office, I would say approximately 7:30 in the morning. So I would have to refer to my report to give you the exact time that she arrived at that office.
So around what time does the 11-hour stretch start?
From the moment we turn on the video room and place her in the room.
So like at 4-something?
Understand, love, this has not been a good day.
4 in the morning.
It's
She was in the room at 4.
For me, it's been grueling.
When was she in the room?
It was, like I said, can I refer to my report to give you the exact time that I put her in there?
Fine with me.
At 9:20 a.m., she was placed in the interview room.
So the 11-hour stretch starts at that point?
Yes.
All right. So the night before this man arrives, at 3 o'clock in the morning.
Sit down. If you want to object, you can stand up, or you have permission to report to object while seated. I will give as much flexibility as you want to be comfortable. Thank you.
So I understand. This man arrives at her home the night before. At 3 o'clock in the morning, this shooting happens.
Objection, counsel testify.
Oh, that is what cross-examination is. Thank you. Please have seats. Please have seats. Thank you.
Shooting happens at 3 something in the morning. She's taken to police headquarters. She's handcuffed. She's placed in the room. And then beginning at what time was it again?
9:20 a.m.
9:20 a.m., some 6 something hours after the
No question pending.
Right, because I haven't heard of the end of it.
Because counsel testify.
He's re-asking. I'm sorry, over here, folks. I'm in the middle of court. Thank you.
So some 6 hours after the shooting, Ms. Link begins an 11-hour stretch of questioning. Is that correct?
It wasn't 11 hours of questioning. She was in the room for 11 hours.
She was in the room for 11 hours.
Yes.
So what time did she finish? What time was it over?
Can I refer to my pretty late note when
Please.
she was transported?
Please.
So approximately 6:20 p.m.
So she wasn't done until roughly, well, I'm not going to ask you how long she went without sleeping, but pretty much almost an entire day, this whole thing was going on, correct?
Yes.
Now, the gun that was eventually found, it was found after she told you what she did with it, correct?
Yes.
It hadn't been found prior to her giving you that information, correct?
No.
Just a moment here. You were asked about whether a casing was found. You remember that?
Yes.
And it's my understanding you said a casing was not found?
To my knowledge, there was no casing found.
Well, the gun hadn't been found, but then she gave you information, and then with that information, you were able to find the gun, correct?
Yes.
You asked her about the casing, she said she didn't know where it was, correct?
Yes.
To your knowledge, police arrived on scene, Ms. Link was rendering aid to Mr. Jimenez, correct?
Yes.
And from that point on, until the point when she was done sitting in that room for 11 hours, later that night, police officers had eyes on her, correct?
Yes.
So, are you aware of any other police officer who during all those hours saw her do anything with any shell casing or anything of that nature?
No.
Is there any evidence, any indication, anything that you can point to that would support the notion that she disposed of, hid, or did anything with any shell casing?
No.
All right, thank you. That's all I have.
Detective, I want to talk about posing threats for a moment. Would throwing a chair at a detective investigating a homicide scene be a threat to that officer?
Yes.
No. He's gonna ask another question.
Sure.
Also, legal conclusion, ask another question.
Judge, can we go sidebar?
No, you can ask another question. Thank you.
Do you know if the defendant threw a chair at Detective Daniel Morales?
No.
If there is evidence to collect on scene, are there certain officers, for example, CSI officer, if a casing is on scene or firearm is on scene, that is the person who would be responsible for actually collecting evidence?
Yes.
And so if there is evidence on scene, you yourself are not going to collect it, a specific officer will collect it, is that correct?
Yes.
So for example, if there is specific video that needs to be collected, are you going to call a specific officer?
Yes.
Are you aware during the period of time that the defendant was in custody if she was allowed to sleep?
Yes.
Did she sleep?
Yes.
Again, did you offer her any kind of accommodations?
Yes, food and water.
Does it look okay? Yeah, it's cute. Perfect.
The defendant told you that she didn't know where the casing was, right?
Yes.
Are you aware if the defendant was being completely honest with officers?
Objection, I made the promise to the jury.
Are you aware if the defendant had lied to officers?
Objection, same objection.
Did the defendant lie to you?
Objection, same objection.
And your kitty love. Okay, guys. Yes, my daughter just landed, and of course she's got to get to the kitties. Gotta love on the kitties. They number one priority. While they're doing that, guys, I have an announcement to make. On Saturday night, Lord willing, the creek don't rise and my life doesn't turn 20 different ways from Sunday, we're going to start a new trial. The trial, excuse me, is that we have 3 San Antonio, Texas Police Department officers who are on trial for murder. On June 23 of 2023, what you looking for? Now look underneath the chair as you go towards the kitchen. In June 23 of 2023, San Antonio PD SAPD officers responded to a report that Melissa Perez, age 46, was with schizophrenia, was cutting wires to a fire alarm system in her apartment complex. She reportedly believed the FBI was surveilling her. The officers allegedly communicated with her. She retreated into her apartment and locked the door. Through a window, she threw glass chandelier at the officers, and at some point she raised a hammer and struck the front window. Officer says she later advanced towards them with the hammer while behind a locked glass door. All 3 officers fired. Only 2 of them, Eleazar Alejandro and Alfred Flores, were accused of actually striking Perez. She was hit and died on the scene. Eleazar Alejandro and Alfred Flores are charged with redrum. Nathaniel Villalobos is charged with aggravated assault with deadly weapon by plugged servant. His redrum charge was reduced. All 3 former officers each have been fired. The key legal issues in the trial. This is the first time in SAPSA history, San Antonio history, that an on-duty police officer have been charged with the redrum for a shooting. One big issue dispute, whether Perez is posed as an imminent threat when she was shot. That'll be interesting. What do you think? Prosecution said the officers did not have lawful reason to force entry or use deadly force given the facts. Defense says the officers reasonably believed that there was a threat. Another issue is whether police followed protocol, especially with respect to the mental health crisis response. Perez was having a mental health episode. Critics raised questions about whether SAPD engaged properly with its mental health unit used to de-escalate. The defense also has charged whether the DA's office withheld evidence, including using audit trails related to who reviewed footage and when, and whether the warrant affidavit was biased or accurate. The trial begins with jury selections in October. Opening statements were made today, and first witnesses, we will catch up on that on Saturday evening or Sunday evening, whichever labels. The Perez family filed a wrongful death civil suit against the city and the officers, alleging excess force, failure in the politic training, and the mental health crisis response. The civil suit was dismissed by federal judge who found the officers acted under the belief that Perez posed that's interesting, immediate threat, affording them to qualify immunity under the law. This is a trial that we will be starting coming up. And I'm going to say farewell to day 3. It's 4:30. That's 5:30 their times. It looks like their trial is ending. we are going to say farewell for now. It has been a week. I appreciate it so very much for you guys of hopping on and joining us all week long for this. We will come back and follow these starting Monday. We will follow the closing arguments in the Ellis trial. We will continue the trial with this, and we will start the trial from the San Antonio police officers who were on trial and for the murder of, what was her name? Melissa Perez. So y'all have a fabulous weekend. Mods, we do have a mod meeting this weekend on Sunday. I will get hold of you all concerning that. And I just want to say movie. Oh, I don't know. June will post it in Discord. June will post the movie in Discord. I don't know if we're going to have a movie, but I'm assuming since you asked, we will. Miss June, I will let you post all that information in Discord. I am going to go spend time with my daughter who drove in from college today. And we are going to go dress shopping. Going to be fun. All right, guys. Y'all have a fabulous evening. Thanks again for being here. Y'all are amazing, and I couldn't do it without you. Good night. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day